too late. Sorry about that.
It's okay. We're on the record, case number 12 CF 1083A, State versus George Zimmerman.
Where we left it last night was the issue of the animation. We had a deposition last night that I think focused the inquiry a bit. I know that the state still has some concerns that they need to address. I don't think it's as much like we talked about yesterday as an admissibility problem itself as to the underlying science, but a question of the applicability to the facts.
Actually, based upon the testimony, I have supplemented the original motion again this morning, and I now do believe that there is both concerns, both the Daubert sort of admissibility issue, as well as the earlier concerns, most of them that I had originally outlined. The reason is this. The gist, and I do have a copy for the court of the deposition from last night. I got an electronic copy mailed to me. This is part 3 of the witness's deposition. And essentially what we have now done from the state's perspective is we have moved from the witness initially creating the exhibit that he said represented essentially the physical evidence as well as things he gathered from police reports and witness statements. Now, what changed since the last portion of the deposition, which is what resulted in the production of the animation I received yesterday, is that we have now taken the animation and attempted to fit it to the theory of an expert who has yet to actually testify about it. So we have now gone from, and that's the reason that the state now believes that there is now a Daubert issue, because we have now moved from simple representation as to physical items to now attempting to create essentially a animated, I don't know if you want to call it a cartoon, but an animated depiction of the theory that that Dr. DeMaio discussed with this witness on the phone on Saturday after Mr. Shoemaker had been deposed twice, but right before Dr. DeMaio's deposition. At least that's according to the timing that Mr. Shoemaker told us last night. So because of that, because of what came out in that deposition that I'm glad the court authorized last night, I do now think that we need to expand this hearing to include Daubert materials, and I do have some cases that point that out why, but whether we call it a Daubert or Fry hearing, a combination Daubert-Fry-Pierce hearing, I think that all those issues now need to get fleshed out based upon the reasons for this change and what they represent. And I filed a supplemental motion this morning accordingly. I would also point out, during last night's deposition, the witness indicated that he had prepared additional still depictions and also showed me or displayed a computer diagram, indicated I was going to be getting copies of that. I got the court reporter's promised transcript, but I have gotten nothing yet from the witness. So I still don't have those physical things to hand to the court to show you, but that is the reason for the supplemental motion, and I apologize for now telling the court that we do want what I hoped wasn't necessary yesterday, but given what was said last night, I believe it is.
Okay, defense response.
A factual response first, I guess, is probably appropriate, and that is that the concern evidenced by the state through various paragraphs in the supplemental motion basically address the one fact issue that is in fact undisputed, and that is that Dr. Shipping-Bow and our expert as to the medical examiner, the pathologist, is that the gun shot entered Mr. Martin at approximately a 90-degree angle from the plane of the chest and somewhere close to a straight through shot. There is a little bit of angling as it enters the body off dead center line, but there's no dispute as to that underlying fact. It is that underlying fact that led to what I believe to be, if I understand the motion, the state's concern, and that is that Mr. Shoemaker, who had attended to the making of the animations for the last several weeks, all of which up to the last couple of days the state has been well aware of, deposed, and given copies of, in consultation with Dr. DeMaio, added to that fact the potential of the distance from the gun to the body. Testified in part by Dr. Bow in that he said the only distance he would give is somewhere between 0.4 inches and 4 feet. The anticipated testimony of Dr. DeMaio, as was referenced in his sworn testimony, is that it's somewhere between 2 and 4 inches. So we had prepared an exhibit to document that. Because of the lateness of concern and the state's concern over that, I'm very fine with not using that still. It's not part of the animation, but that still. I think I can probably use it in closing as a demonstrative tool. I don't think that's necessary for the court's consideration as far as evidence. So that's withdrawn. And I mentioned that to the state a moment ago. It's why I stood up at the bench when he was talking, just to make sure that that was clear, because it was just discussed last night. That leaves the underlying fact that the state seems to suggest is a concern, and that is the positioning of the bodies when the shot was fired. We know the relative positioning of the gun and the body at 90 degrees. So then what's not known, and what is depicted in the animation as the probable positioning of the bodies based upon John Good's testimony, is what I guess is an issue. And that is that if you keep the body and the gun together, maybe 2 or 4 inches, but for purposes of me talking to you, let's just put it up against, that certainly if Mr. Martin was like this, or even maybe the state could argue like this, although John Good has it about like this because he has him mounted over him and leaning over him, that is what we had used, John Good's specific testimony and the only eyewitness testimony as to the relative positions when he saw it. Now, I'll tell you, the state's going to say, well, he didn't see the gunshot. He left a few seconds before, so there could have been movement. And I think that goes to something the state can argue to the jury. They can even have decided to come up with their own animation with something different, or their own expert to suggest something different. They haven't, but they could have. So I think that it's reasonable for us, based upon the evidence, particularly John Good's testimony, and Shipping-Bow's testimony and the anticipated testimony of Dr. DeMaio, that we have an animation that has the bodies in that position. They can certainly suggest what they want to, but I don't believe, and I've never seen, that evidence admissibility is dependent upon it not having some argument to the jury that it may have happened differently. Every witness who came in and gave testimony, whether it be Mr. Shoemaker, Dr. DeMaio, Dr. Bow, or anybody else, is up for impeachment before the jury. So I don't understand now why that makes it a Fry or Daubert admissibility concern when we know that animations are very admissible and often used more in civil cases, but also in criminal cases. Pierce was a criminal case. And as long as it does, based upon facts adduced at trial, which this is, and can assist the trier of fact, which I think it can, and not to mention the fact that it is specifically in line with the facts of the evidence and supports our theory of the defense as to how things happened, and there's nothing to contest it. I don't believe if we were to go through a Daubert, Pierce, Fry standard, it would meet admissibility, so maybe we need to do that now. But the underlying facts are supported by the evidence, so I'm not certain. While I see the state is saying they talked, but they didn't talk and come up with anything different than John Good testified to. So I'm not certain what their true objection is to the admissibility of it, because what they're saying is now it's just based upon what we talked about. Well, no, it's based upon the 90-degree angle, and that's the one underlying undisputed fact that is the premise for the positioning of the parties. Now, as to the entirety of the animation, since I guess we're talking about all of it, what you'll see, and you really need to take a look at it, so we'll present it to you in a moment, what you'll see is it is more than an animation, it's more like a series of stills, because in response to states' concerns in the past, we took out animation and replaced it with a still. For example, there was movement of the arms in one shot, and there was 8, or there were 10, or there were 4, or there were 30.
Sorry
That's
to
okay.
interrupt you, but if we were just to start with the hearing, and then you can give
Sure.
the argument after the hearing. So the defense has the burden. So call your first witness.
Call Daniel Shoemaker. We'll take a moment to get his hardware set up so we can show it to you.
Okay, thank you.
Raise your hand, sir. Do you solemnly swear from the testimony presented will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
May I begin by questioning you just on the lectern?
Yes, you may.
State your name, sir,
Daniel Shoemaker,
and your business address.
1630 North Main Street, Walnut Creek, California, 94596.
And the name of your company.
Contrast Forensics.
And what type of business is that?
Crime scene accident reconstruction. I take a lot of different information. I take coroner's reports, accident, crime scene reports, photographs from the scene. I take my own measurements and my own photos, total station data, which is a survey of the scene. I take all that information and put it into context in the reconstruction of a crime scene.
Okay, well, let's back up a little bit and talk about how you got into this business to start.
Initially, it started from doing information graphics for Fortune 500 companies.
And tell me the time when that began.
It was 26 years ago.
Okay, and who'd you work for and what'd you do?
I worked for Viewcom Systems in Independence, Ohio, and it was we did corporate presentations and information graphics for all the tire companies in Akron. They also had an office up in Troy, Michigan, and we did all the information graphics for the car companies up there.
I'm presuming this is in the days even before PowerPoint, right?
It was days before desktop computers, a lot,
Okay.
mostly.
So back then we're talking about a lot of art graphic work and just poster presentation, is that correct?
We had a sophisticated computer. It was called Imaginator, and it did slides.
And how long were you with that company?
I was with the company for about 5 years.
And what was your position with the company?
Senior artist.
So in effect then you would take on a project, create the graphics and the presentation tools in order to present that to an audience?
Yes, and work with the client on any modifications and all the information that went into it.
Did you have any formal education in this area before you began working for that company?
I have a Bachelor in Fine Arts.
You would just tell the court what the focus of that was and how that assisted you in beginning your career in this type of work.
That ran the gamut for advertising and marketing and corporate identity, covered all those bases.
And you focused your career then on sort of, at that point, the graphic presentation of ideas to audiences?
Yes, the best way to communicate to an audience various ideas and procedures.
And that was done for approximately 5 years?
Yes.
And then where'd you go from there?
I went from there to California. I did basically the same thing in California for a lot of the companies in the Bay Area. And
Is that sort of on a contract basis, or were you working for a particular company?
worked for a company. I was senior artist there.
And worked for a particular company?
Worked for a company. I was senior artist there.
And what company was that?
Dolphin Multimedia.
Similar job description, that you would sort of take on a project and figure out how to best present it?
Similar job as in Ohio. But being in the Bay Area, you had a lot more access to more up-to-date software, more up-to-date technology in that area.
Being close to Simi Valley helps, I guess?
Yes.
Okay. And tell the court, was there any difference in what you'd done for the first 5 years to what you had done now when you're in California doing this type of work?
The main difference between then and now is doing a lot of information graphics for proposals, large government proposals. So I do two types of work. I do information graphics for government proposals, and then also I do the information graphics and crime scene reconstruction for attorneys.
And going forward then, from how long were you doing this type of work in California? Is that what you're still doing today?
That's what I'm still doing today.
So how long have you been doing this type of work in California?
It's been the last about 13 years.
And have you been doing that under Contrast Forensics, or has the name of your company or consulting group changed at all?
It's gone from contrast design to contrast forensics.
What is your role with the company?
Owner, sole proprietor.
You're it?
I'm it.
Okay. And over the past 13 years, have you explained to the court the type of work that you focused on, particularly in the area of, as you said, the courtroom work or the forensic side of it?
It initially started out by working with attorneys on designing their information on how best to communicate to the jury. Corporate presentations were at a certain level, and courtroom presentations were a bit below that. So I worked with attorneys on that. It's gone from information graphics for attorneys like that to drawing crime scenes, and the sophistication of the work in the crime scene has progressed quite a lot, to the point with the equipment that I have that I'm using now.
Okay. So if you would bring us along a little bit as to the progression, how it happened, what type of software or hardware was available to you 13 years ago when you started, and then sort of if you could progress us up through what you utilize today.
Back then it was mostly just drawing out a scene. You go out and measure the crime scene, and then you draw it out on the computer to scale and accurate. And it was mostly 2D. From then it's gone more into 3D, to the point where 3D reconstruction and also the software has gotten a lot more sophisticated with accident and crime scene reconstruction software.
Back 13 years ago, then, did it sort of start with you going out to a scene with a tape roller, where you would go from one point to the other and get a measurement, or how
Yes.
was it back then?
It was just hand measuring like that with a metal tape ruler.
And without going through everything in between, what type of software and hardware is available to you and do you use in your business today?
The software that I use, I have two kinds for using my total station data. I use software called ARIS 360. That's on the cutting edge of taking total station. ARIS 360.
Can you spell that?
ARAS,
Thank you.
and it's just the number 360.
Um,
That's what.
I want to make sure that we sort of start with a foundation point. So even when you say something like total station, which may be something that you're very used to in your environment, if you would bring us back a little bit, not to grade school, but just to an idea of when you walk onto a scene or when you come on to a project, what information do you look for to see if it's existing? And if not, what information do you then try to create in order to assist you? Do you understand what I'm saying?
Yes.
Okay.
It's progressed from using a tape measure to now I use a robotic laser. It's a robotic surveying laser. You set it up on a tripod and you measure the crime scene, and it'll create a series of points in 3D space.
That's the total station used now by a lot of law enforcement, is that correct?
Law enforcement and construction, road crews use that type of.
In effect, what that does is if I had set up that laser-mounted camera right here, it would bounce hundreds or thousands of points off every area in this courtroom, and then it would have a data configuration of the entire outlying area of the courtroom?
There's two types. That one does point cloud that you're talking about. The type that I have is just point by point. I normally lay out, depending on the size of the scene, 200 to 500 points in a scene. So the laser, I walk around with a pocket computer and a prism, and everywhere I go and hit the computer, it'll give me a point where I am. So the laser follows me around. So it only takes one person to operate. So it'll create kind of a point cloud of the whole scene. So if I did the courtroom here, I put it in the computer in ARIS 360, and it'll give me a 3D view of those points so that I can move around the scene anywhere I want.
How does that compare to total station software?
It's the same. How does what compare to?
Is there any difference between that and total station, or are we talking about a different name for the same software?
Total station gathers data, and then you export that data to ARIS 360.
So the total station, when we talk about that, that's just actually getting the information, for example, from this courtroom.
Yes.
That would be gathering the information, and then the way you use it is in another software like ARIS 360.
It's a data collector, yes.
And so again, once you get that information, you would go through just generally what you do when you come upon a project to either see if that information is there and utilize it, or to gather your own.
Yes, I look at the data and examine it, make sure it's correct. There's another piece of software besides ARIS 360 that I have. It's called Visual Statement. And between those two, majority of ARIS 360 and the majority of the other software are CHP and law enforcement. So,
CHP being?
Oh, California Highway Patrol.
Yeah, we're in FHP, so, okay. And so within the context of the ARIS 360 and gathering, if you will, the environment digitally, how do you then make that relevant to a presentation? How do you put people, things, events, pieces of evidence in context to what you've now gathered?
It creates the scene to scale, and then what you do with that is you combine it with other pieces of equipment. Like I have I've got a motion capture suit for gathering. It's the most accurate way of gathering a person's movements. It's wireless, it has accelerometers, and you put on the suit, and in real time you can capture a person's movements. So then I capture a person's movements accurately, and then I can bring those into the scene, and so you have the accurate movements of the person, you have the accuracy of the scene, and you can do a very...
If you would give the court a couple of examples when you talk about the motion capture suits, is that what they're called?
Yes.
Okay. If you would, give the court some examples of how you've utilized that technology in other cases.
You can use it a couple different ways. I use it for, well, about a month ago, there was I had to go down to the impound lot in San Jose, and there was a shooting that occurred in a vehicle. The advantage of my suit over other suits is I can take it out to a crime scene. I can get into a vehicle, and it still sees all of the movements. A typical motion capture suit that a lot of people see on TV has little balls all around it. And then there's high-speed cameras that will capture your movements. The problem with that is you can't take it anywhere outside of those cameras. And if you get into a vehicle or behind a wall, those parts of the person disappear because it can't see the balls anymore. So that's why I bought my suit, is I can take it, it has accelerometers that measure your movements. There's 16 of them. So,
explain to the court just a little bit more the technology of what that is when you talk about an accelerometer and how that's better than just the visual balls that are seen on a suit.
it's perfect for court because then you can, it gives you a running log of all the movements. Say, for example, somebody hit something and caused a certain amount of damage. With this suit, I could do that same action, and from the accelerometers, you could see how much force it took to cause that amount of damage. So,
to the extent that you can, then advise the court what software exists behind those suits or that interprets the movements of the suits that make that information relevant to your presentation.
it's just software that came with the suit. I don't know the physics behind it, but the engineers that have developed it, they not only use it for motion capture like this, but they also, it's used in biometrics for physical rehabilitation and physical therapy, and it monitors the person's movement from day to day, so then they can see if there's any improvement.
So in effect, I could put on one of those suits if I had a range of motion problem, put on the suit, do some physical therapy, get to here, do more physical therapy, get higher, and the suits actually can measure progress?
Yes, you can see a printout of all the movements of the suit.
And does the software that interprets the movement of the suits also then have criteria that can be put into the software to identify things, as you mentioned, like force or speed of movement and the effect that objects have moving through space?
Yes, if you want to accomplish that in your reconstruction.
So if you can then go back to the example of the car and sort of walk the court through how this suit gives data which is then useful for recreation.
With the truck, I put on the suit. It was still considered a crime scene, so they didn't want it disrupted. So you're able to put on a TVAC suit, which is a protective suit, so you don't contaminate the scene. So I put on the TVAC suit, got into the truck, and what happened in that case was somebody opened the door, tried to pull the person out, and in response to him being the attempt of pulling him out, he reached for a gun and shot him.
Shot
So,
the person trying to come into the car?
yes.
Okay.
So it was a very good use of the suit. Putting it on, I had a an attorney opened the door, tried to pull me out, and I was able to record it all in real time.
Let's talk about let's continue with that and advise the court, if you would, then what you were able to recreate, what data you used to recreate those movements, firstly, and then we'll talk about possible changes to the movements later. So what were you able to do in that case as far as recreating it, and what data did you use or information did you use to recreate?
In the truck?
Yes, in the car case.
I had accurate measurements of the truck, so I had recreated the truck. And since I had the motion capture suit on, interacting with the truck, my movements fit well within the truck. So then I take my movements, it exports a BVH file, which is a motion file.
Okay.
And then I bring that into a 3D program that I also have the truck in. And then I can just place that person. What you do is you map that person's movements onto a figure that matches the person that was involved. You map it onto the person's skeleton. So then his movements are all accurate, the size of the person is accurate.
Let me interrupt you and ask you, how do you get the size of the person to be accurate?
From police reports or coroner's reports. Or
So you would use height and weight, and does the software, or a function of the software, is to take that data, input into the software, and it recreates a body in proper proportion to height and weight and whatnot?
It doesn't do any simulation like recreating like that. I just have a figure that I size to the size that I need. And when I bring in the motion capture file, you can specify what height the person is.
And can you specify their weight, for example?
Weight is more the appearance from photos.
Would it be helpful for you to, and do you have the animation available of the car recreation?
I've got another sample.
Then we'll go on to another one, if you don't have the car one with you.
This is just a simple one that happened in a Sam's Club parking lot.
Okay. And I think it's shutting down, so we might need a moment, Your Honor.
Okay.
Be able to hook this up to you.
Might take a moment. We have one screen on, but not that one, so I may need some help from the clerk just to do an input change. Unplug it and then put it back in, see if that helps with it self-identifying the source. It's on the screen on here.
Just went off. Just went off the screen.
I think since it's just the court, maybe if we could somehow approach the bench, you could see it off of his computer screen. I think that would probably satisfy the need for me to show a video unrelated to this.
Fine, you may bring it up here. Council want to approach?
Just identify where we are. If you would advise the court, you can hear us? Ma'am, you can hear us? Thanks. Advise the court what it is that you're about to show.
This is a sample of a motion file applied to a figure in the computer and dropped into the scene.
And very quickly, how is this scene recreated so that it actually shows the environment that is the background for the event?
This was all created in 3D software.
And where the information come from?
There was a security camera. It was very bad resolution, so I went out and measured the scene and placed the vehicles where they were in the video. And this is just a better representation of what they couldn't see in the security video.
And in order to come up with those graphics, when you say you went out and measured the scene, then is that the information you then put into one of the graphics programs you mentioned earlier?
Yes.
And then we're about to see the actual animation. So how does the information concerning the movement of the animation get placed into the environment?
I just imported from the motion capture software.
Okay. And again, that's just something that you take from one environment that you created, and then when you put the action into it, how does it get placed in the right location, and how does that occur?
I can move the figures around according to where they were placed in the scene. I can move around, rotate them, and place them into the scene.
Okay, so that's a manipulation that you can do based upon either advice of counsel, evidence in a courtroom, or even come up with alternatives as to how an event may occur, correct?
Yes, it doesn't change their movement. I can just change their location in the scene.
Okay. Go ahead and play that for the court then, if you would.
Oops. So I actually used the shopping cart to position my hands correctly.
So is that then a graphic representation of information that you took from evidence or witness statements, whatever, and then made a graphic representation of it on the screen?
Yes.
And when you say that the movement of the person, how do you decide how the movement is, both the speed, the direction, and how does all that occur?
It was timed from the security camera.
Okay. As far as that, nothing further than that.
Okay. Thank you.
Now that we've had a chance to look at that animation, was there anything, before we get specifically to the Zimmerman case, but to ask this, was there anything different in the software or the hardware that you used in that representation than the one that you've used in the Zimmerman case?
The Zimmerman case, there was more total station data. It wasn't data that I acquired. It was data that was provided from the DA's office.
Okay, before we get to your specific work on this case, tell me, are there any coursework or training programs that you go through to either enhance your abilities to do this type of work or to maintain your level of competence?
both in the ARIS 360 software. I've gone through classes in that and been trained in that. I've been through 3. It's only required to go through 1, but I've gone through 3 total station data classes and been certified in using those in both ARIS 360 software and visual statement software.
Let's talk about the total station for a moment. That's the software program you said that law enforcement use?
The total station is the piece of equipment. It's a Sokia robotic total station.
And actually, you know, in the Zimmerman case, that there was total station information available having been gathered by the Florida Department of Law Enforcement, correct?
Correct.
In addition to those certifications that you mentioned, well, these total station certifications, who actually does the training for that?
The software companies train those.
Who own or license out the software?
Yes.
And what was the most recent time that you've taken any training regarding total station?
Training in those courses for certification, I think it's been a couple of years. It's on my CV. I can't remember the exact date. But also in the ARIS 360 software, I continually update my skills in that. They have a webinar every Friday that I watch.
So on total station, have there been any significant changes in the software since your certification, or is it still basically the same program?
The same. They come up with the software comes up with upgrades every 6 months or so.
And how about the ARIS 360 program? Do you take training courses on that? And you mentioned the webinars every Friday.
Yeah, I've gone through training and certification on using that software. Not only using the software, but using it with Total Station.
And how long have you used the ARIS 360 software?
When it first came out, I believe it's 2 years ago in September, I think is when it first came out.
Do you have the current version of that software?
Yes.
And up to date on your training with the current version?
Yes.
Any other software programs that you utilize in your general work in creating computer graphics and animations?
The 3D software that I use is it's Luxology, use Modo.
I'm sorry, say that again and slower for the court reporters.
The company is called Luxology, and the software is Modo.
M-O-D-O?
Yes.
And it's Lexology?
Luxology, L-U-X.
And explain to the court then what that 3D software is and how it differs from the other two we've mentioned so far.
It's for creating 3D scenes. They use it for animation movies, animated movies.
Does that then give you or allow you to present the environment we talked about, or the framework within which the animation is going to be created?
Yes, it's an environment where you can take all the data and bring it into it and create the scene.
So if you were to create an animation of this area, would you then do the dimensions, get the environment, and then start putting in elements like the desks and the credenzas and the clerk's desk, things like that?
Yes.
And how do you get those accurate?
The measurements from the total station data.
So that the total station would be used in conjunction. It would bounce points off the various relevant points here, and then sort of input it into the software, into the program.
Yes. And then also, one part of the ARIS 360 software is I have a helicopter. I haven't used it in this case. It's just a drone. And I fly it above the scene. I can take a photograph of the scene. And then with that photo, I have the data points from the total station of the scene. I take the photo and it'll lay it on, it'll drape it right onto those points. So you get a very accurate outdoor reconstruction of a scene.
So in effect, you can get more of a bird's eye view of the situation and also make certain that the ground level scene is accurate based upon a comparison with those data points?
Yes.
have you had an opportunity then to create these type of animations and discuss them in the context of civil and/or criminal cases?
Yes.
And if you would give the court an idea over what period of time you've done that, and then we'll talk more specifically about the type cases and whether or not you've testified in court.
It's been an ongoing for the last 13 years of doing it for criminal and civil cases.
What was the first time that you created and presented an animation in a court case? Not necessarily in a courtroom yet, but into a court case.
2009.
If you would then tell the court, have you ever then gotten to the point where your animations have been utilized in a courtroom?
Yes.
And tell the court the experience that you've had in both civil and criminal settings regarding your testimony and admissibility of the animations.
Well, also I use the motion capture suit not only for doing animations, but also to verify a person's position. I did one a couple months ago where a person was also in a vehicle. Somebody came up, shot through the window, and then shot a couple more times. And I had to determine which shots were done with him in the car and which shots were done because the car door was open and then he fell down. So I had to verify his position when those 3 shots were fired.
So in that animation, and explain to the court how is there a name for this motion suit?
It's a XSEN.
XSEN?
Yes, XSEN's initial motion capture suit.
And you used that in the shooting case. Explain to the court how it benefited you and in the presentation of the animation.
What I did was I put on the suit, got into a vehicle that matched the vehicle that was used, and recorded my movements of getting out of the vehicle. And then I put it in the computer, and then in the figure that matched the victim, I put in the rod to match the bullet trajectory, and then looked at his positions getting out of the car to see what positions the bullet trajectory would be, and if it was consistent with the height and the position of the shooter.
Now let's talk about that in a little bit more context. So when you get in the car, you have the motion suit on, and it's communicating with a computer, correct?
Correct. And
so the computer knows exactly where the body is, in that it knows exactly where all 16 accelerometers are, correct?
yes, you calibrate it at the beginning of your recording.
Calibrate for accuracy?
Yes.
And so at that point, you're doing movement, but the computer is actually gathering data on 16 discrete points in space that are moving throughout space. Is that
yes.
correct? The computer at that point may not know it's a body. It just is keeping track of 16 data points. Would that be accurate?
Well, in real time on the laptop, you can see a mannequin. Okay. So if I move my arms up, the mannequin will follow all of my movements.
Okay. Explain to the court how you handle the frailty of an animation, because it is not an exact video of, in this case, the driver moving his arms one particular way, but rather you deciding how the arms ought to be moved and how the body moves. So how do you address that frailty of the animation?
You look at certain things that you know from the discovery, like the bullet trajectory, the opening of the door, and also the physical characteristics of the inside of the truck. And you look at different scenarios to find which one best matches the scene and the evidence and discovery that you have.
So in effect, what you do is do an animation that, at the point you create it, is consistent with the known information about do you then make your animation in consideration of the evidence known to you at the time?
Yes.
And if that information is modified or augmented by additional information, do you then modify your animation to come into conformity with that?
Yes, whatever's most accurate.
At the point in time then when you don the suit, like you mentioned a moment ago, that the software allows you to change the configuration of the body for things like height.
Yes.
And then how do you then do a analysis of the person's physical size, not just height, but if the person is particularly thin, particularly obese, how do you look at that and what do you input into the program to accomplish that?
Most of that is done through photographs that you have from coroner's reports or police reports, photographs.
So do you then take measurements of those photographs, for example, do the ratio comparisons and then put that ratio comparison onto the mannequin, as you say, to make it as close as possible to the live event?
Yes, the measurements that you can get from a coroner's report or a police report, or even any measurements that you can take.
And you also look at photographs?
Yes. There's a thing you can do, which is I do not only on that, but say for example, police took pictures of a scene. One of the things that's challenging with what I do is I come in after the fact. So I have to rely on police photographs that were taken at the scene. So a lot of times you don't have certain measurements for things, but you may have one measurement for an item in a photograph. So if you have one measurement of an item in a photograph with photogrammetry, you can extrapolate the measurements of other items, and that's photograph.
Just explain very quickly what you just said by photogrammetry. What is that, and how does that assist you in coming up with measurements?
It's if you have one known object that you know the measurement of, with software, you can extrapolate the measurements of other items in the scene.
For example, if I'm standing here and you know how tall this is, and you might know how tall this camera is, that would assist you in telling you how tall I am?
Yes, and other items, like I can tell how far away from the wall that you are by the position of your feet relative to the height of the wall.
And that's what gives you the photogrammetric distance perspective, right? So that if I was this much further away, you were looking at it, it might be different than if I was this close.
Yes. You lay down a plane in the software, you lay down a plane, and if you know one measurement, you apply that measurement to the grid, to the plane, and it'll extrapolate the measurements of the other items.
And that's all the computer software that exists in these various programs we talked about. You don't necessarily know the algorithms or the math and physics behind it. You just know that it has been certified to work.
Yes.
And this type software, and we're talking about this concept of a motion suit, does that have application also in the entertainment industry?
Yes.
What type?
The suit that I have, it was used in Avatar, Iron Man, X-Men, and they use it for creating movements of the characters in the movies. And it also is used in gaming, like Madsen football. So they put on the suit and record the movements and apply them to the figures.
So in effect, when we see Robert Downey Jr. running around looking like Iron Man, it's actually a stuntman in a motion suit?
Or he could be wearing it.
Okay. And then the Iron Man is then placed on top of him in the movie?
In the computer, in the 3D program.
Okay. And we were talking, and I took you off on a bit of a path, we were talking about your experience in testifying. So you advised the court, I think you said about 2007 you testified about a case. How many times have you testified in court? where your animations were presented. And do you need your CV?
Yeah.
Just a moment. On that for a moment, we'll come back to your CV. It seems to be close by, but not right here. So if you could advise the court your experience in testifying regarding the animations.
Animations or use of
I'm
the
sorry.
suit?
Use of the suit and your presentations in court.
Pretty much most of the work that I've done since I acquired the suit in 2008.
I'm sorry?
Pretty much most of the cases that I've worked on since 2008. So probably 20.
Okay. And if you could advise the court the types of cases that you've worked on and what courts you presented them to.
That's also on my CV.
Yeah.
It's got a list of the counties and the,
Sure. Just having a bit of a trouble finding it right now. I don't know if you have a copy of it on your
I think I got it on my iPad.
computer. Sorry.
I might have it on my iPad.
If you don't mind, if the court doesn't mind a moment for you to get that, and we'll present a copy, a very hard copy as soon as we can.
Mr. Manti, would you like to see it when he brings it up?
I actually have a copy, so I don't need to see one, but
It was provided, I just, not suggesting anything, but when it wasn't a hearing, then it didn't know that I needed that information.
I don't have it on here.
I think
need
Mr.
it.
Manti would be so nice just to let us use what seems to be the only copy in the courtroom,
that's a front right there, it's highlighted, but I don't mind.
if you don't mind. Thank you very much. If that assists you, then tell us the type cases in the courtrooms that you have presented that work in.
I've worked on 59 criminal trials so far, 21 civil trials, and I've done declaration or testified in 20 of those.
Okay. So approximately 100 presentations, whether by declaration or testimony?
Oh, 59 was the total,
Oh,
or
I'm
59 plus 21 civil.
Okay. And you give the court then an overview of the type of criminal cases that you've been involved in?
Trying to figure out shooting incidents. I've worked with the Department of Justice in police officer involved shootings, stabbings. It varies quite a bit.
Okay. In each of those 59 cases then, did you take on the information that we've talked about, gather together data, and then make a graphic presentation, whether it's an animation or poster type presentations?
Yes.
And are we now talking about the spectrum of murder cases and aggravated batteries? I mean, do you know the charges, or were you just told the information?
Sometimes I've been told more detail. Sometimes I'm just given the evidence and I do creation from the evidence.
Within that context, let's focus on the 59 cases. How much or what percentage of that would you have worked on behalf of the defense, and what percentage on behalf of the prosecution?
100% on the defense. But that doesn't, some of that has also to do with defense of police officers in police officer involved shootings.
And if you would explain to the court what you mean by that and what cases you handled in that regard.
If the Department of Justice has a police officer that is a civil case is brought against him, or a shooting occurred. Then I've done work with them on doing a reconstructions on that, also assisting them in court in the presentation of their material.
Okay. Again, focusing for a moment on the criminal cases, have you actually presented testimony in court in any of those 59 cases?
Yes, in about 8, presented personally or had my material
Has your
presented?
material is presented after you've been qualified?
Yes, pretty much all 59.
Okay, maybe just give some flavor to the court as to what courts you presented to, and then we'll talk about whether or not actual testimony was required.
I've been qualified as an expert in Placer County, Alameda County. I've got Placer County,
Can you spell that?
Placer. I got about 16 counties here that,
And those are all in California, correct?
yes.
Okay. If you would, just for the record purposes, advise, when you're talking about the counties, are these counties in which the courts of that county have authorized you to testify as an expert? Where you've actually presented or had your information presented to a court where it was qualified to be good information to be presented?
All the courts where my information has been presented, it's all been qualified. I've never been denied.
If you would, list through the counties in California then, and do it slow enough so the court reporter can get it down, and there may be some need for spelling. Just want to make sure it's a record.
Okay, Placer County, Alameda County, Contra Costa County, San Bernardino County, Sacramento County, Los Angeles County, Napa County, Fresno County, Solano County, Solano, Yolo County, San Francisco County, Riverside County, Stanislaus County, Stanislaus, San Mateo, Santa Clara, Orange County, Santa Cruz, and El Dorado.
Have you ever testified in Florida before?
No,
Have you testified outside of California before?
no.
How long have you actually had the motion suits that you talked about a moment ago?
Since 2008.
And in those counties that you've testified, those counties, did you testify in each one of those counties, or was your information you created presented in those counties?
Information that it was both.
Okay.
My information was through either being as an expert witness testifying in court or a declaration, because sometimes the material that I create can be testified to by another expert, like a ballistic expert or a medical expert. Or
Do I take it that in certain cases you might create the animation or the graphic, and then that is admitted by what you call declaration, we may call affidavit, such that the underlying graphic is brought to court even without you having to come in live and testify?
yes, I just speak to the accuracy of the creation.
Have you actually testified in court concerning the accuracy and the methods used to create the animations or the graphics?
Yes.
And if you would advise the court, as best you can, what counties first? And I'm going to ask you, to the best of your recall, what cases and types of cases you've testified to in court.
Um,
You want to go through them one at a time, or however you want to best present that?
I don't have a listing of exactly which counties I...
Just from your memory, what cases have you testified to in court? What type of cases?
All the ones that I've testified to in court have been criminal
Okay.
trials.
So give the court then an example of some of the cases that you testified to and what animation you presented and what you testified to regarding it.
There was one in Placer County, it was about 4 months ago. I testified in that on doing the shooting reconstruction, and that was to determine the position of the person shot and the position of the person shooting, and then what order of the shots that occurred and what position they were in when they were hit.
And was that one of the examples you gave us a moment ago?
No, this is another example.
And did you testify in that court?
Yes.
Were you qualified as an expert in this area of the creation of and presentation of graphics and animation?
Yes, I was qualified as an expert, and the motion capture suit was also accepted.
Okay. Another case where you testified in this regard?
There was one in Contra Costa County, the one where I was trying to determine the position of the person of the 3 shots when he was shot in the car. I was able to determine that there was only 1 shot through the window, and then the other 2 shots were outside of the vehicle.
And was your testimony, were you qualified as an expert to give that testimony in that court?
Yes, I was.
One more, if you would, about another case where you testified in court and the basis for it.
There was a couple down in Moreno Valley, down in Southern California. There was 2 of them, actually. One of them was a person was inside a house. They were threatening suicide. They were chatting to somebody saying they were going to kill themselves. Police officers responded, and they were waiting at the corner of a garage, asking him to come out. One of the officers was looking out at the street because people were starting to come around. The other officer was looking into the doorway. So what I needed to do in that case was determine who shot what, which officer did the shooting, and also the position of the person that was in the house. In my reconstruction, the person in the house said that he was on the floor in the kitchen the entire time. He was charged with 2 counts of attempted murder on a police officer. I was able to show that he was in the house the entire time because of the angle of the door when the bullets hit. The first police officer said that the person came out and pointed a gun at him. So he started firing. He fired 3 shots. His partner turned around and just started firing, shot the partner in the elbow, and continued firing into the doorway. I was able to show which shots came first, the 3 shots, and what position the door was in. And then the second series of shots, what position the door was in at that time, and able to show that there was no way somebody could have come through the door when those shots went off because there was such tight space outside the door. If he was outside the door, he would have been hit. He wasn't hit, and there was no way for him to go in and out of the door, so he had to be in the...
Was that testimony then accepted in that court?
Yes.
And did you actually give evidence or testimony before the court or the jury in that case?
Yes.
Of the 59 cases that you were involved in on the criminal side, we'll talk about civil in a moment, but of those 59 cases, have there been other cases where you've been attempted to be qualified as an expert for the underlying graphics or animation where you were failed to be qualified as an expert?
No.
In all 59 then, either by affidavit or declaration or testimony, you were able to give your testimony in regard to what you created?
Declaration or testified was 20 cases.
Okay.
So in all of those cases, I've never been disqualified. I've been qualified in all of them.
Was the experience you had on the civil side similar, the other cases that you've talked about?
Those were mostly information designed for the attorneys for presenting their case to the jury.
Were there any of those cases on the civil side where it actually went all the way to trial testimony, where you gave testimony before a court or a jury?
Not in the civil trials.
Just on those in the criminal that we've already talked about?
Yes.
Okay. Let's talk a moment then about the Zimmerman case, and advise the court then what you did and how you first became involved in this case.
First became involved at towards the end of April. I initially had a conversation in August, but my first meeting with the attorneys was towards the end of April.
We had talked in August of 2012, correct?
Yes.
And then you went through a medical condition that sort of took you out of sorts for several months?
Yes.
Okay. That's all resolved?
We'll see.
Okay. And now you're back to work, and we talked again, was it April of this year?
Yes.
Okay. And what information did you then gather and review? Well, first, what task were you given as far as work on behalf of this case?
The scope of work
Yes.
was to do a reconstruction of the scene with the information that we had and creation of an animated timeline.
Okay. And what information, was that something within your qualifications?
Yes.
Is that similar to what you have done in these other cases that we've talked about, both the 50 non-criminal cases and the 20 or so that either live testimony or declaration testimony was given?
Yes. There's not a lot of opportunity, though, to have live audio during the occurrence.
So
So
this is-
that was different in this case, where we're able to have work audio into it with the 911 call.
Somewhat unique because we had actual audio recreation or audio evidence, real-time evidence available for you to use in your recreation?
Yes, it helps you with the timeline.
Okay. Similar, I guess, to when there's a security video camera that exists and you have some of that information that makes it that much more accurate?
Yes.
Video surveillance did not exist in this case, though?
No.
So this was within the area of your expertise where you've been qualified before to create this type of graphic and animation?
Yes.
So what information did you then gather or was given to you to assist you in the work that you've done?
The discovery from the district attorney's office, photographs, coroner reports, police reports, audio from the 911 calls. There was also investigation or questioning at the police department of witnesses.
Depositions?
Depositions, yes. Also photographs that they took of the scene, and then also total station data that they, from their measurements.
Okay. Were you able, was there any information that you needed in order to create the animation or the graphics that you did not have available to you?
Use of the motion capture suit at the scene, that wasn't available to me. So I made 2 visits to the scene.
Okay. So in effect, you came back, once you had the information and the foundation for the animation or the recreation, you then came here to utilize the motion capture suits?
Yes.
Okay. Do you recall when that was done approximately?
Second week in May.
And explain to the court then what you do with that and who did it and how you assure accuracy in that regard?
To assure accuracy, that's where it's good that I can interact with the suits at the scene, because if there's a slope or other physical characteristics of the scene, you catch that in the movements of the person that's walking over the surface.
In this case, was there any concern that you had with the data that was given to you that was gleaned from law enforcement? It looked good, except for there were 7 points that were obviously, they were labeled windows, and they were obviously not in the position of the windows. They're actually sort of in trees where the total station laser bounced off something different than what the person thought it was?
Yes, where they set up the total station at the T intersection of the sidewalk. They pointed it up at second-story window on the right side, and it went through the tree, and going through the tree, it picked up a few branches. So there's 5 points or 6 points on the one side, and I believe 1 point on the left side that went through a tree. So you've got points in the computer that are just hanging in space. So it's easy to see that it's at the location of the tree and not to use it.
Were you able to address that or fix it in your software that you ended up using?
I didn't manipulate the data at all. I just used the other points that they had.
So in effect, just excise those out because they were obviously sort of in the way or errors?
Yes.
Did you, in addition to the motion capture suits, we'll talk about that in just a second, did you do any other measuring of the scene now that you're on scene?
I also had another piece of equipment. It's called a Matterport.
Will you spell that, please?
Matterport. It's a Matterport scanner. It also sets up on a tripod, and it has a little computer in it and some cameras. So it has one camera that takes photographs, and another camera will take infrared photos for distance purposes. So you set this up, and with the iPad interface, you can just hit scan, and it'll twirl around in 360, and it'll scan the area around the scanner, and you just walk it through the scene. So it captures all the little intricate parts of the scene, along with texture map of the photos.
Oh, what map was sorry?
Texture map of the photos.
And how does that assist you in what you created in this case?
It was very helpful in getting the slope and the positioning of the buildings and the trees and the sidewalk.
Did that then make it even a more accurate rendition of the scene than the total station was able to give you?
Yes, it added to the total station data. And I verified the Matterport scanner with the total station data so that it all matched up.
It meshed pretty well so that what you came up with in your review matched the total station data?
Yes.
Did the Matterport then allow for a better graphic representation of the sloping that existed on the actual ground?
Yes.
And total station had not done that?
They didn't take very many, they didn't measure very many points. They mainly measured there's a couple metal drains and a sprinkler head or piece. They went around and measured those and the edge of the sidewalk and then the building, but they didn't do, in the location of the trees, but they didn't do really any measuring of the slope.
So did the Matterport then allow for a even more accurate rendition of the sloping of the ground in the area where the T intersection was, the area where the body, where Trayvon's body was, and other points along the way?
Yes.
Mr. O'Mara, Mr. Shoemaker has been standing almost
Yeah,
an hour. I thought that when you wanted him to stand at the podium,
Yeah.
that it was going to be a short presentation. Would you like to take a seat, sir?
How much longer? I'll be okay.
We're getting to the meat of it right now, and that's not going to, I have to have him review the animation for you and the pictures, so I'm going to have to drag it back down here in a moment, so I'm going to move it along.
Thank you.
So, you went to the scene, got everything that you needed to start working on what your project was, correct?
Correct.
So then what did you do with that information? Well, we were talking now again about the motion capture suits, who did them, and what frailties exist with having other people use the motion capture suits.
There was a couple volunteers from the your law office that put the suits on. Then as far as the timing for the second part of the scenario where they were on the ground, we used, or I used the audio from the 911 call for the timing of it, to time it with the shot of the gun.
Okay. Did you also available to you, John Good's police statements and I guess at that point deposition testimony regarding what he said he saw and what happened?
Yes, that was used for the their positioning.
Did you also have information available to you from a Miss Mora, M-O-R-A, a woman who said she saw George Zimmerman on top of Trayvon Martin some seconds after the shot?
Yes.
And did that assist you in the creation of your animation, putting the bodies where other witnesses saw them?
Yes.
Did you also then have, as you mentioned, what we now call the Lauer 911 audio, which has in it the shot and a matter of time before the shot itself?
Yes.
What did you also have? Whatever other information was available to you from the discovery?
There's also Ms. Lauer's police report statement.
And that included her statement that she first heard the altercation occur at the T intersection?
Yes.
You also had Jeremy Weinberg's information available to you, and he cooperated that?
Yes, from the same location.
Now, as we fast forward through this, you had created some poster graphics, we'll call them stills of the scene, and we'll get to those in just a minute, based upon that testimony as well?
Yes.
Did you most recently remove Mr. Weinberg's statement from one of those posters, since I advised you that he ended up not testifying here at trial?
Yes.
So along the way, and we'll get to it in just a minute, were you modifying the animation and the posters to come in line with actual trial testimony?
Yes.
At least as it was disclosed to you by me or on my behalf?
Yes, to get the most up-to-date, accurate representation of it.
Okay. And were you in fact able to create an animation based upon the information available to you?
Yes.
Before we view that, let's just go over the sources of that information. You had testified a moment ago that you had seen discovery, correct?
Correct.
That's what we call it here, and that's including witness statements, depositions, and other information like autopsies and police reports, correct?
Correct.
And did you also have available to you diagrams made by the witnesses, such as John Good did a diagram showing stick figures with certain placement of bodies?
Yes.
And all the other information within the discovery?
Correct.
I know that you don't know the full answer to this question, but did you get a lot of information from the defense, including all the witness statements, police reports, and diagrams that you felt were necessary to create your animation?
Yes, I did.
You didn't receive a lot of information that was extraneous or unnecessary in creating your animation, but that you wanted to review it to see if it was relevant?
Yes.
You also then have conversations with me or people on my behalf regarding the creation of the animation?
Correct.
What other sources of information did you have in order to come up with the animation and the posters that you did?
Pretty much everything that you mentioned.
Okay. Anything else besides that? The discovery itself and conversations with me?
My going to the scene and scanning the scene, photographing the scene, doing the motion capture.
Was there anything that you would like to have had to assist you in creating the posters and the animation that was not available to you in this case?
I believe I had everything that I needed to create the scene.
I mean, aside from a video of the whole event or something that would, okay. Then I'm going to ask you to present the animation you created. We'll talk about it, but we try one more time for a moment to see if we can get this projected to cooperate, because it's going to look a lot better there.
It was working yesterday.
Mm-hmm. Yeah.
T, do we need to get Victor in here?
We'll need it sometime during the day, so we'll just get it fixed now and have it go away. Well, we could. We're going to need it.
Well, they can fix it during lunch. I still have a jury sitting back there now for an
Okay,
hour.
then let's try it.
I had not anticipated that we were going to take this time, so if you'll please bring it up to the bench and I'll look at it from there. I can.
Do you need police, fire, medical? Maybe both, I'm not sure. There's just someone screaming outside. Okay, what's the address of that here? Please. Is this in Point Lake Town, in Sanford? Yeah. Okay. And is it a male or female? It sounds like a male. And you don't know why? I don't know why. I think they're yelling help, but I don't know. Just send someone like say stop. Does he look hurt to you? I can't see him. I don't want to go out there. I don't know what's going on. So they're sending. So you think he's yelling help? Yes. All right. What is your There's gunshots. You just heard gunshots? Yes. How many? There's one. Jimmy, get down. No, come here. Is he no longer yelling?
Tape continues, but the animation
I
doesn't.
don't know.
So I don't think we need to hear that.
Jimmy, get in here now.
Now, as you're at the bench, there are the posters, which is another things that he created.
These are the new ones?
Some of them are new. We took out Weinberg, for example.
Still didn't get this.
These are very nice. I don't know if you want testimony at the bench, just so he can at least identify
If he's
what
going
they
to
are.
show them to me, yes.
Yeah. Okay, let's go through this, and I may question you about the animation in a minute, but if you would, just advise the court what this is, first of all, and how it was created.
This was created from a still image from the 3D model that I created for the animation. It's to explain the location of the markers and the witnesses.
And just so I'm clear, where'd you get the markings, where you have the markers, how did you identify them and put them at that particular location?
It's straight from the total station data.
Okay.
I not only used total station data, but they also had a flat 2D illustration of the scene from their data.
And that was incorporated as well?
Yes, so the location of these markers are exactly where they're marked on that.
Okay, next slide.
It's
Same thing,
basically the
diff-
same thing, just
Same thing, different view.
different view.
Next slide.
This one's to show the slope.
And again, that came more from the Matterport than the total station?
It's from the Matterport, but it's verified with the total station. The different areas where the concrete, the sprinkler and the drain heads, they matched up with the Matterport. So I was able to verify the slope.
But this does give you a better slope than the total station alone would give you? A better rendition of the slope?
Correct. They don't, on their total station, they just had sidewalk marked and those
Right. They did not run like
drains marked.
They did not run like a bunch of points on the ground, which would have given you the slope, and that's what you did with Matterport?
Yes.
Okay, next one.
Then this is just to show photographs from discovery of what was at those markers.
The flashlights and where they were found.
Yes.
Okay, next one. Again, different parts of different items, where they were located. And for example, top left-hand corner is the picture that you just imported from the picture we gave you.
Yes.
Bottom left is the picture from the medical examiner with the Mr. Martin's wet pants.
Yes, from the scene.
Okay, then the cartridge case at the bottom,
Yes.
and then the cell phone.
Yes.
And in the middle?
This?
Yes.
That's from the point of view of Mr. Good.
Oh, and you can see right behind the pictures on the left is Mr. Good's head in
You can
effect.
see his ear right back there.
And that
And
was-
it's taken with a 50 mm lens in the software. So that is what most closely resembles what a person will see.
Okay, and there's a line going sort of right above the cartridge case. Is that a distance measurement from what to what?
The edge of the porch concrete to the marker number 8.
Number 8. And when you say 50 millimeter, that's the way the human eye looks at an event. It's about 49 or 50 millimeters.
Exact measurement, I believe, is 49.5, but it's just rounded off to 50.
So you look at, this is a perspective that one would see as a human's looking at it through a human's eyes.
Yes, if you were standing there, that's how they would appear if you were
That's the
standing.
perspective.
Perspective, yes.
Okay, next one.
This is going back to the T intersection.
And this was the one where we initially had Mr. Weinberg on it as well. He didn't testify, so we just had Ms. Lauer. I think that's a trial testimony as to where she thought the altercation occurred.
Yes. So it's an explanation of why I placed him there. So it's a,
Okay.
And that is John Good's head off there to the left as sort of a focus point.
yes,
And that again is a 50 millimeter presentation
yes,
with the distance included.
yes,
And that states what John Good testified to at trial regarding the what he saw and the people's descriptions.
yes, yes.
Next one. And that's Ms. Mora's testimony from trial as to what she saw when she looked out around her column.
Yes.
Is that the column on the right-hand side?
Yes, there's a aerial map here showing where her condo is.
And is that also a perspective of what she would see from her location?
Yes, it's a 50 millimeter lens. Also in all these photographs, I didn't try to reconstruct the lighting because it's more important to see detail.
Okay. Obviously, if I was Ms. Moore looking at this, the lighting was much darker back then, correct?
Correct.
So that's one frailty, if you will, of the presentation of the posters, because if the lighting was what it was that night, almost nothing could be seen as far as your poster presentation.
The jury would have a hard time seeing detail.
Is that the last one?
Yes.
Yeah. Bring out the other side again. I have a motion.
I think the problem they're having is with the Apple computer interaction, and they're going to check it out over lunch.
We'll change it out to a Mac, to a PC, and get this presentation on a PC should whatever part of it be
Do you have
allowed.
any other questions?
Just very briefly, which is, so you have been doing this type of graphic and animation work and presenting to court for the past 13 years or so?
Yes.
Okay. And I think you testified that you have not, your work has not ever been disqualified or disallowed in a court?
Correct.
Tell me your awareness of the industry of animation and other people who do this type of work.
The type of work that I do, I'm the only one in the United States with a wireless motion capture suit, so I'm unique in that way.
There are other people who use similar motion capture suits, those being the older style, the one with the balls, correct?
I believe some reconstruction are using it, but it's really very rare that you find a reconstruction that has a motion capture suit, whether it's the balls or the wireless.
The area of reconstruction of events, though, you've been involved in that for how long?
13 years.
And this type of work is also accepted, is it not, in the entertainment community, as we've talked about?
Yes.
And that's used, as we talked about, in both video games and in motion pictures, such as Avatar and Iron Man?
Yes.
And this software that you utilize, tell the court where that fits into the industry of reconstruction of events.
The 3D software I use or the AIRS 360?
Either as a compendium or individually.
It's just one of the key elements that I use in reconstructing.
And how long has that software been around?
Luxology has been around probably 4 years, but I believe 4. It started out as version 201. They're up to 701 now, so it's been around for a while.
Okay. And do you ever attend seminars or any type of conventions where other reconstructionists interact or talk about information in regard to this industry?
Yes. Well, the software actually has a users group that gets together, the Moto software, and I've given presentations there on the work that I do.
How often do you give presentations to that group?
I've just presented to them once.
Okay. And in that user group, is that made up of the people who use this software on an ongoing basis?
Yes.
We're talking about the ARIS 360 now?
No, that is the Modo software.
I'm sorry.
There's a group, the ARIS 360 gets together with a webinar every Friday.
Okay. And do you keep up on that part of the industry, the interaction between other people who use this software?
Yes.
And is this software one of the softwares that is accepted in the community of people who create animations or recreate scenes, whether it be for accident reconstruction or other types of recreations?
Yes. The Highway Patrol uses, I think there's 3 basic kinds of software that is used for car accident and accident or crime scene reconstruction for the police departments, which is Visual Statement, ARIS 360, and there's another software which is called Crime Time or something like that. That's what Sanford Police uses on theirs.
Is the software then you use some of the most up-to-date and current software that's available for this type of work?
Yes, ARIS 360 and Visual Statement are the industry standard for accident and crime scene reconstruction.
And do your contemporaries who do work similar to yours, though they may not have the suits that you have, use this type of software to do their work?
Some of them. It's mostly used in police departments for their reconstruction.
ARIS 360 or the Moto or?
Probably 80% of ARIS 360's customers, I've asked them, they said 80% are police departments. The rest are accident reconstructionists like myself or crime scene reconstructionists or private investigators.
And you interact with these people, including law enforcement, on these user group meetings that you have?
Yes, you can ask questions, and if you have anything coming up from the week, you can get it answered at the end of the week.
Within the context then of accident reconstructionists and animators, is this software then the type of software which is used in that industry?
Yes, mine's kind of like cutting edge.
Yours is more advanced, correct?
Yes.
And even you say that you're the only one who uses the new style of motion suits for your type of work, correct?
Correct.
They are used, however, again, in the entertainment industry much more so, correct?
Correct. They're also used in, like I mentioned, medical rehabilitation.
Is any limitation to their availability based upon their expense?
Yes.
Okay, they're still quite expensive?
Yes.
No further questions, Ron?
Cross.
Judge, I could ask for a 5-minute break before we do that, and I would also ask the witness to just assume the stand.
We can have a 5-minute recess, but we'll be in recess for 5 minutes. And when we come back, Mr. Shoemaker, if you please take the stand. Please be seated. Is Mr. Shoemaker here? Or? How much longer do you think that this is all going to take? Because I've had a jury sitting back there since 9 o'clock. I stayed late last night so I could get this accomplished and was told I didn't have to. So how much longer do you think it's going to take?
I'm going to ballpark it at 45 minutes.
45 minutes? No. We'll do this afterwards. I'm not having a jury sit back here for another 45 minutes doing nothing. So we'll have to do this in the afternoon. Mr. Shoemaker, you can remain outside. We'll continue the hearing after court. Are we ready with your next witness? Because I want to bring the jury in. Is the defense ready with your next witness?
Yes, ma'am.
Okay, are we ready to bring the jury in? Very brief.
Very brief. Put it a little bit.
Yes, you may. Mr. Zimmerman, please stand up for just one moment, sir.
Yes, sir.
I have been informed by counsel that the testimony of Dr. DeMayo is going to be carved down. And I don't want to know what the discussions were. I just want to know, did you have discussions with Mr. O'Mara about Dr. DeMayo's testimony?
Yes, sir.
And based upon those discussions, do you agree with his representation that he is not going to ask certain area topics from Dr. DeMayo?
Yes, sir.
And that is your decision that you agree with that?
Yes, sir.
Has anybody promised you anything to get you to make that decision?
No, Your Honor.
Has anybody threatened you?
No, Your Honor.
Are you doing so freely and voluntarily?
Yes, Your Honor.
Thank you very much. Are we ready to bring the jury in?
Yes, Your Honor. No, not quite. Just very close.
Well, how close are we?
Would like to have the physical exhibits in the courtroom, Your Honor. The shirts that have been encased.
Okay, if you'll please open the clerk, please open the evidence locker door and please get out whatever you think you're going to need. Can somebody from the defense please go in there and see what you need? Are we now ready to bring the jury in?
Yes, we are.
State?
Yes, Your Honor.
Thank you. Let's bring the jury in. Lisa?
Jury's present, Your Honor.
Please be seated. Welcome back, ladies and gentlemen. Again, I apologize for keeping you sitting back there, but we have been busy working here in the courtroom. During the overnight, I'm going to ask you my questions. If your answer is yes to any of the questions, please raise your hand. During the overnight recess, did any of you have any discussions amongst yourselves or with anybody else about the case? No hands are being raised. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use any type of an electronic device to go on the internet to do independent research about the case, people, places, things, or terminology? No hands are being raised. And finally, did any of you read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case? No hands are being raised. Thank you very much. Mr. West, call your next witness.
Thank you, Your Honor. Vincent DeMaio.
Do you solemnly swear affirm the testimony presented will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Morning. You may proceed.
Thank you, Your Honor. Good morning.
Good morning.
If you would, please state your name.
My name is Dr. Vincent J.M. DeMaio.
And would you spell your last name, please?
Capital D, small I, a space, capital M, A-I-O.
Thank you, Dr. DeMaio. And what is your profession, please?
I'm a physician, presently employed in the private practice of forensic pathology.
Do you hold a degree in medicine?
Yes, sir. I obtained my M degree from the State University of New York Downstate Medical Center back in 1965.
And Dr. DeMaio, would you please outline for the jury and the court your educational background then beginning at medical school?
Okay. As I said, I graduated medical school in 1965. I then did a one-year internship in pathology at Duke Hospital in Durham, North Carolina. From there, I did a 3-year residency in anatomical and clinical pathology at the State University Downstate Medical Center Hospital. Following that, I did a 1-year fellowship in forensic pathology at the Office of the Chief Medical Examiner for the state of Maryland. After successfully completing the 3 residency programs, I took my specialty board exams and was certified as a specialist in the fields of anatomical pathology, clinical pathology, and forensic pathology.
Is that board certification? Is that what you're referring to?
Yes, a board certification means that you've successfully completed a number of years of training in a subspecialty of medicine, and then you have taken a written and practical exam and passed the exam. And then you are certified and you're recognized by other physicians as a specialist in these areas of medicine.
Dr. DeMaio, you mentioned anatomical, clinical, forensic pathology. Let's start first with what is pathology, and then maybe some more detail about those other areas.
Well, pathology is a branch of medicine concerned with the study and diagnosis of diseases. Anatomical pathologists generally work in hospitals, and they examine tissue that is removed from somebody. If you had a mole removed from your skin, you had a breast biopsy, or some tissue, from inside your body or part of an organ removed, this is examined by a pathologist who then tells your physician what the disease is and if it's there, the extent of the disease, and then he tells you what the diagnosis is. Pathologists are generally doctors. You won't contact them because your physician has contact with them, and that's an anatomical. The clinical pathologist is concerned with the laboratory studies done on patients in a hospital. If you've had a blood test, a urine test, all of those are done in clinical pathology laboratories. The forensic pathologist is concerned more with the application of the medical sciences to problems in the law. Most forensic pathologists function as medical examiners. That is, they determine the cause of death, what killed the person, and the manner of death, how it came about, in individuals who are thought to have died of violence, such as accidents, suicides, or homicides, or who've died suddenly and unexpectedly, and the exact cause of death is not known. At that time, they may elect to perform an autopsy to make such determinations. And then, based on the circumstances surrounding the death, the autopsy findings and tests done, they'll make a determination as to cause of death, what killed you, and manner of death, how it came about.
Let's talk for a moment about the professional positions that you've held following the training that you've outlined at this point.
I'm sorry, but I'm having trouble hearing you. I apologize. My ears are getting a little less sensitive.
Let me touch this and see if it's... I'm happy to speak up, Judge. I think I was facing away, but of course, if Dr. DeMaio prefers some assistance.
We can make him available in case you need some assistance.
Sure. Apparently, we don't have a PA system in the courtroom that amplifies my voice, so I'll just try to be more careful to speak up. And
yes, sir.
So, following the training that you've outlined, would you please give us an idea then of the professional positions that you've held?
Yes, sir. After I completed my training, I went into the Army for 2 years. I was a major assigned to the Armed Forces Institute of Pathology in Washington, D.C. It was on the Walter Reed campus. For the first year, I was chief of the medical legal section. For the second year, I was chief of the wound ballistics section. Following this, I moved to Dallas, Texas, was a medical examiner there from the summer of 1972 till the end of February of 1981. In 1981, I became chief medical examiner of Bexar County, Texas. And for the transcriber, Bexar is spelled B-E-X-A-R. The X is silent. So I was chief medical examiner there. The major city is San Antonio, which I'll give a plug. It's the 7th largest city in the United States, and a beautiful place to live. So I was chief medical examiner there from March 1st, 1981, until I retired December the 31st, 2006. For 16 of the years I was there, I was also in charge of the crime laboratory. I then retired and I went into the complete private practice of forensic pathologist, which I have been doing since then. I'm also the editor of the American Journal of Forensic Medicine and Pathology, which is an international journal of forensic medicine. And I'm chairman of the Texas Forensic Science Commission, which is a state agency charged with, I guess you could say, monitoring the practices of crime labs in the state of Texas.
Dr. DeMaio, you did mention that you were the director of the Bexar County Crime Lab for about 16 years. Could you expand on that a little bit? What was your role more specifically, and what did the lab do?
Well, essentially, I established it. The police department had the crime lab. The county took over when I came there. It started out as just firearms and basic serology and document examination. And then we were one of the first laboratories west of Mississippi to establish a DNA laboratory. And it just does the usual things, you know, drug identification, DNA, trace evidence.
Did some of that work include knowing how to package evidence that may have biological or perhaps DNA evidence?
Well, yes. I mean that, but usually you just teach the forensic pathologists. They know that, because even if they have no association with a crime laboratory, that you have to. There's techniques for handling trace evidence, you know, in collection, establishing a chain of evidence, and packaging. So if you
is it well known that there are certain certain requirements when you are packaging evidence that may contain biological samples, blood, other fluids that may have DNA that are wet?
Yes, you have to dry out the material and then package each item individually in paper. Because if you don't let it dry out, and especially if you put it in plastic containers, the bacteria just love that, and they begin multiplying, and then you get mold, and it just stinks to high heaven, and everything deteriorates.
So that's something that's well known in the forensic pathology community?
Oh yeah, that's standard practice.
It's been well known for a while?
Yeah, I'd say maybe about 30 years that I know.
Back to the work that you have done with the group that monitors forensic labs. I think you said you were involved.
Oh, Texas Forensic Science Commission.
Yes.
Yeah.
What is that work, and what does that involve insofar as you and other pathologists?
Okay, essentially it's a government agency, and if there are problems, somebody thinks there's a problem with a crime laboratory, either an individual in it or the whole laboratory, whether their techniques or whether there's that somebody in the lab is doing something wrong, then it's reported to the state agency, and then we investigate it and then issue a report. Actually, most of the problems with the laboratories are actually reported by the laboratories themselves because they want the test to be done proper. So a lot more than half our investigations are laboratories reporting themselves that there's something wrong with them.
In addition to the professional positions that you've had and talked about, have you also had academic appointments?
Yes, with the University of Texas system, I started out as an assistant professor, then associate professor, and then I ended up as a full professor before I retired.
And in what subject matter, please?
Pathology, specifically forensic pathology.
Have you, in addition to your day-to-day work as a medical examiner and your work at the university as a professor in pathology, have you published any books or articles, scientific articles, in the area of pathology?
Yes, I've published 88 articles in peer-reviewed journals, I think 13 book chapters, and then I've published 4 books. The first book was Gunshot Wounds, which I wrote myself, and it's been published in English, French, and Spanish. Then I wrote a book called Forensic Pathology with my father, who was chief medical examiner of New York City, and he's deceased now. And then the third book was a handbook of forensic pathology, which I wrote with one of my colleagues, Dr. Susanna Dana. And the fourth book is on what's called excited delirium syndrome, in which I wrote, well, the senior author, I'm the junior author of that book. The senior author of that book is my wife, who's a forensic nurse. And so we wrote that book on excited delirium syndrome. That's the last one we've written. So
let's talk for a moment about your work in gunshots. That was, I think you said, the first book that you wrote, and has it been updated over time?
There's been 2 editions published, and the 3rd edition is going to the publishers in another week or 2. This week kind of delayed it, but it's going in about 2 weeks, the 3rd edition.
Would you describe for the jury generally the purpose or the focus of that book, if it isn't otherwise self-explanatory by its title?
Basically, the book starts out instructing people about firearms, and then it talks about firearms wounds in general, then in rifles and handguns and shotguns, mentions things, how to do an autopsy, how to collect evidence, and what you can do with the analysis.
When you say gunshot wounds, are you talking about how a pathologist could, by looking at a gunshot wound, learn such things as the distance, perhaps, from which the shot was fired?
Right, whether it's a contact or near contact or loose contact or distant wound, ranged, nature of the weapon, you can tell by the wound in many cases, things like that. And how to describe it and how to document it.
Has that been the sort of work that you've been doing yourself virtually your entire career?
Yes, I have a very strong interest in gunshot wounds.
You also mentioned, Dr. DeMaio, that you've written, I think you said 13 chapters. I take that means in other people's books than your own.
That's correct, sir.
And how does that work? How would you come to write a chapter that someone else would include in one of their books?
They solicit me to write the chapter. You know, they say, would you please write a chapter on this and that in other books.
Are some of those books a more comprehensive look at forensic pathology than maybe what you wrote yourself in your gunshot wound book?
Well, I don't think so. Usually, it depends. The chapters are not all on gunshot wounds. Some of them are like excited delirium or other things as well. Nursing, investigation of nursing home deaths and such.
About how many of those chapters, if you recall, that you wrote for other people's books involved gunshot wounds?
I think about 7.
You also mentioned that you have authored or participated in about 88 peer-reviewed articles. Would you explain to the jury what is a peer-reviewed article?
Essentially, it's a scientific article that is submitted to a journal, and when the journal receives the article, they send it out for other people to review, to essentially give their opinion whether it should be published or not. So it's reviewed by other people, then it comes back to the main editor, and then the editor decides whether to publish or not.
Peers mean other pathologists?
Other pathologists, right.
And if the article is indeed published, does that make it available to other pathologists, other researchers who may want to refer to it in work they're doing, or to perhaps educate themselves as to the body of research out there in a particular subject area?
It is. We have kind of like a central, used to be you looked in the library, but now you go on the computers and you can get into a medical library, and they'll have the articles listed, and usually nowadays you can actually review the article on the computer. But these are, essentially it's a library. So it's, all these things are listed in certain indexes for physicians.
About how many of the articles that you have participated in writing involved gunshot wounds?
I think something like 35, 37, something like that.
Over the entire span of your career, you're talking about the peer review articles, the books, the chapters, and the research that you've done yourself? These events, these writings were developed over the time that you've worked as a forensic pathologist.
Right, over 40 years.
You mentioned that you had worked in Bexar County as the medical examiner from 1981 until the end of 2006. During that time, did you routinely perform autopsies?
Yes, I performed about 9,000 autopsies, and then I reviewed the autopsies that were done under my jurisdiction, and that was about another 27,000, 28,000. That meant I read the autopsies and you know, said whether I agreed or not. And as I said, the 9,000, I did autopsies until October of the year that I retired.
Would you typically, if involved in a criminal case involving work that you had done, be called by the prosecution?
Yes. Yes, sir. You know, of course, when I was chief medical examiner, then I would testify in court about the autopsies I did, and the other doctors testified about the autopsies that they did.
Meaning that you had a staff of other forensic pathologists at your medical examiner's office that also performed autopsies?
I had 4 full-time physicians, plus I had 1 training position. Our office, my office, former office, was approved for a program to train fellows in the field of forensic pathology. There's about, I think, 38, 39 offices in the United States approved to train in forensic pathology.
During the time that you were there as a, for lack of a better term, a ballpark idea of how many autopsies the office would do in the course of a year?
Oh, we do 1,400 to 1,500 autopsies, I would say, and then we'd have about another equal number of 1,400 to 1,500 bodies that we elected not to do autopsies, just external exams.
And you would yourself perform autopsies throughout the time that you were there?
Right. I think the last autopsy I did was in October, and then I retired in December. You can't work to the last day because it takes weeks, if not a month or 2, to complete all the details of an autopsy. So you have to stop a couple of months before.
Since 1981, when you began your work at the Bexar County Medical Examiner's Office, were you also able to work as a consultant privately in other cases outside Bexar County?
Yes, sir.
And what kind of work would you do in that regard?
Mostly civil cases, and then a few criminal cases. Outside Bexar County, I could testify for the defense as well as for prosecution. So you don't do many private criminal cases, such as like what I'm doing now. I'd run about, 2 to 4 years at most.
You have been working as a consultant since the beginning of 2007 then, if I've done the math correctly. Exclusively as a consultant, having retired from the medical examiner's office.
Right, since January of 2007.
In other words, you've been in private practice as a consultant since January of 2007.
Yes, sir.
And the majority of your work is in connection with civil cases?
Yes, sir.
Does that sometimes still include gunshot injuries, though?
Yes, usually it's cases, insurance cases involving alleged suicides, whether a case is suicide or not. Occasionally you'll get a case of accidental discharge to maybe a defect in the firearm.
You mentioned that you were in the military. Did you do any research when you were in the military?
Yes, so that's when I started my firearms research. We did study the mechanisms of firearms and also review gunshot wound cases. We had with microflash and high-speed photography. You see pictures occasionally of like a gun going off and a bullet in the air or something. That's the type of photography we did. But we would shoot into ordnance gelatin to evaluate different types of ammunition and how effective it was. We also, when I was in charge of the wound ballistic section, I also had what was called the wound met study. This was a study done in Vietnam, and photographs of individuals who had been injured or killed by different type weapons, and it was an attempt to study the effectiveness of these studies. It was fairly exciting. All I remember now, we had 50,000 35 millimeter slides in this, and then we had all the cases with it.
You mentioned microphotography and began to explain to the jury what a picture of a bullet leaving a gun would look like. Is that right?
Right, it's called microflash, and what it is it's kind of like, a flash that you have on your camera, and only this flash is very, very quick, And so when you could take photographs of things like moving through the air, bullets going through the air, 2,000, 3,000 feet per second. You can just kind of freeze them when the flash goes off.
So would you take a moment, please, and explain to the jury the mechanics of what happens when a bullet is fired from a gun, in terms of what comes out of the gun and when?
Okay. The firing pin hits the primer in the cartridge case. The primer detonates and sends a jet of flame through either one or two holes in the primer into the main body of the cartridge case, igniting the gunpowder. The gunpowder then begins to burn. It doesn't explode, it burns. And it's converted to gas. And then the pressure will be gradually to build up. Now, at the front of the cartridge case, you have the bullet, and that's kind of fixed in. So the pressure then begins to push against the bullet, to push it out of the cartridge case into the barrel, and then to be gripped by the rifling of the barrel. And it takes a while. It has to build up. Now, during this time, some gas will get around the bullet and will actually get in front of it. So now what you have is you have some of this gas in front of the bullet, then you have the bullet, and then you have the bulk of the gas. Now, the barrel of the gun, of course, is filled with air. And as the bullet goes down the barrel, it pushes the gas ahead of it, and it pushes the air. It's kind of like, a hydraulic system. So it pushes it out. So what happens is the first thing you get out of the gun, if you do microflash, you'll see it, you'll get a little cloud of gas, not very big, and then pretty soon after that, you get the bulk of the gas. It looks like a mushroom lying on its side, okay? And in that big gas cloud, there'll be a bullet, and there'll be unburnt or burning grains of powder. So it's gas, bullet, big gas cloud with powder grains, all coming out in that order.
Can the gas that comes out first, that's part of the firing process, combined, the burning material combined with the air that's in the barrel?
Well, it will to a certain degree, but that's mostly the larger cloud of gas. What happens is it's kind of like you have a column of gas and air being pushed straight ahead. So if you hold the gun against, say, like clothing, what happens is this column of gas and air tears a hole through the clothing. And then the bullet gets to the clothing, and then the gas with the soot gets to the clothing as well as the powder. And so that material, if it's in contact, all the thing after the hole is made goes through the hole and comes out the other side.
If I heard you correctly then, if the muzzle of the gun is against clothing, there will be a hole made in the clothing by the gas first.
And the air, right.
And the air, followed by the bullet, and then followed by the soot or the burning powder behind it.
Right. And that's why blanks, people think blank cartridges are dangerous, are not dangerous. You can kill yourself with them. If you take a gun with a blank cartridge and put it against your chest, the gas formed will just tear right through your skin and muscle into your lung. And people, kid around, they'll put it to their head, they're going to die. It goes right in. You don't need the bullet to kill you with contact wounds.
Let's continue, though, with some of your experience and some of your writings. Have you written any articles about head trauma in particular?
Yes, I wrote one peer-reviewed article, and then I've written a chapter in my book on forensic pathology on head injuries.
Head injuries meaning such thing as blunt force trauma to the head?
Right.
I think you mentioned that you also have served as an editor of peer-reviewed scientific journals.
Yes, I'm the editor-in-chief of the American Journal of Forensic Medicine and Pathology.
Does that work include whether or not to accept a submission by a researcher for publication?
Yes, I have the final say. I receive the articles, they go out to reviewers, their reports come back to me, and then I read the reviews and decide whether to publish or not.
Let's talk about work that you may have done specifically for entities outside the Bexar County Medical Examiner. With reference to your expertise in firearms injuries particularly, have you done work for the United States government?
Yes, I think about two years ago, I testified for the U.S. Attorney's Office in some incidents in New Orleans during the Hurricane Katrina, where police officers shot and wounded a number of people and killed one person. And I testified for the U.S. Department of Justice in that case. And I've done like one or two other cases and such.
Have you done any work for the United States Marines?
War crimes, I testified for Marine Corps in the prosecution of individual charged with war crimes.
How about for the British government?
Pardon?
For the British government?
The Bloody Sunday massacre that happened in Belfast years and years ago, and I have another case going in about another 2 months in Britain, having to do with actually concussion, head injury. Yes.
As well, the United Nations?
Yes, Yugoslavia war crimes. Reviewed the reports, the autopsies to determine whether they are valid or not.
And let's talk briefly about some of the jurisdictions in which you've testified as an expert in forensic pathology.
I've testified in most states in the Union, state courts, federal courts. Testified in Canada, Colombia, South America, by video. I was able to testify, by the computer and everything. Let's see, South Africa, Israel.
I don't believe we've touched upon, and that's in the United States, in both state and federal courts?
Yes, sir.
Have you received some professional awards as well?
Yes, sir. From my medical school gave me the Master Teacher Award, and then I got some Outstanding Service Awards from the National Association of Medical Examiners, the Milton Halpern Award from the American Academy of Forensic Sciences, and the Milton Halpern Laureate Award from the National Association of Medical Examiners.
Dr. DeMaio, is your professional background and your peer-reviewed articles, your books, and awards detailed with more specificity in your curriculum vitae?
Yes, they are.
I would like to approach the witness, please.
You may do so.
I'm handing you what's marked as Defendants MM. If you take a look at it, please.
Yes, sir.
Is that your curriculum vitae?
Yes, sir, it is.
Thank you, Your Honor. I would offer then Defendants MM as Defendant's next exhibit.
Any objections?
Approach the bench.
Yes, you may. Exhibit MM will come into evidence as Defense Exhibit 23.
Dr. DeMaio, let's turn to the work that you did specifically in this case.
Yes, sir.
Would you describe the materials that you have received for review in this case, and if you have notes reflecting some of that information that you want to refer to, you're welcome to do that. Copies have been provided to the state, but just feel free to use your notes if you wish.
Yes, sir. The material I reviewed were scene photos taken by the police and the medical examiner investigators, photographs of Mr. Zimmerman by the police and some civilians, the autopsy report, including toxicology and autopsy photos, the medical records of the EMS and a clinic regarding Mr. Zimmerman, a witness statement and a transcribed conversation given by Mr. John Good, 911 calls, a reenactment tape of the incident by Mr. Zimmerman, DNA reports, the firearm examiner reports, and the deposition of Dr. Rowe.
What I'd like to talk with you about in terms of your findings, well, let me ask you first. You did have an opportunity to review the video recording of Mr. Zimmerman, in a sense, reenacting the events immediately surrounding the shooting.
Yes, sir.
And you've had access to some witness statements.
Yes.
Have you, to your knowledge, reviewed all of the witness statements?
No, I haven't, because by the nature of this case, it's more about determining whether the physical evidence is consistent with Mr. Zimmerman's account of what he says happened, because the witness statements tend to be, in most cases, all around, vary greatly. So the easiest way to hear is to evaluate the physical evidence that you have on the body and the clothing and such, and then compare it to the statements of the defendant, in this case Mr. Zimmerman, and see whether they are consistent. If you say that the bullet came in the front and the bullet came in the back, well, obviously they're inconsistent. So that's what you're essentially doing in this case.
And in doing that in this case, would you look at, in addition to what Mr. Zimmerman said happened on the video reenactment, you would look at the forensic evidence, which includes the pictures from the autopsy that might show the gunshot wound? Would that include looking at the report from the firearms expert who analyzed the clothing?
That's correct. The two most important things in this case are the autopsy report, including the photographs of the wound, and the reports by the firearms examiner. And then with a secondary, the scene photographs and such. But what you're looking at mostly is the autopsy and the very detailed and excellent report by the firearms examiner.
So would your analysis include, for example, trying to reach an opinion as to the distance between the end of the barrel and the skin?
Yes, sir.
Would it also include trying to reach an opinion from the end of the barrel to the clothing?
Yes, sir.
Trying to reach an opinion what effect, if any, the clothing may have had in the appearance of the wound on the skin, such
Yep.
things as that.
Yes, sir.
We'll talk about some of those details in a moment, but some of the things that I would also like to talk with you about today is your opinion of how long Trayvon Martin may have been alive, and also how long Trayvon Martin may have been conscious, if those are different opinions.
There are different opinions because you can be alive and unconscious. Right, they're two separate things.
We'll talk about that more. I also want to ask you some questions about the injuries that Mr. Zimmerman sustained that are reflected in the photographs taken by the Sanford Police Department. Did you have access to those photographs and the chance to review them?
Yes, sir, I did.
I'll also want to talk with you a little about the injuries that you observed through photographs or through reviewing the autopsy sustained by Trayvon Martin, in addition to the gunshot wound itself. So generally that's the framework of what I'd like you to talk about today, and let's more specifically talk about the gunshot itself and the mechanics involved in that. I know you've already touched upon the mechanics of what happens when a bullet is fired from a gun, when you talked about the micro photography and that the puff of gas followed by the bullet followed by the rest of the gas is essentially the sequence.
Yes, sir.
So let's talk about the evidence in this case. Would you describe for the jury what you saw when you looked at the photographs of the clothing that Mr. Martin had and the photographs of the wound to his skin and the gunshot or the tattooing that was referenced in the autopsy report? Can you put all that together for us?
Yes, sir. The photographs show a contact discharge of the weapon against the clothing. And this I agree 100% with the firearms examiner, that at the time of discharge, the gun was against the clothing, the gas came out, tore the clothing, there's a defect and there's tears from it, there's deposit of soot all around it. And so what you know is that the muzzle was in contact with the clothing at the time of discharge. And again, this is what the firearms examiner said, and she also did, I believe, some experiments proving that. When you look at the wound in the chest, there's a different picture. The wound in the chest was about 1 inch to the left of the midline, 1/2 inch below the level of the nipples. And what you had was a circular punched out wound, which is an entrance, but it lay in an area of powder tattooing measuring 2 inches by 2 inches. Now, powder tattooing are marks on the skin due to powder grains that come out the muzzle of the gun. They're not powder burns. People use the term powder burns, but it means a whole bunch of different things. This is very specific. When the powder grain comes out of the barrel, and the barrel is close enough to the body, that grain of powder hits the skin and produces a mark and a reaction, a reddish color reaction. And these marks are called powder tattoo marks. Some people call them, use other terms, but the powder tattoo marks. They use the term stippling, but I prefer powder tattoo marks. And this indicates that a grain of powder has hit the skin and the person was alive at the time. You do not get true powder tattoo marks in dead people. And there was a distribution measuring 2 inches by 2 inches and a certain density in these tattoo marks. And this indicated that the gun was not against the skin. It was not a 1/2 inch away. It was more than an inch, and based upon the concentration of the marks and the size of the pattern, it's my opinion that the muzzle of the gun in this case was 2 to 4 inches away from the skin. So the barrel of the gun was against the clothing. The muzzle of the gun was against the clothing, but the clothing itself had to be 2 to 4 inches away from the body at the time Mr. Martin was shot.
Dr. DeMaio, I'm going to show you what's marked as State's Exhibit 96, which is a photograph taken at the medical examiner's office showing the entrance wound. It may take a minute to warm this up, so let me, if I might, approach the witness, and perhaps you could point out what you're saying to the jury.
Yes, sir. May. If you look, what you see is the hole produced by the bullet. And that's essentially a punched out type entrance. And then all around the entrance, you see these all little marks, almost like flea bites or ant bites, not fire ants, but regular ants. Little bite marks all around, and these are powder tattoo marks. And because they're red and reddish brown, that indicates the person was alive. And if you notice, there's a variation in the density, and there's a measurement of about 2 inches by 2 inches, according to the autopsy report. This indicates, again, that he was alive at the time he was shot, and that the muzzle was not in contact, but had to be back. The first time you see powder tattoo marks is when the muzzle is a ½ inch away. Less than ½ inch, you don't see tattoo marks. And then as you begin to move the barrel away, the area of tattooing begins to get bigger and bigger and bigger. And then as it increases in range, your density will decrease. This is a fairly heavy density, so you know it's less than 6 inches and such. And the density decreases until finally the tattoo marks disappear. This is ball powder, most probably flattened ball. It would disappear from bare skin at about 3 feet. But by the size, the density, this is close, somewhere between 2 and 4 inches.
Your opinion as to the distance is based upon your training and research?
Yeah, I've done a lot of research in powder tattooing and whether you can make valid judgments as to range. That is, what firearms examiners will do is they'll use usually heavy white paper, and they'll fire the gun, and they get a hole, and then they get marks around it. And then by the size of the pattern and the density, they'll give an opinion as to the range. Well, this has been used for 75, 80 years to make judgments. But the problem was, does it really reflect what happens on the skin? And I got curious about that, so I decided to make a determination. And I did experiments, and you have to use living animals to do it. And based on the experiments, I found out, yes, it's valid. To determine the size of the pattern by shooting against like white paper is valid out to at least 18 inches. So I got interested in there, and then I did determinations of powder tattooing from handguns and rifles and shotguns, and how far it extends, and how different types of powder make such a determination. This is a ball powder variant, so it actually, there's a lot more grains in a cartridge loaded with with ball powder, so you have a denser pattern. And because of the configuration of the grains of powder, they actually go out further. So, and I know it's ball powder because the firearms examiner states that in her report.
Dr. DeMaio, the exhibit you just published to the jury is now on the screen. The detail may not be as good as on the photograph itself, but that's in evidence the jury can review later. This is what you described as the 2-inch by 2-inch tattooing pattern?
Yes, sir.
Is that what helps you be more precise about the distance than just the 1/2 inch where you said it can't be less than a 1/2 inch, or the beyond 18 inches or several feet where you know the powder would have dropped off?
Right. The thing is that if it's less than 1/2 inch, you would see a hole surrounded by dense soot, and you would not see individual powder tattoo marks. Powder tattoo marks begin at about, in the metric system, 10 millimeters. It's about 1/2 inch. And then begins the pattern gets broader and broader.
How does the pattern get broader as the distance increases?
It's kind of like with a hose when you have that spray coming out, the cone shape, and the farther you get from the end of the hose, the bigger the spray pattern. And so it's like that. And but of course, what happens is just like the hose, after a while, the water droplets just fall off, and you can spray so far. Well, it's the same thing with the powder. After a certain distance, it loses its velocity and just falls away.
Would the clothing, it's not disputed in this case that there was clothing in between the end of the muzzle and the skin. In fact, we have the shirts here in the courtroom if it would assist in your testimony with the jury. But the question is, what effect, if any, would the clothing being in between have on the appearance of the wound itself on the skin?
In this case, none, because the clothing was not between the powder and the skin at the time of discharge, because there was a hole there produced by the gas and the bullet. So don't forget, the powder is behind the bullet. So the gas tears open the cloth, and the bullet makes sure there's a hole there. And then the powder comes through there. So now if you had, the gun will say 6 inches away from the clothing, you'll have just a little hole. The clothing will filter out the powder to a degree. But in this case, clothing didn't filter out the powder because the clothing wasn't there. You had a hole there. And you had the muzzle against the body, and so everything coming out the muzzle was going through the hole.
If the muzzle of the gun had been pressed into Trayvon Martin's chest, even with the clothing in between, what would you see differently than what you see here?
You would see a hole like that, and it would be surrounded by a halo of black soot, and maybe on the skin a grain or two of powder. But you wouldn't see powder tattooing because what the clothing would do is it disperses the soot. It doesn't disperse the powder. The powder would be inside the body.
From a medical examiner standpoint, with your training and experience, literally having written the book, is this a hard call for you?
No. This is basic, 101.
Let's talk for a moment, if we might, about the trajectory of the bullet itself. Having reviewed the medical examiner's report, included the photographs, I take it, that were available of the internal examination?
No, there weren't photographs of the internal examination. There was an X-ray, which is actually better because organs shift around.
Let's talk about the Well, reference the x-ray if you wish. That's in evidence too,
Right.
somewhere in this stack. But also that you know the path of the bullet through the right ventricle and into the lower left lung.
Right. What the autopsy describes
I'm
is-
sorry, the lower right lung. I'm sorry.
What the autopsy describes is a bullet hole in the left chest, as I said, an inch to the left of the midline. It goes through what's called the fifth intercostal space. That is, between your ribs you have spaces. Fifth intercostal space is the space between your fifth rib and your sixth rib. So it went through there, and then it hit the sac surrounding the heart, went through the right ventricle of the heart, in and out, and then it went into the right lung. And when you look at the x-ray, you can see the lead core of the bullet in sort of the center, and then you see the jacket fragments on the right side of the chest. So the bullet really went from the deceased's front to his back and from his left to his right, because it went into the right lung. And it started out on the left side.
Meaning there must have been, based upon your review of the description of the autopsy, must have been at least a slight left to right trajectory.
Yes, there's some. I can't really quantitate it, but there's some. It doesn't appear radical, but that the bullet was going from Mr. Martin's left to his right.
I wanted to point that out, that left to right, meaning from Mr. Martin's left toward Mr. Martin's right.
So that's correct. There's a standard way of describing wounds. And when you describe wounds and when you talk left to right, up and down, you're talking from the deceased's viewpoint, not from you looking at him. So whenever I would say like front to back, it means Mr. Martin's front to his back, his left to his right.
In other words, it was not precisely a straight-on shot.
No, it does not appear so.
Let's talk for a moment about the mechanics of that shot, putting together the defect on the clothing. That's a result of contact with the muzzle. That you believe that the distance between the clothing and the skin was somewhere between 2 and 4 inches, not a contact. Your understanding of Mr. Zimmerman's statement because of the video reenactment. Your work, essentially, your task was to determine whether the medical evidence was consistent with what Mr. Zimmerman said happened. Is that a good
That's
summary?
correct, sir.
Okay. Let's talk about that for a moment. First of all, were you aware that Mr. Zimmerman said that Trayvon Martin was straddling him?
Yes, sir.
And leaning over him?
Yes, sir.
And that Mr. Zimmerman had the gun in his right hand?
Yes, sir.
And if you would describe then what you know about that sequence of events compared with the medical, forensic, and gunshot evidence.
The medical evidence, the gunshot wound, the tattooing, is consistent with his opinion, with his statement as to that. And the reason it is don't forget, the simplest thing is the gun was in his right hand. So if you're going to shoot somebody and you're right-handed and you're really close to them, there's the natural inclination with the twist, the hand, that the bullet will tend to go from the deceased's left to his right, okay? But that's a minor point. The most important point is the nature of the defect in the clothing and the powder tattooing. That is, if you lean over somebody, you will notice that the clothing tends to fall away from the chest. If instead you're lying on your back and somebody shoots you, the clothing is going to be against your chest. So that the fact that we know the clothing was 2 to 4 inches away is consistent with somebody leaning over the person doing the shooting, and that the clothing is 2 to 4 inches away from the person firing.
You may consider, in your opinion as well, that the clothing was wet. Mr. Martin's shirt was described as being damp, that it had been raining that night, and that when it was photographed at the medical examiner's office the next day, it was obviously wet in places. You may also consider that the responding officers found an unopened can of a beverage in the front pouch of Mr. Martin's hooded sweatshirt. This is in evidence as Exhibit 148, an unopened 23-ounce can of a fruit beverage.
Yes, sir.
Do you find those facts consistent with what you saw, as well as consistent with what Mr. Zimmerman said happened?
This would tend to reinforce, because the reason that the clothing, as you bend forward, the clothing falls away from the body is gravity. Now, if you have wet clothing, clothing's heavier, and there's going to be a greater tendency to fall. And if you have something in the front pulling the shirt down as you lean over, again, it tends to pull away from the body. So the wound itself, by the gap, by the powder tattooing, in the face of contact of the clothing, indicates that this is consistent with Mr. Zimmerman's account that Mr. Martin was over him, leaning forward at the time he was shot.
Let's shift gears for a moment and talk about Trayvon Martin's, the mechanics of the effect on Trayvon Martin receiving that shot, in terms of how long you believe he would have survived and how long within that time you believe he may have been conscious, and further, what, if anything, he could do voluntarily during the time he was conscious, whether he could talk or move or be physically active. Do you follow me?
Yes, there are three questions that you've brought up. Number one is the ability to move. That is determined by the amount of oxygen in your brain, for which you have a reserve of 10 to 15 seconds. So even if I, right now, reached across, put my hand through your chest, grabbed your heart, and ripped it out, you could stand there and talk to me for 10 to 15 seconds, or walk over to me, because the thing that's controlling your movement and ability to speak is the brain. And that has a reserve supply of 10 to 15 seconds. Now, that's minimum. That assumes no blood is going to the brain. If you get some more blood going to the brain, that could be longer, okay? It's going to depend on blood pressure and how severe your wound. The other thing is, and I know the answer is kind of getting complicated, not being simple, is that some people get shot and immediately collapse. Some people get shot, don't even know they've been shot, so they can function. So what I'm saying is minimum is 10 to 15 seconds. That's a given, okay? Now, how long can your heart beat? Because I'm using for time of death cardiac, not brain. That's not relevant here. Okay, cardiac. In this case, you have a through and through hole of the right ventricle, and then you have at least one hole, if not two, into the right lung. So you're losing blood. And every time the heart contracts, it pumps blood out the two holes in the ventricle and at least one hole in the lung. So you're losing blood. If you engage in a struggle, which is what was supposed to have happened, your heart rate increases. Mr. Martin was a healthy young man. If he's involved in a struggle, you expect his heart to be beating, especially after he gets shot, more than 100 times a minute. You know, healthy people, 120 in a struggle, it's no big deal. Now, remember, every time the heart beats, out comes the blood. Now, if he loses, say he's only beating 100, which is relatively slow. If he loses 15, if he loses, okay, we got the three things. Say he loses a tablespoon of blood every time the heart beats, which is, well, you got two big holes in the heart. So if you lose that tablespoon, that's not that much blood. That's 15 cc's. The heart's beating 100. You're losing 1,500 cc's in a minute. That's about a quarter of his blood supply. And a second minute, if you consume the same rate, actually the heart would probably be beating faster for the second minute. He's going to lose another 1,500. Well, that means he's lost more than 50% of his blood supply very suddenly. It's not just the loss of blood. At that point, he's not pumping any sufficient blood to the heart, to the brain, or anywhere else, and he's reached the point where he's going to die. So, assuming these conditions, in all probability, nothing's 100%, he's going to be dead within 1 to 3 minutes after being shot, in this case. Now, all I'm talking about is heart effectively pumping blood. Now, you can still get some electrical activity, but you're not pumping. And this is in all probability. So, how long was he conscious? Significantly shorter than the time necessary to die, because you wouldn't have sufficient oxygen getting to the brain. I can't tell you exactly how long he could be conscious. I can tell you the minimum, 10 to 15, unless psychologically he just blacks out. So that's the best you can give in estimates.
Dr. DeMaio, in your training and experience and research, are you familiar with incidents where individuals received a similar or even more serious injury than you see that Trayvon Martin sustained and could still talk, move, do voluntary actions for that 10 to 15 seconds?
Oh, yes. Best case I have, speaking like a forensic pathologist, is an individual shot in the chest with a 12-gauge shotgun at point-blank range. His heart was completely shredded. He turned around and then ran around 65, 75 feet before he collapsed.
Does the fact of being shot in the heart itself mean anything other than it has an accelerated loss of blood and that it will quickly deplete the oxygen to the brain because of the loss of circulating blood?
No, nothing else than that.
It doesn't cause the same kind of physical response as being shot in the head, for example.
Right. It's that some of the SWAT teams, if they want to immobilize somebody immediately, what you have to do is you have to shoot them in the head. They know it.
from what I understand you to say, then, for at least 10 to 15 seconds after Mr. Martin sustained the shot, he would have been capable of talking and of voluntary movement.
He could, right. Some people just lose consciousness immediately. It's psychological, it's not physical. But he has the potential for 10 to 15 seconds minimum, right.
Which could include then moving his arms from an outstretched position to underneath his body.
Sustained.
Could that include moving his arms from an outreached position to underneath his body during that 10 to 15 seconds?
Yes.
At the time that one loses consciousness, I take it they then lose the ability for voluntary movement?
Oh, yeah. Once you're unconscious, you don't have voluntary movement.
And you would not be feeling pain?
That's correct, sir.
Let's talk for a moment about the injury to Trayvon Martin's knuckle. You remember there being in the photographs and a discussion in the autopsy an abrasion on the left hand fourth finger?
Right, 1/4 by 1/8 of an inch abrasion, straight.
Do you agree with Dr. Bao that that's an abrasion type injury?
It appears to be.
Is that consistent with having come in contact with a hard surface or impacting some other surface?
It's consistent with impacting a hard surface.
Would concrete qualify?
Concrete could qualify, yes, sir.
In your training and experience under circumstances like this, would you expect to see bruising on the knuckles if there had been punching going on?
You can see bruising or you cannot see bruising. It depends what part of the body you punch. You know, the softer the portion, you may not see it. And then in a case like this, you can have bruising, but it may not be visible unless you cut open the hand, you know, the skin, and peel it back. So there may have been bruising there that we don't know about, or there may not have been bruising, but it doesn't make that much difference. You can punch someone and not get bruises, and punch someone and get bruises. It's just too variable.
Does it take blood pressure in order to get bruising?
Yes. Once your blood pressure goes, then you don't have bruising. That's why they say you can't bruise a dead body. No blood pressure. The bruising occurs when the blood pressure forces the blood out of the torn blood vessels into the soft tissue.
And in this instance, Mr. Martin lost blood pressure very quickly.
Yes, sir.
So had Dr. Bao been looking for bruising, especially in the areas of the knuckles, the better course or the better practice would have been to take a look internally.
Right, to cut. The funeral director repairs it without any problem.
As far as you know, that was not done in this case.
That's correct, sir.
Let's then move, if we might, to the injuries that George Zimmerman sustained.
Yes, sir.
You've been provided photographs that were taken at the scene of his bloody nose. Is that right?
Yes, sir.
And a photograph that was taken of the back of his head showing some streaming blood.
Yes, sir.
And were you also provided with copies of the photographs that were taken later that night, some 4.5 hours later, by the Sanford Police Department.
Yes.
Let's talk then a little about head trauma. Let's talk about the mechanisms or the mechanics of blunt force injury to the head.
Yes, sir.
What happens when somebody's hit in the head, either by a fist or has their head impacted against a hard surface like concrete?
Well, okay. What'll happen is the brain, the head will move. The heads will say, the head's fixed, and then all of a sudden it's made to move, or it's moving, hits, and stops suddenly. It works the same way. The brain will shift. The brain is kind of like gelatin. And it will move back and forth inside the cranial cavity. And as it moves back and forth, there's three possibilities. One, you get bruising by impacting the bone inside. The brain can come back and hit the bone so hard you get bruising. Or, a variant of it, you get bleeding. You can get what's called subarachnoid hemorrhage or subdural hemorrhage. So you can get intracranial hemorrhage. And if the intracranial hemorrhage is sufficient enough, it can kill you. The other type of injury you can get to the brain is axonal injury. The brain is a mass of brain cells, and they're all connected together, and the connection in part is through fibers called axons that run from one cell to another cell, and it passes down certain chemicals which activate the cells. Now the axons, as I said, are elongated, run from cell to cell. When the brain moves, of course, back and forth due to impacts, the axons will be stretched to a certain degree. Within limited motion, the way we are walking around and such, or even bumping your head, it's no big deal because the axons can take that. If the movement is very violent, it stretches the axons. And this causes injury to the wall. If the movement, which is more violent, is relatively mild, the injury is repaired by the axon, and there's no problem. And then there's a gradual increase in force until you get something like an automobile accident where, you know, you run into something and your head goes forward and hits the panel. Say. That force is so great that it will injure these axons and they will not be able to be repaired, and they die. Now, luckily, you have a lot of brain cells and a lot of connections. So you can lose a good number of brain cells and still be all right. But at some point, you will have impairment, and at some point, you're going to die. So impacts of the head with its hard surface like concrete, we'll say, what you worry about is the intracranial bleeding and some axonal injury. More likely the intracranial bleeding than axonal injury, to be honest. And so it's always dangerous. The thing is, it's like if you hit your head here on the floor, it's carpet that absorbs. Concrete doesn't yield. When your head hits concrete, your head yields, not the concrete. So it's dangerous. Could you kill somebody? Sure, if you bang them hard enough. But if you don't, but even if you don't do enough to injure the brain significantly, you're going to have some stunning effect. That's what concussion, you know, these football players who get the concussion. What it is it's axonal injury. And, you know, some can take it, some can't. Sometimes there's sequelae down the line. But you can get very mild concussion, just bang your, not just banging your head on a cabinet, that doesn't do it. But I mean, you know, you fall and you hit your head, and you can get a mild concussion. You don't lose consciousness, you just appear stunned. I know this is not a medical term, but it's like stunning goes to concussion, goes to getting worse. I think the best thing is stunned, where you may not have any significant physical injury to the brain, but you are stunned just from the impact. Stunning is a good term. It's better than concussion.
You're suggesting it's a progression depending on how hard the impact is and perhaps how susceptible the person is to it?
Yes, and how many times, you know, it is, and how much force is used. But at least you're gonna, if you get, your head hits something unyielding on concrete with sufficient force to tear the scalp, you are going to be, at a minimum, stunned. And then it could be much worse than that. But you're going to be stunned. Because the thing is, we all hit our heads all the time, and how often do you get a scalp laceration? It's not that common. Even in people who have their hair cropped, or, like a lot of people in this courtroom, are bald. You know, that removes a little of the cushion. But, you know, the thing is when you have lacerations, you know, there's some trauma.
Dr. DeMaio, you were talking specifically about lacerations to the scalp. I know that you've received the photographs and reviewed the evidence that George Zimmerman had 2 lacerations to the back of his head. If I might have the lights for a moment, Your Honor, I'd like to show State's Exhibit 76. This has been identified as the photograph. Is there maybe another button to push?
The clerk is doing that. Cycle down for a moment.
I'll hold it up for you in the meantime. This has been identified as State's 76, the very first photo taken of George Zimmerman that night by Jonathan Manalo. You've seen this before?
Yes, sir.
Does this evidence some bleeding to the back of the head?
Yes, so there's 2 sites of bleeding, you can say.
Two wound sites, if you will.
Where you're bleeding, right. A laceration, it's a tear in the skin.
I'll stick that here on the projector, just as a frame of reference. Okay, that's the first picture. And then you later saw pictures where some of the blood had been wiped away.
Right.
Let's take a look for a moment at 74. And how well that can be seen, maybe not so great. What do you see in this picture in terms of evidence of injury?
It looks like you've got a bruise on the left side. It's not really a very good photograph.
Let me see if I can find one that may be a little bit better. These are all in evidence, so the jury can review them at their leisure, but they aren't in sequential order, so I'm struggling here a bit. Let me see if I can find it easily. If not, we will move on. No, I think we're stuck with this one for the moment. Do you see in this photograph what looks like 2 separate areas of swelling?
Yes, if you look in between, you can see There's an injury at, let's see, if you look at the head, say at,
I have a pointer if that would help.
yes.
It's the top button. Look at where. That's a better picture.
There's an injury here and here, which are probably represent the lacerations, since it looks like clotted blood. But if you look right in between, there's kind of a valley. And the reason is that this impact site is swollen. And then this is swollen here. So this is not swollen. So you know that there are two separate impacts. One impact here, producing two separate lacerations with an area in between that is not swollen. And the swollen is due to you know, just a bleeding under the scalp. That's what it is.
The knot or the lump that people get after hitting their head on something hard is blood as opposed to some other fluid?
It's blood, right. It's
Talk for a moment, if
the
you
medical
would.
term is hematoma, but knot is, I guess, non-medical acceptable.
Talk for a moment, Dr. DeMaio, if you would, about the curvature of the head and why you're confident that's two separate impacts as opposed to one impact that could have caused all of the injuries that you see?
Oh, well, okay, it's real simple. You've got an unyielding surface, so when the circular area hits it, it's going to flatten at the point of contact. And it's not going to flatten 3 inches on the other side. You have to move it over. And on top of that, you can see if it was one impact, it would be swollen between the two. But here you've got 2 areas of swelling, so they're separate.
You commented earlier that it's not that easy to get a laceration from impacting on a flat, solid object.
Yeah, because it takes sufficient force. I mean, everyone bangs their head and has fallen and hit their head. You don't get lacerations, you know.
What's the mechanism by which the laceration occurs, where the skin is split in some way?
There's 2 ways that you can get a laceration. One is if it's a direct perpendicular impact, you just crush the skin. And as you crush it, you push it away from the point of impact, and you get a tear. The other is if you hit it at an angle such that you bang it and slide, the surface holds one edge, and the rest of the moving head pulls against that, and so you tear. A laceration is nothing but a tear.
Here's the picture I was looking for. Let me substitute this. This is Exhibit 57, and see if there's anything else here that more clearly shows what you were talking about.
Yeah, again, when I was, you can see that there's a swelling here, and there's like a little valley here, and it's swollen here, and then it's swollen here, and there's a laceration here, and this is a blood clot over a laceration. One of the lacerations is almost an inch, and the other one is like 1/5 of an inch. But the wounds aren't cleaned up when they took the photograph, so you can't say which is which.
Is the laceration itself a significant injury?
In this case, well, just that it's a marker of force. In theory, if you get a real bad laceration, rarely, I've seen it maybe twice, people have actually bled to death from lacerations of the scalp, but not like this type of laceration.
When you say it's a marker of force, are you saying that it represents something other than just the actual injury itself?
Right, it indicates that you've had severe force because you've it's not like you just bump your head or something like that.
Would it be possible to have your head struck on something hard enough to ring the bell or stun you that wouldn't actually leave a mark visible some hours later on the outside of the scalp?
Oh, sure. You see that a lot in abused children, where there's not a mark on their head, and then you get inside, they've even got skull fractures. So you can get severe trauma to the head without external injury, actually. That's why they're always doing CT scans, when you have head trauma.
So the presence of the injury on the outside, are you saying doesn't necessarily mean there wasn't additional impact, or that the impact itself was minor?
Okay. What I'm saying is that you can get severe head trauma, but actually without any marks on the head. Or you can get marks, lacerations and contusions, and have head trauma. They're not necessarily, more commonly when you get severe head trauma, you have some injury to the scalp. But you can get severe head trauma without a mark on the scalp, too.
Sort of gauging the amount of force necessary to cause those injuries alone, would that be enough force, in your opinion, to cause this stunning effect that you talked about?
Oh, yes. Anyone who's ever had a real bang on the head knows you don't have to have a laceration or a big bruise to be, it's a transient type of thing, maybe 5-10 seconds, you're kind of stunned. That's a good term to use. Medically, the doctors would refer to it as an ultra mild concussion. But stunning would be a better thing, because people experience that, when they hit their heads, and they understand it, and it's not really of that much significance neurologically.
If you sustained a stunning blow like this, and then you continued to receive additional blows to the head, would the additional blows continue to cause this stunning effect?
Oh, yeah. Yeah.
So it may compound in a way?
Yes. It's actually, if you get a concussion, even if it's mild, and then you, within a short period of time, get multiple other concussions, people have died. That's the, Friday night football, where they get it 1 week, and then they get another one the next week, and they'll collapse and die. It's a recognized syndrome.
So in other words, these impacts could be cumulative just that night into multiple stunning effects, ultimately leading to a concussion?
Oh, yeah. Well, they probably, by stunning, I'm using the term stunning, and I know any physicians listening to me are cringing, because essentially it's what it is. It's a very mild concussion. But stunning is kind of more, it's not an incapacitating thing. You're not knocked out. Is anyone who's ever fallen and hit their head hard knows what I'm talking about, the stunning effect. But it's, you hit your head hard, you understand what it means.
There has been some discussion in the testimony about punctate abrasions.
Yes,
Let
sir.
me show you Exhibit 66. Are there punctate abrasions evident in this photo?
They're right here. It's kind of washed out with the photograph. But you can see, little reddish markings, and that indicates that there was impact with a surface, a flat surface, that was not really smooth, like this wood here. If you hit your head on this wood here, you would not get punctate. You'd have to get something with a little non-flat surface, little edge to it.
Would concrete of the nature that's used in your everyday sidewalk have that kind of surface?
Yes, sir.
Is this injury consistent with Mr. Zimmerman's head having impacted a sidewalk?
Yes, sir.
There is some We were just checking to see if you care for some water. If you do,
Oh,
just...
no.
The punctate abrasion is that sort of granular-looking red stuff around the temple?
Right, it's not smooth.
Mm-hmm.
It's an area red here, and then a little here, and 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 a little here, that sort of thing.
There appears to be a noticeable lump or knot a little higher up.
Right, over here.
Does that appear to be a consequence of the impact?
Right.
What would you? How would you describe that?
A knot? No, hematoma. It's bleeding underneath the scalp.
Mm-hmm. Do you think it's likely associated with the impact that caused the punctate abrasions?
Yes, sir.
Could that then be those injuries caused by one or more impacts with the sidewalk?
Yes, sir.
Let me show you State's Exhibit 70, a view of the right side of Mr. Zimmerman's head, I believe. Do you see anything here that would suggest impact with a fist or the sidewalk?
You can start to see this was that punctate, and there's a little lesion over there. It's not a good photograph, unfortunately, so. But again, it's consistent with some impact of some sort.
This is another photo of the same side. This is in evidence as 71. Slightly different angle.
You can see it. Here's the injury. It goes here. You can see the reddish areas.
Let's take a look at the other side of the head on the left side in Exhibit 73. If I might take a moment, Your Honor, and approach the witness so the witness can see the actual photograph.
Oh, I can see.
Okay.
There's no problem.
What do you see in this photograph, Dr. DeMaio, that's consistent with blunt force trauma?
Again, you see, this is a washed out photograph, but there's an area, there are marks right over here too. I would assume a print photograph would show it better, but there's some punctate marks over here.
May I approach the witness just briefly, and then I'll return.
Yes, you may.
Just to show you this photograph itself. Exhibit 73.
If you see better in this what was on the projector, could you point that out to the jury?
Yes, if you look right here, you can see an arc of punctate abrasions, and then kind of a palette area, and then another arc right over here.
Do you see signs or evidence of a hematoma, bruising of some sort?
There's suggestion, but it's not as distinct as on the other side.
Thank you. Let me approach one more time. I'd like to direct your attention, though, Doctor, to this area above the ear.
That's the area I'm saying that it looks like it's swollen in that area. But it's hard to say definitely.
I see. That's consistent with swelling as a result of blunt force trauma?
Yes, sir.
That area is this general area here?
Right.
Dr. DeMaio, you have seen Exhibit 79, the first photograph taken at the scene of Mr. Zimmerman's face.
Yes, sir.
And what signs of trauma do you see in this picture?
Well, you have to look at the original, but if you do, this appears bruised. But if you look at the outline of the nose here, and it shows up, and there's swelling here, a little abrasion there.
Is this a better picture?
Yes.
Maybe I could approach the witness, Your Honor.
You may.
Thank you.
Okay. If you look at this, you can see there's congestion in the nose and there's an abrasion. But notice how the outline here is a smooth outline. Here, it bulges out and then comes back. And if you then compare it to another photograph, you see that this is consistent with a possible displaced fracture, because of the next photo taken of him in police custody, the swell, which is only a few hours later, this swelling is not as prominent. And that's why I believe the EMS thought he had a fractured nose. And you can see there's a swelling right here. It's very prominent. It's just below the area where he's got a small abrasion.
Is the injury you see in this exhibit consistent, this exhibit 79, consistent with having been punched in the nose?
Yes, sir.
This is exhibit 48. We'll put it on the projector and see if you can find the detail. This is represented as the photograph taken several hours later at the police department of Mr. Zimmerman's face.
Right.
Can you point out to the jury what you were referring to?
If you look now at him, notice that swelling appears to be gone. Well, if you get, it can't be gone if it's just blood. So this is strongly suggestive of the fact that what he had was a kind of a displaced fracture here, and that when he was maybe examined by the EMS or something, they just pushed it back in, either consciously or unconsciously. And so now it's just in place, and it's just being held there by the muscle.
Either way, whether or not the fracture was displaced or not, or even fractured, does the trauma that you see in that photograph and this photograph consistent with having been struck hard in the face?
Right. And so it's there. And then, of course, there's another blow here.
I will show you 72, taken that same evening, to see if that illustrates some of the other injuries you observed. Is that the part of the forehead you were talking about?
Right. It's again another one of these washed out photographs, but let me see. You can vaguely see there's like a line here, and then there's another, and when you look at the prints, they're reddish markings. You can see this is linear right here, see? A line. And then, this is a crease in the forehead. I'm talking about this coming down. And then right over here. And those are, if you look at a better photograph, there are reddish areas. It's not consistent with concrete. It's consistent with something more like a punch than concrete. So this would, because what you've got is, if you look at it, the skin is intact. The injury is underneath the skin. This reddish mark.
Something that doesn't wash off.
Yeah, oh no, this doesn't wash off because it's on multiple photographs. But I mean, it's not blood, but I mean, it's underneath the skin. But it's not from something like concrete or anything like that.
Would it likely be a different impact than the one that caused the injury to the nose itself?
Yes, it's too far down, and it's not the same thing.
In the photograph, if you look more to the right, I'll put the pen on it for a second as you describe the photos being washed out. Do you see some evidence there of some mark of some sort?
Right, this is it. There's a mark like this, and then there's a mark here. I have a photograph of myself, which is not entered into evidence, so
It's the same picture, is it not?
it's the same picture, but it's kind of, this thing's washed out. So you should have a picture in evidence.
Yes, that's Exhibit 72. I'm showing it to you here now. This is the picture in evidence. So there's a separate red mark on the forehead that you're pointing out now that may suggest additional impact?
No, I think this and this are the same impact. I think you have 6 identifiable injuries. The 2 lacerations on the back of the head, the impacts in both temple regions, that's 4. The nose is 5, and the forehead is 6. And there may be others, but the photographs are not of the quality that you can say.
May there also have been impacts that, for one reason or another, may have landed but didn't actually manifest itself in a visible injury.
Right.
Speculation.
Sustained.
In a fight situation where someone may be resisting the attack by someone else, would you expect them, for example, as they're being pushed toward the concrete, to resist by their muscles or their back trying to sit up, for example?
I would assume so.
So, consistent with what you see here, is it possible there may have been other impacts, but they weren't so pronounced because there was some ability to actually resist the full force of the impact?
Objection, speculation.
Overruled.
Yes, I told you that, also in addition, the head wasn't cleaned of blood in some of the photographs. All I can say is there's definite evidence of 6 impacts. That does not mean that there were only 6, but the 6 I can say.
You have just a moment. Thank you, Your Honor. Tender the witness.
Yes, you may. Ladies and gentlemen, we're going to recess for lunch. During the lunch hour, you're not to discuss the case amongst yourselves or with anybody else. You're not to read or listen to any radio, television, or newspaper reports about the case. You're not to use any kind of an electronic device to do independent research about the case, people, places, things, or terminology. And you're not to read or create any emails, text messages, Twitters, tweets, blogs, or social networking pages about the case. Do I have your assurances that you will abide by these instructions? Thank you, and if you'll put your notepads face down and follow Deputy Jarvis, we'll be in recess till 1:30. DeMaio, you're free to take your lunch break and be back at 1:30, but you cannot discuss your testimony with anybody, including the lawyers.
Thank you.
Okay, thank you very much. Court will be in recess until 1:30.
Thank you, Dr. DeMaio.
I don't think he'll have time to get to the courthouse, and he doesn't have a car.
Then fine.
Thank you.
Please be seated. Back on the record. Is Dr. DeMaio outside? Okay, are we ready to have the jury come back in?
We are, Your Honor.
All right, let's go ahead and have the jury come in. Yes. Welcome back, ladies and gentlemen, and while you're getting settled in, I'll go ahead with my questions. If your answer is yes to any of them, please raise your hand. During the lunch recess, did any of you have any discussions amongst yourselves or with anybody else about the case? No hands are being raised. Did any of you read or listen to any radio, television, or newspaper reports about the case? No hands are being raised. Did any of you use any type of an electronic device to get on the internet to do any independent research about the case, people, places, things, or terminology? No. Thank you. No hands are being raised. And finally, did any of you read or create any emails, text messages, tweets, social networking pages, or blogs about the case? No hands are being raised. Thank you very much. Mr. De La Rionda, you may inquire.
Please support. Good afternoon, Doctor.
Good afternoon.
You've got a loud voice like I do, so hopefully we'll be able to hear each other.
Okay.
We also share another thing in common. Now, Doctor, you're not testifying here as to who started what led up to the death of Trayvon Martin.
That's correct, sir.
And you're not saying as to who attacked who, whether it was George Zimmerman who attacked Trayvon Martin, or whether it was Trayvon Martin who attacked George Zimmerman. You can't say it to that, correct?
That's correct, sir.
In fact, you can't testify as to who threw the first punch.
That's correct, sir.
In fact, you can't really testify whether there was a first punch thrown.
That's correct, sir.
And you can't say whether it was Trayvon Martin defending himself or George Zimmerman defending himself in terms of when this first started.
When it first started, that's correct, sir.
Your really testimony is only focusing on at the time of the actual shot, correct? Would that be accurate?
That's correct, sir.
Okay. And you're not stating here, are you, that everything George Zimmerman stated at the statement you saw, the reenactment, is the complete gospel truth?
That's correct, sir. I'm just stating the nature of the gunshot wound being consistent with his account of how he shot.
Right. But were you aware, sir, that the defendant had given 1, 2, 3, I believe at least 4, maybe 5 statements prior to that one?
I believe you had mentioned that to me, sir.
I think I mentioned that in your deposition, right?
Yes, sir.
Now, is there a reason why you only focused on the reenactment as opposed to the original statement that he gave?
Well, because I know what the reenactment said, and essentially he's holding to that account. And so what I'm saying is that what I did was I evaluated the objective evidence in regards to this account that's being presented here. Okay.
I apologize. I interrupted you. Were you finished?
No, that's fine.
Thank you. Let me know if I ever interrupt you. I apologize. And I also told the court reporter that I would be slow, and so if you can do the same thing, she needs to get everything down. When we're talking to each other, make sure we don't talk over each other.
Yes, sir.
Am I correct in stating that you've always believed that the first statement is the most accurate statement?
The first statement is usually more accurate than when given weeks or months later.
Oh, okay.
Because you get that in depositions, you know.
I got you. Now, you mentioned your prior experience with the medical examiners. You were head of the medical examiners office in that beautiful city, San Antonio.
That's correct, sir.
That, in fact, when you go to the Alamo and right near there, you can go down and go actually to the water. You go down to what, about, I don't know how far you go down, but you go down somewhat.
It's about 2 levels down. You're on the Riverwalk, right?
Okay, all right. Now, you mentioned that when you worked there for, what, 15, 20 years, I think?
25 years and 10 months.
Okay, didn't mean to cut it short. You mentioned you, as a medical examiner, it was important for you, was it not, to, before you render an opinion, to make sure you understood all the facts, correct?
Depends upon the case. You know, in some cases you want more information. Some cases it's not necessary. It just depends on, everything's personal.
Right. But I guess what I'm saying is when police would bring you a case, the medical examiner, and obviously they bring you the body,
Right.
and you start doing the autopsy, you'd want to know what all the witnesses said. You wouldn't just pick one witness and say, okay, what did you say? You would want to know what everybody else said to make sure it was consistent with the evidence that you saw, correct?
In most cases, yes, sir.
Okay. Now, in this particular case, you just focused on the defendant's statement, and I believe you said Mr. Good's statement, correct?
I focused on the defendant's statement because that's, as you pointed out earlier in your cross-examination, that's all that I'm concentrating on. Whether it's, so I went to see is if his statement was consistent with what I found, or what was found as the gunshot wounds. The rest, I can't say.
Right, because you weren't provided with all the other statements of all the other witnesses, correct?
But again, I couldn't say I would have to disregard them in regards to the gunshot wound.
Okay.
Because the only one present there is Mr. Zimmerman. So you have to go by what he's saying.
Well, I respectfully beg to differ with you. There was another person there, wasn't there?
Well, there were a couple other witnesses, yes, sir.
No, I mean respectfully, the other person there is not among us anymore.
Right. That's because he's the only one who communicates. That's correct.
He can't speak because he's dead.
Yeah.
Okay. Were you aware, by the way, that the deceased, the victim in this case, Trayvon Martin, was on the phone with a lady?
Yes, sir.
You didn't review her statement, did you?
No, sir.
But when you worked with the medical examiner's office as the chief medical examiner, you, in most cases, attempted to find out all the information before you came to an opinion.
It depends on what the case is about. Often the information from the witnesses, it goes more towards the manner of death rather than the cause of death. And in this case, there's no question what the manner of death is.
Okay. And so are you suggesting that then all the witnesses' testimony should just be disregarded?
For my purpose, not for the jury, but for my purposes, it's not important in my giving my opinion.
In terms of your limited opinion as to the gunshot wound itself, in terms of how it possibly could have occurred?
Right.
Is that correct?
Right. The other statements are for the jury to evaluate, not for me.
Okay. So you're not saying that we should just disregard what led up to this, whether somebody was following or whether somebody was attacking somebody. You're not saying that should be disregarded.
That's not right. That's not what I'm doing. The rest of that is the jury. That's why they're sitting there.
Okay.
Right.
I didn't mean to imply that you were saying that. I just wanted to make sure the record was clear about that.
No, that's no problem.
Okay. And Mr. West asked you a few what we refer to as hypotheticals. What if, assuming this fact, and in order to give an opinion, when somebody gives you a hypothetical, it has to be based on facts that are accurate and truthful, correct?
No, a hypothetical doesn't have to be true.
Oh, okay.
A hypothetical is just, suppose this and this happened.
Okay, so we would be speculating, I guess, or potentially speculating.
Well, it's not even speculating. You're just giving a presentation and you're asking what it is, so it doesn't even get to the speculating.
Okay. And you would agree that at least the one statement that you relied on, which I think was either the fourth or fifth statement that Mr. Zimmerman had given, the reenactment, that Mr. Zimmerman has a self-interest, correct, when he's talking to the police?
Yes, sir.
And one could even argue that he has a bias in not telling the truth.
One could argue that. I think that's your argument.
Yes, sir. And you would also agree that if his statement doesn't match the evidence, then it's not the truth, correct?
That's correct, sir.
And I guess in what you reviewed, you were aware, were you not, that the only person that was armed out there was George Zimmerman and not Trayvon Martin?
Yes, sir.
Okay. Were you aware that he wasn't just armed with a firearm, but that he was also armed with a flashlight?
Yes, sir. Actually, there's a photograph of the flashlight in the scene photos.
May I bring the person witness, John? You have the big flashlight. This right here?
Yes, sir.
Did this do some damage to somebody?
It's,
Sorry,
yeah.
I apologize. May I approach the witness, Your Honor?
You may.
Well, it's not a good, I thought it was one of these all steel heavy things. I wouldn't consider it a really dangerous weapon.
You think it's all right to hit somebody like that real hard and it wouldn't cause any bruising?
I think it might cause a bruise, but it's just not heavy enough to,
Okay.
to be of significance.
So you were not provided with a statement of Jane Serdica, who described George Zimmerman on top of Trayvon Martin before the shooting?
I was not provided with that statement. That's correct, sir.
You were not provided with a statement of Celine Bahadur, were you?
No, sir.
And you mentioned you were provided with a statement of John Good. I think you stated originally an audio recorded statement and a written statement he gave, correct?
Yes, sir.
Were you aware that he gave also an additional sworn statement in which he described not hearing this at all?
No, sir. I don't think so.
Were you aware that he also stated under oath that he did not hear anything hitting concrete at all?
No, sir.
I'm trying to do this chronologically, but I want to go back. I don't want to. I want to go back a little bit about your CV and your qualifications that Mr. West talked about in terms of where you've been and that kind of stuff. You mentioned that I was curious, you mentioned something about shooting animals. Now, are we saying that this experiment was done while the animals were alive?
Following federal regulations, yes. What you have to do is the animals have to be kept in a federally approved area, and then a veterinarian has to be present at the time of the experiments, and the animals have to be anesthetized.
Okay, and so then you,
It's
what,
complicated.
just started shooting at them, or how many times were they shot?
I'd have to read the paper originally, but you know, it was a test to determine whether the testing method used by firearms examiners was valid.
And you determined that it was, correct?
Yes, sir, it was.
Okay. You also mentioned that you've testified all over the world, really, I guess, or part of the world.
A couple of places, yes.
Okay. And you testified in criminal matters, both for the government or the state and also for the defense, correct?
Yes, sir.
And in fact, you were asked about several cases that you had testified on behalf of. I think you testified in the, and you were nice enough to send me and Mr. West your list of your cases, at least within the last 5 years since you've been in private practice, or is it 7 years?
It's 6 going on 7 now.
Okay. And I think you said, what, over 50 times or so, or do you recall the number?
No, I don't think I said a number, how many times I've testified. But again, as I pointed out, most of them are civil cases.
Right, and I think one of them you mentioned was the Drew Peterson case, right?
That was a criminal case, yeah.
Yeah. And then also the Specter case, too, I think, right?
Yes, sir.
And in both of those cases, you testified for the defense, right?
Yes, sir.
By the way, how much are you getting paid to come testify here today?
Same thing I charge everybody, $400 an hour.
And how much total have you charged so far? I know you got to take a trip back, but
Okay, up to yesterday, $2,400. This is not exactly a complicated case forensically.
okay. You mentioned that, I think you brought your notes with you, correct?
Yes, sir.
Yeah, I guess most experts have their notes just to, if something is asked, what do you use it for, just to refresh your memory?
Because if you get a whole bunch of papers and you only are interested in one fact, it's easier just to put the fact down, that's all.
So they're like little cheat notes, I'm not saying anything improper.
No, I know what you mean.
Right, just like little bullets type things so you would be able to answer something, or?
Right, bullets.
And I think you prepared, what, a 5 or 6 page of notes that you provided to me this morning and to Mr. West?
Yeah, 5 pages. Well, it's 5 pages, but it's double-spaced, double-sided in some, so it's probably closer to 10. No, 8 maybe, something like that.
Okay. And I think you also mentioned as part of your review of this case, obviously you couldn't be there when the autopsy was done, so you actually reviewed the autopsy report, correct?
Oh, yes, yes.
And your opinion is in part derived from reviewing Dr. Bowles' medical examiner report, correct?
That's correct, sir.
In terms of, obviously, the photographs that were taken, but in terms of his findings, shot to the heart, correct?
Right, sir.
There is no dispute about that the deceased, the victim in this case, Trayvon Martin, was shot in the heart.
That's correct, sir.
Okay. Now, did I understand you correctly that if you came over here and you pulled my heart out, that I could sit there and walk and talk for how long? 10
to 15 seconds, yes.
Okay, so if you pulled my heart out now, I could keep talking and just keep talking and talking and talking and just talking and talking and talking without a heart.
That's right.
Okay, for about 15 seconds or so?
Right. It's between 10 and 15 seconds. It's dependent on the oxygen supply to the head. And that's why some of the SWAT people will prefer shooting somebody in the head if it's a situation where the person has like a gun on somebody else.
Okay. Now, even though my heart is gone, I would still feel some pain, or would I not?
Oh, yeah, you'd still feel pain, but Right.
Now, I think you stated that in this case, you believe it was 12 to 15, or what did you say, 10 to 15 seconds, or 5 to?
No. What I said is I can't say.
Okay.
All I can say is that the minimum amount of time would be between 10 and 15 seconds.
Okay. And you said the maximum would be up to 3 minutes, did I get that right?
Well, I said that in all medical probability, the individual would have no cardiac function after I said 1 to 3 minutes, so 3 minutes is the outside.
And by the way, you're not here to testify as to, while this was going on, who was yelling for help, whether it was the victim or George Zimmerman. You can't say it, right?
No, sir, I'm not testifying to that. That's correct.
And in fact, you can't testify as to one of the statements that George Zimmerman said, where he said he pulled the gun from his holster and shot. You can't say that that happened that way, correct?
Oh, you mean that he pulled the gun out of the holster?
Yes, sir.
Right. I can just say that the injuries are consistent with how he shot him, but not where he got the gun from.
Right, in terms of the shot being to the chest.
Right.
Okay. But in terms of how he claims that he grabbed the gun while the other person is kneeling over him or straddling him, how he managed to somehow get the gun out and shoot the other person, you can't say that that happened that way or not.
No, because that's before, because you can't tell that by any scientific method.
But George Zimmerman said it happened that way. That doesn't mean it's true, right?
As I said, sir, I can't testify to it, so that's it.
Okay. Now, what happens if it was just physically impossible to do what he said happened?
I would say it.
But you didn't get a chance to review that, and you're not here to testify about whether he took the gun out of the holster the way he did or not.
Right, because it's outside my ability to make a conclusion like that.
Right, okay. You're just here focusing on the gun and how close it was to the skin or to the sweatshirt, correct?
That's correct,
I
sir.
mean, that's the bottom line.
In regard to Mr. Martin, that is, yes, sir.
Okay. Now, is it not true, sir, that one possibility, as you stated, is Mr. Martin was over George Zimmerman, the defendant, and he was like this, right? George Zimmerman was down on the ground, and Mr. Martin's like this on top of him.
Well, he'd be some way over him. I don't know what angle it is.
Well, is it this angle?
Or I can't tell you. The reason is because if you put your hand out, since it rotates, if someone was over horizontally, you could shoot that way. If they were at an angle, you could shoot that way, and you still get the path. All that I can say is consistent with him being over.
And it also could be consistent that they were facing each other, standing up.
You asked me that question once before, and
that
I
position.
said the problem with that is the shirt would hang down. You'd have to grab the shirt with the other hand and then grab the shirt and like pull it away this way. But the problem with that is if you then shot through the shirt in that area, when the shirt is let go and put back in position, the wound, because of that, moves over to the side. So the defect in the shirt would be over here if it was pulled this way. Because if you hold your finger on the shirt right here, and then if you pull the shirt this way, you've moved it to where it would be overlying the gunshot to get it away from the chest.
So you're saying that Trayvon Martin had to physically be on top, like this?
I'm saying that the physical evidence is consistent with Mr. Martin being over Mr. Zimmerman.
And is it not also consistent with Mr. Martin pulling away from Zimmerman on the ground, and you would have the same angle, he's pulling away, and Zimmerman shooting him at that time?
Yes.
Right? I think you said yes.
Yes, I did.
Okay, I apologize.
That's all right.
I told you I was a little bit hard of hearing. I want to make sure.
Well, that should be interesting since both of us seem to be that, so.
I was going to ask you what ear, but Anyway. The other question I had is, in terms of possibilities, you mentioned blunt trauma, and I'm talking now about, I'm switching a minute, to George Zimmerman's head, the defendant's head.
Right.
In terms of that would be concrete, it's a possibility, correct?
Right.
Or maybe like a tree branch, that's a possibility for any of those bruises?
If you hit someone in the back of the head with a tree branch.
Or
yes.
if you bump into it?
Where? The face or the back of the head?
Either one.
The problem with tree branches are, if you hit it in the face, they're rough and you would expect an abrasion.
Well, didn't he have an abrasion on the face?
No, he doesn't have abrasions, don't forget.
What did he have on the forehead?
That's a contusion up there. The skin, if the skin is smooth and shiny, an abrasion is a scrape, like you fall on your knee and scrape.
Did he have any abrasions at all?
Yes, he did.
Okay,
He
I'm
had.
sorry.
Okay.
Go ahead. No, finish, please. I interrupted you. I'm sorry.
He had a small abrasion on the right side of the nose, and then he had impact type abrasions on the right area, the temple, the left temple, and then in the back he had the 2 lacerations.
So I'm struggling with you, we're wrestling, we're doing all that, and then I push you and you hit the tree? Couldn't that have been caused that way?
From the front?
From the back, whatever.
Well, you'd have to have a tree branch there, and I didn't see any.
You didn't?
But wait a minute. But the other thing is if you just bump your head in, wood gives. Originally, police officers carried wooden batons. And the reason they carried the wooden batons were they're much less dangerous than metal things. Metals don't give, wood gives. And so, I mean, if you hit someone hard enough on the back of the head, yes, you're going to get a laceration.
You know, I try to simplify things as best I can when it comes to medical stuff. You do any gardening at all?
No, my wife does.
Okay. I do gardening and I've got a bald head, and if I don't wear a ball cap sometimes, I'll come up and I'll hit my head and there'll be a bruise or something from a tree branch. Isn't that possible?
An abrasion. I said there are abrasions back here, but what I'm saying is, whatever.
Okay.
Now I've lost my chain of thought. But.
Yes, sir. You weren't aware, and I'm showing you, Dr. DeMaio, that there was trees out there where at some point, even the defendant acknowledges that there was a struggle of some type near those trees.
My understanding of what you were saying was the trees were on the ground, not that.
Oh, I apologize. I'm talking
So
about a live tree.
I saw the pictures and I saw the vertical trees, right, yeah.
So, thank you, Your Honor. So that's a possibility, correct? For at least some of the bruising,
You could have
abrasions.
one of the injuries due to bumping against a tree. That's correct, sir.
Okay. And also, some of the injuries that you described to the defendant, George Zimmerman, could be just from rolling around, and both of them rolling on the concrete, hitting the concrete as they're struggling or fighting.
Impact on the concrete. That's what I'm saying, yes.
Right? I mean, that's consistent with what you're saying, impact
Yes,
on the concrete. Is that
Yes.
correct? I was curious what you mentioned about Trayvon Martin, that you mentioned you described the injury to his left hand, I think, what did you call it? Or what did Dr. Bauer call it, I should say, because
An
I know you got to
abrasion to
rely
the-
on him, but
Abrasion to the
you
forefinger.
were agreeing with that assessment, correct?
Well, he called it, so I have to go with it.
Well, you saw the photograph, didn't you?
Yeah, I'm not sure if I did or not.
Okay. Well, let's assume, I can show it to you if you want, or,
No, go ahead. I'm listening to you.
okay. And assuming that's an abrasion, you believe that there may be additional injuries under his knuckles, I think you said?
No, those are 2 separate questions.
Okay.
One question was whether it's an abrasion, and I said, I can't disagree with the individual who did the autopsy. But I said, the next question was, if you punch somebody, will you get bruises on your knuckles? And my answer was yes and no.
So you might not.
You might or you might not. If you really suspect something, they should have made a cut into the hand and then examined underneath.
And I gather if the person's still alive, you're not going to say, hey, let me cut all your knuckles, right?
Right, but what happened to the person's alive, you just sit there and wait a day or so, and then you'll know whether there's any hemorrhage.
But didn't you say sometimes you can hit something and not have any hemorrhaging at all?
Right. That the problem, what I'm saying is, you can get it or you cannot. And if
Okay.
you have it, and you live a couple of days, you'll be able to see it. But the thing is if it's not there, it's not important.
I think, let me make sure I understand what you're saying. That you can hit somebody and not leave any bruising on your knuckles, correct?
That's correct, sir.
In other words, George Zimmerman could have hit Trayvon Martin and not left any bruising on his knuckles.
That's correct, sir.
You were asked a bunch of questions, and I think you were showing some photographs of George Zimmerman's head, right?
Yes,
All
sir.
parts of his head, and you gave your opinion as to what that is or not, correct?
Yes, sir.
Would you not agree, sir, that somebody who's familiar with his head, like a doctor that had treated him in the past, or like a physician's assistant would know what's existing there before that day and not in terms of what the shape of the body or the head is?
May or may not.
Okay.
I mean, you don't generally remember the shape of one of your patient's head, especially if you're seeing 20 or 30 patients a day. So,
Well, my next question regarding that, would you agree that that would be the best person that would see George Zimmerman alive right then and there what's happening the next day? Would be able to describe what injuries he had or did not have?
in theory, if they do it correctly, yes. The problem is that emergency room records and doctor's records are generally lousy in regards to describing injuries. Very, very lousy.
Well, you agree that the fire rescue people do an honorable job in the sense that they know what they're doing, I guess is what I'm saying,
Yeah,
right?
I'm not saying these people aren't competent, but their job is to treat patients, and they have a tendency not to document what they see. And that's why they want to put forensic nurses in emergency rooms to document these injuries, because doctors aren't interested in the injuries. They're interested in treating the patient.
Sure, but the fire rescue people are interested in injuries, aren't they?
They're interested, just like doctors, in treating a person. Because, like, if you read the records, they mention 2 lacerations. They don't even say where they are, except in the back of the head.
Well, Ms. Folgate actually measured it for you, and that's why you were able to detail exactly how little they were.
Right, well, 20 millimeters and 5 millimeters. But then they didn't say which one was on the right side, which one was on the left side, or located exactly. So,
Now, you could tell, couldn't you, when you looked at the photograph?
yes, but they didn't do it.
Okay.
And I couldn't tell which one was the 20 and which one was the 5 because the wound hadn't been cleaned up when they took the photograph.
Well, are we talking about the same photograph?
There were 2 photographs, remember? The better one on the back of the head, there was still blood there, and you couldn't really tell which one was the 20 millimeter, which was the 5, because one of them had clotted blood on top of it.
Now, you do agree with the treatment in the sense of it didn't need any stitches, right?
I agree, but actually my answer should be it's outside my area of expertise.
Okay, so
because
you're
it's
not
treatment.
quibbling with that, right?
But yeah, but I will agree that they didn't need treatment.
You're sticking to your main thing is gunshot wounds, correct?
Well, I'm describing blunt force injuries. You're asking me about treatment, which is different.
I'm sorry,
You asked me about treatment, and I don't treat people.
Okay. You deal with them after they're dead,
Yes, sir.
right?
Yes, sir.
Okay. But you did review the fire rescue report regarding the treatment of George Zimmerman, correct?
Yes, sir.
And when it says the patient has a GCS of 15, what does that mean?
Oh, that's the Glasgow index thing.
And what does that indicate to you, sir?
Oh, it means that he's perfectly fine. Everybody here has a 15. So in this room would be a 15. So.
And those are the fire rescue people that dealt with him right after this interaction between the defendant and Trayvon Martin.
That's correct.
Correct?
Sir. Yes.
Now, did I understand you correctly that you're saying that the difference between the photograph at the scene, that bloody photograph that he's got. Do you have that big one by any chance? I know we've got it in evidence, but I believe the defense has got a big one. Thank you, sir. The front of it. Thank you, Mr. Mayor. You're saying this one right here, that there's a difference between, I apologize, Your Honor, may I approach the witness? This big photograph that shows the front of the defendant's face, it's got some blood on it, that was taken by the police out there, right? You remember seeing that?
Yes, sir.
Okay, you're saying that you believe there was something wrong with his nose, the right part of his nose, correct?
Yeah, yes, sir. If you look at the photograph taken about 4 hours later, that marked deviation of the side of the nose is not there. It's disappeared.
And do you need something to drink? Or?
No, no.
And your opinion is that you believe the fire rescue people just did it without them noticing that they did it, or the defendant, George Zimmerman, realizing that they had put his nose back in place, correct?
It's a simple, if it's a simple, I said it's consistent with the fracture. Since no one, the EMS thought there was a fracture. They said that. And if it's a fracture and it's now replaced, that would account for the differences in the photographs.
Because you agree that 4 hours later, his nose is perfect.
It's not swollen to the right side. That's well, it's still swollen a little on the right side, but it's not as deviated as shown in the first photograph.
And it's possible that it wasn't fractured at all.
But then the swelling should still be there, which it wasn't 4 hours later.
Well, did you know whether they gave him something to put on there to control the swelling?
It's not going to change.
Okay.
It's not going to change.
Now, you also talked about the injury to the back of his head, right? The two, I think, I'm going to call them scratches. That's not the correct. Are they lacerations?
Lacerations. Right.
Okay, and those are what, how, there were 2 inches and 4 inches, you said?
Oh, no. It's 20 millimeters, which is a shade less than an inch, and the other one is 5 millimeters, which is about a fifth of an inch.
So one is about smaller than this,
Right.
and then one's about that?
Correct, sir.
You're not saying that those are, that he would die from those, are you? Do you?
Oh, no, I never said that.
Oh, okay.
I said it's indicative of a hard impact, that's all.
Or maybe hitting a tree limb or just rolling around in the dirt and on the concrete?
It's indicative of a hard impact. That's all I said.
But you don't know whether it was a hard impact, somebody hitting him on the thing, or him rolling around in it?
It's a hard impact. That's all I can
Okay.
say. That's all I have said.
Yes, sir. Now, and you were aware that he was offered medical care in terms of going to see a doctor at some point, and he declined to do that?
Yes, sir.
Correct?
Yes, sir.
Now, also, I believe Ms. Fulgate and also the fire rescue did not notice any kind of other injuries to the top of his head. Do you think they dismissed it?
No, there's 2 possible explanations. Is one that the bleeding continued after he was seen by EMS, and so you're looking at something where it's been bleeding for 4 or 5 hours, or they just didn't notice it because they knew there was an impact, they didn't consider it significant.
But he went to the
That's the EMS.
facility, no, he went the next day to the facility where he ran it, where physician's assistant Ms. Fulgate treated him, and she didn't notate all the injuries that you're describing.
Well, that's the problem that forensic pathologists pull their hair out from, is that the medical personnel just don't describe injuries properly.
Okay.
Which is nothing bad against them, because their job is to treat people. My job is to look at injuries, not treat.
The other thing that I wanted to ask you about this is, may I approach the witness, Your Honor? The photograph that was taken at the scene,
Yes.
I'm sorry, of the defendant, I apologize, where he's got blood there, right?
Right.
Okay. I put my hand over that, right?
Okay. Yes.
What do you expect my hand to have on it?
Blood.
Sir, wouldn't you agree that that photograph I just showed you that I put my hand over, you said you would expect blood in my hand. Wouldn't you agree that if he was bleeding like that, that the blood, if he's standing, the blood will go down, right? I'm assuming. If he's bleeding from the nose?
It depends how profusely, but eventually it'll go down, right.
Okay. Now, if I'm laying flat on my back and I'm bleeding from my nose, the blood will go inward, correct?
Partially.
Right.
Some will go out and some will go in.
And so it will be more difficult for me to swallow or to speak, I'm assuming, if blood's coming down, correct?
Depends how profusely you bleed.
Sure.
Right.
Okay. Well, assuming I was bleeding profusely, assuming I had a bloody nose or maybe even a fractured nose, and it was bloody, and I'm laying down, the blood would go into my mouth, correct, eventually?
Yes, sir.
So it'd be harder for me to swallow, talk, etc., I'm assuming, right?
Yeah, unless you just start swallowing it.
Okay. Now, did I understand you correctly that you did not view the video that was taken of George Zimmerman, the defendant, when he was brought to the police station, when he was being walked, and he walked fine and had no problems walking or talking?
Actually, I've seen it, but they kept playing it on TV all the time.
Okay. I mean, he seemed to be walking fine and had no problems, correct? And
That's
being
correct,
able to
sir.
communicate.
That's right.
And I know the recording that you saw of the defendant's interview was subsequent to that. I believe it was 2 days later.
Yes, sir.
But on that evening, right after he was in this struggle with Trayvon Martin, he was walking and talking fine.
Yes, sir.
Okay. You're not quibbling with that, right?
No, sir.
And you agree that there is actually no witnesses to the actual shooting other than the person charged with the crime, George Zimmerman, and the person that's dead?
That's correct, sir.
Regarding the gunshot wound, and I know that that's your focus in terms of how close, I think you stated it was up to 4 inches would be max, and then 2 inches, correct? Did I get
Right,
that
somewhere
right?
between 2 and 4.
Okay, and when you say 2 inches, you are accounting for the sweatshirt underneath, and then the hoodie or sweatshirt with a hood over it, correct?
No.
You're not, because you're saying the hole kind of creates a barrier, or
Right.
a hole, I guess.
Right. I'm talking between the skin and the muzzle.
Okay. Now, have you ever worn one of those hoodies? Those jackets, sweatshirts?
Not that type, no.
Okay. Have you seen people wearing them?
Yes, sir.
Don't they normally wear them a little big?
Yes, sir.
Okay, and don't they kind of hang down?
Yes, sir.
And if the person's wearing it hanging down and he's got something in it, wouldn't it hang down?
I'll object. Requires speculation outside the scope of this particular case.
I don't believe I'm allowed to ask. He asked in terms of possibilities.
Yes, sir.
Wouldn't you agree that if I've got something here heavy, it's hanging down, right?
Right.
And that would make it a little tighter, wouldn't it?
Yes, sir.
You were asked about the DNA, and I know at some point you were head of the lab. I think it was in Texas too, wasn't it?
Yes, sir.
Okay, and you were asked about the DNA and about the possible packaging or improper packaging. I think you were asked about what the proper way is and what it's not, correct?
Yes, sir.
And would you be surprised that that same object or piece of evidence, the shirt, let me backtrack a second. You're saying that the plastic would contaminate or cause mold, bacteria, and it would, I guess, retard or degrade whatever DNA is there, correct?
No, what I said was that you're supposed to dry the blood, and then you package it separately so that one piece doesn't contaminate the other. And you don't put it in a plastic bag because a plastic bag is airtight. If you put it in, wrap it in paper, then the paper kind of breathes.
Sure.
So if you put plastic bags on like a body and you put it in a refrigerator and then pull it out, you've got moisture all over it.
Right, but what if you put the piece of clothing or the article of clothing in a bag, paper bag, and then you put it in plastic, whatever way you do it, but you keep it separate. You still believe mold to get into it, right?
Okay, there's always, okay, you can always get mold into it, but if it dries, that's where you're drying it to prevent the bacteria and the mold.
Assuming you don't dry it proper.
Oh, then you'll get mold and you'll get bacteria.
And then whatever DNA is gone.
Right.
Is that correct?
Yeah, you can glue some or all, depends on how long you keep it in there.
Okay, would you be surprised if there was DNA found in this area that apparently was mispackaged or whatever?
No.
Okay. You said you did review also the firearms report, is that correct?
Yes,
How
sir.
at least that was from FDLE, and you agreed with that in the sense of the findings in terms of the range and all that stuff, and stippling or soot or gunpowder, whatever words we want to use.
She just describes soot and a few unburned grains of powder, right?
Am I safe to assume that your opinion is that somehow after George Zimmerman, the defendant, was punched or whatever, rolled around, whatever, he had an injury to his nose, that you believe it may have been fractured or at least displaced in some way, and that somebody out there at the scene put it back in place, correct?
Or he did, just by pulling
Oh, he
on it.
could have done it himself.
Sure, just by pulling
I'm
on it.
assuming that would have been painful.
Yes, sir.
Okay. And so you believe he would have done it himself?
No, I didn't say that. You asked me who could do it, and I just added to your list.
And, you're saying anybody could have done it?
Anybody could have done it.
Okay. Or nobody could have done it, and it just wasn't as bad as people think.
Well, if it's just swelling, it shouldn't have gone down in 4 hours. That thing is just so deviated. The most likely is that the nose is just deviated because it's been fractured.
I'll talk about another subject that's close to our hearts in the sense we're both bald-headed. In fact, I've been referred to as that bald-headed dude. I don't know if you've ever been called that before, but my question is, when we bleed there, tell us about the bleeding. It's very profuse, isn't it? Because
scalp bleeding is always profuse because the scalp has a lot of blood vessels in it.
More than other areas of the body, potentially?
Yes, sir.
And why is that?
I have absolutely no idea. That's how the design is, you know.
So the bottom line, sir, there are possibilities, and one of the possibilities is what you said, and then there's other possibilities of how that gunshot wound occurred. Is that correct?
To a degree. What I said was that it's consistent with what his account.
Right. And you're not saying the account where he's saying he grabbed the gun and how he took it out. You're just saying when the gun is out already.
That's
correct. Is that correct?
That's correct, sir.
I mean, I want to make sure the jury understands that. You're saying at the time he had the gun out already and was pointing it at the person he ended up shooting.
Yes,
correct?
sir. Yes, sir.
And at that point, you don't know if Trayvon Martin was backing up, backing away in terms of providing an angle, or whether he was going forward. You can't say.
All I said was it's consistent with his account, Mr. Zimmerman's account, that's all.
But it's also consistent with Trayvon Martin pulling back in terms of providing the same angle.
I told you that too, yes, sir.
And I think, I apologize, I've already asked you that. You're not here testifying about the holster, how that works, and the reason I ask is because you are, I don't want to say a firearms expert, but you are an expert regarding gunshots. You're not here about
No, sir. No,
nor
sir.
about the firearm himself, right?
Not about the firearm either, no, sir.
Now, if the hoodie or the sweatshirt with the hood on it, do you need some water or something?
No, sir.
Okay. If the shirt's baggy, people are still able to grab it. In other words, it's still going to grab in terms of being bagged, right? If it's big, correct?
Yes, sir.
Okay. And I think you testified about the fact that your expertise is once the body is dead, not while alive in terms of the trauma and all that. You're not an expert on that. Trauma to the head or anything like that, or are you an expert on that?
No. Okay, trauma is pathology, so I will testify on that. I don't testify to treatment.
Treatment on injuries to the head.
Right. I don't testify to treatment at all because I don't treat people.
Now, were you aware that out there at Retreat at Twin Lakes, where in the area where this happened, that there's also, in addition to the concrete, walkway, there's also sprinkler boxes? Did you see any of those in the photographs you were provided?
I didn't see any of those in the photographs, no, sir.
Okay, or you mentioned knuckles too, or fist, correct? It's a possibility, correct?
Yes, sir.
I may have a moment, Your Honor. Do you know whether George Zimmerman's right or left-handed?
Right-handed.
Thank you very much, sir.
Okay.
Dr. DeMaio, the notes that you prepared to assist you today in testimony, do they contain a summary of some of the measurements, for example? That Trayvon Martin was 5'11" feet inches and weighed 158 pounds.
That's correct, sir, yes.
That his body mass index would be 22, which would be right in the middle of the normal range for a person his size.
That's correct, sir.
For example, you would have indicated that the location of the gunshot.
That's the leading nature of the questions.
Would you have indicated, for quick reference, where precisely the gunshot wound was on Mr. Martin's body, for example?
Yes, sir, I put that down.
Do you need your notes to form your opinions once you have the facts before you?
Oh, no.
Do your notes include several pages of the photos that you think were the most pertinent in assessing the trauma to Mr. Zimmerman?
Yes, sir. 4 of the pages are just photographs.
Have we shown those photographs here?
Yes, sir.
The scope of your work, if you will, was to consider the statement that Mr. Zimmerman made to the police about how the shooting took place at the moment the shot was fired, and for you to consider the forensic evidence of that gunshot to determine whether or not Mr. Zimmerman's statement about what happened is consistent with the physical forensic evidence.
Leading and compound question.
Do you understand the question?
Yes.
Okay, you may answer.
Yes, sir.
To do that, is it necessary in your mind to review every witness statement, regardless of whether they saw the actual moment when the shot was fired?
That's correct, sir. I have to interpret the objective evidence. I'm not going to base my opinion on the witnesses because witnesses are wrong all the time.
Have you had occasion where you reviewed witness statements, people who claim to have seen something with their own eyes that was absolutely contradicted by the physical evidence that you knew to exist?
All the time. They'll say someone stood over a man and shot him, and 2 architects and a secretary said that they saw it. The only problem is that the bullet taken from the body did not match the gun of the person who supposedly stood over him and shot him, and the bullet that hit him was a ricochet that had to have been fired from 20 or 30 feet away. So that's one case, but I've got half a dozen of those cases.
Let's talk for a moment more specifically, since Mr. De La Rionda mentioned them by name. A woman named Celine Bahadur testified in the trial and didn't claim to have seen the individuals at the time the shot was fired. Would that matter to you at all?
No.
Let's talk about Jane Serdyka then, for example. Ms. Serdyka testified in the trial, and she said she was looking at the individuals outside her window some distance away and believes that she was looking at them when the shot was fired. What she described was that at the time the shot was fired, of Mr. Martin.
Objection, leading, and mischaracterization of the facts.
Can I finish my question, please?
Well, if it's a mischaracterization of the facts, I need you to rephrase your question.
It's not, Your Honor. I guess
that's for the jury to determine, so please rephrase your question.
Okay, sure. Ms. Serdyka said she was looking out the window and that she believes she was looking at the individuals when the shot was fired. She said that at the time the shot was fired, that Mr. Zimmerman was on top and that Mr. Martin was face down. Is that possible given the forensic evidence that you know in this case?
No, sir, it's not possible.
Mr. Martin wasn't...
He's shot in the front, so...
So would her statement have done you any good in this case?
No, sir.
In fact, that would be an example of how an eyewitness, no matter how well intended, just gets it wrong.
Yes, sir.
You did consider John Good's statement to the extent that he was the person...
Objection, that's the leading question.
Sustained.
John Good testified at the trial that when he looked out his back door, he saw the person later identified as George Zimmerman on his back on the ground, and that he saw Trayvon Martin straddling him on his knees, striking Mr. Zimmerman in some sort of MMA style. And then he went back inside, and some seconds later, the shot was fired. Is the position that Mr. Good saw Trayvon Martin straddling and striking Mr. Zimmerman with Mr. Zimmerman on his back consistent with the forensic evidence that you found at the time of the shot?
Yes, sir.
That statement, I take it, is separate and apart from Mr. Zimmerman's statement describing essentially the same thing.
Right, but again, I would not have used that to give my opinion. I have to use the physical evidence in conjunction with the statement of Mr. Zimmerman.
You pointed out in your direct evidence that there were 2 lacerations on the back of Mr. Zimmerman's head, and that you testified that you believed those to have been from separate impact.
Yes, sir.
Because you could see the sort of valley in between?
Yes, sir.
Those were the 2 blows that created the lacerations.
Right, and in addition, they were so separate that if you impacted one, you couldn't get the other one. So there were two reasons.
Your testimony was that was consistent with having Mr. Zimmerman's head struck at least twice on a surface like concrete.
Objection is to the leading nature of these questions.
Setting the stage for the question.
Well, but they're all still leading. You need to rephrase your questions.
Are the two lacerations with the valley in between on the back of Mr. Zimmerman's head consistent with at least two separate impacts on a surface like concrete?
Yes, sir.
And is it, I'm trying to figure out a way to ask you about tree branches. And, were there any big tree branches that you knew in the vicinity of where this happened that were on the ground that could have been used as a club?
No. What you have is tree trunks, to be quite strictly speaking, but there's no tree branches that I could see. That's why when I first answered the question, I said there were no tree branches.
So for Mr. Zimmerman to have received those lacerations on the back of his head because of impact with a tree trunk, what would have had to have happened if, in fact, that were possible?
You'd practically have to be upright, sitting maybe, because you're going to have to hit the trunk. And you'd have to go back violently against the trunk on the two occasions. So it would still be blunt trauma to the back of the head twice.
Or it could have been from hitting his head on the sidewalk.
Objection,
Right.
leading and argumentative.
Well, overruled as to argumentative. All overruled as to leading. Please make sure you phrase your questions correctly.
Sure. Is that scenario much more plausible and consistent with the physical evidence?
The cement is more plausible, especially when you look at the injuries on the side of the head, which wouldn't be tree trunk because you've got a pattern of punctate abrasions.
You commented, of course, that there's a different role that some professionals play in dealing with someone that's been injured.
Yes, sir.
Whereas you may have a forensic approach, a treating doctor or PA may have a different objective.
Now, their objective is to treat somebody. My objective is to document the injuries and interpret the injuries. And, you know, they don't care really, which is fine because their job is different than my job. And that's why they're pushing forensic nursing, to put forensic nurses in emergency rooms to document the injuries correctly because they're trained to do that. But nobody wants to spend the money.
You had an opportunity to review the physician assistant notes that Ms. Folgate took the next day?
Yes, sir.
And did you notice in the notes that she documented what generally would be known as black eyes?
Yes, sir.
Is that consistent for something that shows up later after receiving a blow to the nose?
Since it's secondary blackening of the eye, it shows up later. If you punch the eye directly, it'll usually show up immediately. If you punch the nose, the blood generally leaks into the soft tissue of the eye. And so that shows up like the next day or a few hours later.
It would not be surprising to you that someone who had sustained the blow to the nose that's shown in the photos the night of February 26th, that there might be associated black eyes the next day?
No, it wouldn't be surprising at all.
Regarding the issue of whether or not Mr. Zimmerman's nose was actually deviated or whether it just had some swelling that went down later, is that significant in whether or not he got punched in the face?
He'd still been punched in the face. The reason I say that there's a probable displaced fracture is the next photograph is 4 hours later, and that so-called swelling is gone, which most likely represents the fact that the nose was displaced, and now it's been put back into position.
within the range of medical possibilities? Is it possible that maybe his nose wasn't deviated, or if it was fractured, it wasn't deviated? Or does that matter in the sense of whether or not he got punched in the face?
No, he's obviously been punched in the nose, and he's been hit in the forehead.
That's the injuries up here you're talking about?
Yes, sir.
The GCS scale of 15, is that a reference to a paramedic note? Is that what that?
No, it's probably a check, is an area on the form where, you know, a 15 means they're walking and talking and breathing, and they got heart rate, and they're not really bad. You know, once you start, most people who come into emergency rooms are 15s. Everybody in this courtroom is 15. To start going down, you have to start getting into trouble.
No, I take it you're not claiming in some way that Mr. Zimmerman wasn't able to walk or talk that evening, notwithstanding his traumatic injuries.
That's correct. What I'm saying is the type of injury he would get would be more of a stunning, not a, what most people would think of as a significant concussion. That's why I tended to get away from the word concussion, and I went to the non-medical word, a stunning type of injury.
The idea of a concussion that may lead to subdural hematomas, may lead to death, is something that happens after, at some point in time, after the actual impact.
Objection, again, leading.
Please rephrase your question.
Are the consequences of the blow those that develop over some period of time after the impact?
No, usually concussions show up immediately. But the problem is that they can be extremely subtle. And that's why sporting events like to have doctors there, because lay people will look at someone who's got a concussion and will not pick up anything unusual if it's a mild concussion.
Mm-hmm.
Because then as it gets more severe, then it becomes quite obvious.
When you're getting hit like that, are you feeling it?
Oh, yes.
Are you in some appreciation that you're being injured?
Yes. I mean, if you get punched in the nose, believe me, you know it.
Does that continue to hurt for a while?
Yes, sir.
How about when you get your head banged on concrete? Does that hurt then and continue to hurt?
It can very well, yes, especially if you got lacerations. Hurt for a while, yes, sir.
Would someone at that moment, when this is actually happening to them, be able to know whether or not what was happening to them was life-threatening?
No, because they're stunned, and you know, and you're in pain and you're in fear, so you can't interpret. Even looking at them outside, someone looking at them can say, "Oh, they're all right," but it happens all the time. You know, people, they think they're all right, and then they die a few hours later.
Mm-hmm.
That's why the police in this case should have taken Mr. Zimmerman to a hospital, not to the police station. Because if he had died in the police station, they would have been sued, and the family would have won the lawsuit because he had head injuries, and that means you take him to the hospital.
Even if there's not evidence of a concussion that he's stumbling or falling down or not able to talk?
If you have had head injuries like that, you go to an emergency room. You don't play around.
If some,
I mean, people die in jail like that a lot of times.
Mm-hmm.
And
With
the jails always lose the lawsuits, I'm going to tell you that.
Mm-hmm. So if someone is in the process of being hit and having their head struck on surface like cement, they're having this stunning effect and the pain associated with it. In the moment of that, not knowing when it's going to stop, are they able to say, I can take 3 more of these before I need to do something about it?
Leading and argumentative.
Same.
Speculation.
Mm-hmm. under these circumstances with the trauma that you've seen in this case, would it be somewhat overwhelming the person that's on the receiving end?
Same objection.
Well, you gave 3 objections last time, so which one of them is it?
Leading and argumentative.
Overruled as to both.
Yes.
There were some questions about the packaging of the evidence, and especially if it's wet and has biological material on it. In this case, there's been testimony that the wet outer shirt in particular was sealed in a plastic bag while wet and then placed in a paper bag on the outside of that. Is that consistent with good evidence handling?
No, sir.
There was also testimony that when the bag was opened, it smelled very strongly of mold and an ammonia type odor.
Because it's decomposing. That's why you air dry it and you put it in plastic and paper bags, not plastic, because you don't want the decomposition.
Is it accepted forensic practice that subjecting evidence to that type of packaging, you can also assume that it was in that condition for roughly a month, that would promote degradation or contribute to the likely degradation of the integrity of any DNA evidence on that clothing?
Oh, yes. Yes.
Mr. Delarianda mentioned that if Trayvon Martin had put his hand over George Zimmerman's nose at this point in time when there was blood, that there may have been some transfer of blood to Mr. Martin's hands. That's what that question was getting at.
Yes.
And you think
Objection is for what I was getting at. Speculation.
Sustained as to that part.
if Trayvon Martin had put his hand over George Zimmerman's nose and mouth when it was in this condition, is it your testimony that there may have been some transfer of blood to his hand?
Yes, sir.
I take it you would have no additional information as to whether or not Mr. Zimmerman's nose was actually bleeding at some point in time during the incident.
That's correct. I mean, you get an impact to the nose. You'll eventually bleed, but I can't tell you if you're going to bleed immediately or not. Just depends on what's injured.
Where that blood goes may depend on the position that your head is in?
Yes, it does.
Now, you've also talked quite a bit in direct about, I'm sorry, in cross, I guess, indirect, about if you find something that's important, but if you don't, the absence of finding it doesn't necessarily make the absence of evidence important.
Right. That's a general fact that's understood. Absence doesn't mean anything. Presence does. Because especially if you don't know what the statistical probability that a thing is present is, how often do you actually find something? Like a transfer of DNA, how often does it occur? And you have to know that before you can even give a probability. If you haven't done that, you can't even give an opinion.
Do you agree that environmental conditions can affect whether or not DNA is present on physical evidence?
Oh, yeah.
For example, in this case, you can assume that it was about 3 hours from the event until Mr. Martin's body was transported. And during that time, while it may have been, the body may have been covered with a blanket or covering on the outside, there was a period of time when the body and his hands were exposed to the elements.
Right, and then it's also how you enclose the body. Do you wrap it tightly or do you put it loosely? Again, putting it in plastic containers, plastic tends to rub and be stiff. So, if it's there, it's significant for most things. If it's not there, It's usually not significant.
You may also consider on that issue that there's been testimony that the weather conditions varied from a light drizzle to a heavy rain during these events. And would the fact that it was raining to some degree, could that also affect whether or not there's biological or DNA evidence collected from Mr. Martin's hands?
That's true. And you know, or how the hands were handled and things like that.
Or perhaps even if they may have been washed prior to being photographed?
That's why the forensic pathologist is supposed to be with the body from the time it comes in. You should always be there. You should never leave the body, even if you have assistants helping you. You don't leave the body.
You wouldn't trust your assistants to do, well, I guess what you're saying is while you may trust your assistants to follow the protocol, you would confirm and verify.
Right. Like if you want them to, if you want the clothing removed, you examine the clothing on the body before you say, okay, take it off. And then you stand there as they take it off to see if they're doing things appropriately and not maybe throwing it on the floor. You throw it on the floor, anything on the floor is now on the clothing. And then you have it put on a tray, but you don't have the clothing piled on top of each other, because if there's some material on one piece of clothing and you put the other piece of clothing on top of it, you can get transfer. So you're supposed to be monitoring this the whole time.
Let me show you, Doctor, what's marked as State's Exhibit 28, which has been offered into evidence as
beyond the scope of cross-examination.
I don't know what it is.
I'll ask the question. The State's Exhibit 28 has been offered into evidence, and it represents a picture of Mr. Martin's chest taken at the scene by the crime scene technician. And then I'd like to show you State's Exhibit 95, which is in evidence and has been represented as a photograph taken at the time of the autopsy, but before any cleaning or washing was done to the body.
Stand objection, Your Honor.
If you'll please approach and show the pictures to the court. Yes, you may.
State's Exhibit 28 was taken at the scene. And if you would note whether there's any blood present in that photograph.
Yes, there's some blood around the nipple.
And if you would look at State's Exhibit 95, which was represented as being taken at the time of the autopsy, but before the body was cleaned. Do you see any blood in that picture?
No. In the original photo, there's a stream of blood running down from the nipple, down from the wound to the nipple, and that's missing in this photograph.
Evidently, someone cleaned it.
Yeah, it's been cleaned.
Objection as to argumentative and speculation.
Sustained as to speculation, overruled as to argumentative.
Dr. DeMeyer, the last two photographs that were shown, do
Yes.
you remember what the ones that were shown?
Yeah,
One at
that's
the
the.
scene.
I'm sorry, what?
I apologize. May I approach the witness, Your Honor?
Yeah, the gunshot wound, one taken at the scene,
One
allegedly.
taken at the scene, State's Exhibit 28. Doesn't that show that the sweatshirt is up,
Yeah, but it's been pulled up.
right? And if it's at the scene while they're transporting the body, and the body comes to the medical examiner's office with their sweatshirt down, wouldn't that absorb the blood there?
May I see the other photograph?
Sure.
Well, since it's not here, it's been removed, so it's been pulled off. So if you're asking me, could it have wiped the blood up as it was being pulled off? Sure.
In other words, you would expect the blood in the sweatshirt, correct?
Right.
Now, you were asked a bunch of questions by Mr. West. You agree that Mr. West testifying is not evidence, correct?
Yes, sir.
Okay. And would you use Mr. West's statements to form your opinion?
No, sir, I used the autopsy report and the laboratory reports to form my opinion.
And the autopsy report, that was the one that you mentioned prepared by Dr. Bell, correct?
Right, and the photographs plus the firearms report to form my opinion, yes, sir.
And you agree there was an absence of any x-rays or other actual proof of a broken nose, correct?
That's correct, sir.
And you agree that there was absence of documentation of any kind of concussion or brain injury or brain bleeding, correct?
Oh, yes, sir.
And you agree that there was absence of any proof of anything being washed off the victim's body?
I can't say whether it was washed or not. What I said is that if that shirt was lying on there and they pulled it off, they could have wiped off some of the blood. And that's why you're not supposed to do that. You're supposed to take the photograph of the wound intact before you clean it. And so there was a big no-no there,
Okay,
either way.
Are you saying that at the scene, the medical examiner personnel should remove the clothing of the victim, or should the clothing remain on the victim until he's transported to the ME's office?
No, what I'm saying is that the clothing should remain on the body, so the photograph taken at the scene, that's proper. But when they got to the medical examiner's office, they shouldn't have pulled, if they wanted photographs of the scene as received, they shouldn't have undressed the body or pulled anything off, because they would be wiping it. And then the rest of but the whole chest is clean and such. So, you know, the techniques weren't exactly correct, let's put it that way.
But you did rely on Dr. Bau's report in terms of his findings, correct?
I had no other choice, sir.
Okay. And based on your observations of the photographs, they document what occurred in terms of the gun, right?
Yeah.
You're not disputing that?
Right, the photographs of the wound were the best thing.
Do you have is there any absence of evidence that anything was washed by the rain?
It would have to be, you'd have to know how much it's raining there, and you'd have to have an observation.
Pure
It could be
speculation.
washed away by the rain.
Pure speculation, correct?
Yeah, unless you were there and saw how much it was washed away.
And there was an absence of vomiting, right? You didn't see any vomiting out there, correct?
No.
And finally, you were asked about John Good, what he testified. Do you agree that a jury that heard John Good's testimony should rely on what he said on the witness stand? Correct? And here's what I'm getting at.
It's kind of interesting. If he's got a good statement at the time and then he testifies something else on the witness stand, you begin to wonder.
Okay.
You know? I mean, I think that's up for the jury to consider.
Right. My question is, if John Good testified he neither saw nor heard any blows landing, and neither saw nor heard anything being slammed on the sidewalk, does the physical evidence, is that what then you rely on?
No, I wouldn't. I tell you, I didn't rely anything on his statement.
Oh, you completely disregarded John Good?
No, I disregarded the witnesses because the problem what I was trying to do was essentially take Mr. Zimmerman's statement and see whether the physical evidence was supported it or invalidated his statements.
So,
because the witnesses, you know, they're all over the place. You can't use the witnesses to make autopsy decisions.
but isn't what George Zimmerman, the defendant, is relaying to the police, isn't he affect a witness in terms of what happened?
Yes.
Okay.
But that's why you don't believe him and you do the tests and look at the autopsy to check what he said matches what you find at the body.
Right. And what you did is you relied on one of his statements, and the bottom line is what you can say is the gun was out and it was 2 inches from the body.
2 to 4 inches
I'm sorry,
from
2
the
to 4
body.
inches,
Right.
correct? Thank you.
Right.
One very narrow area. On this notion of the absence of evidence not being evidence of absence notion, if Mr. Good didn't testify that he heard George Zimmerman's head hitting cement like this in some way, does that in any way mean that Mr. Zimmerman's head didn't actually get hit on the cement?
No.
Same thing, if Mr. Good didn't hear Trayvon Martin hit George Zimmerman in the head like this, does that mean George Zimmerman didn't get hit in the head to cause the injuries that you saw?
No.
Thank you.
Thank you. May Dr. DeMaio be excused?
Yes, Your Honor.
Mr. West, may Dr. DeMaio be excused? Okay, thank you very much, Doctor. You're excused. Call your next witness, please. Your next witness is?
I'm sorry, Your Honor. One moment. Mr. Bonaparte, Your Honor. Sorry for the delay.
And his first name is? Okay, we'll ask him when he gets on the stand.
Norton. Sorry.
Do you solemnly swear from the testimony presented will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
We have a question
Yes.
very briefly.
You may proceed, yes.
Thank you. Good afternoon, sir. State your name, please.
Norton N. Bonaparte Jr.,
And your occupation.
City Manager, City of Sanford, Florida.
How long have you been so employed?
A year and a half.
And you were employed then back in February of 2012 when this event happened, correct?
That is correct.
I want to focus your attention, if I might, on a very particular event, and that is the event that surrounds the playing of a what we now know to be a 911 call to the Martin family. Okay?
Okay.
I understand that there were some decisions that were made getting us to that point. We're not concerned or going to inquire into the reason. I only want to talk to you about the actual event, okay?
Okay.
I'd like you to focus on that. My understanding is, and if I might be given some leeway to lead a slight bit to focus the witness, my understanding is that that a decision was made to play the tape for the Martin family, correct?
The decision was made to play a number of tapes.
Correct, including, and I know that there were several tapes that were played. Those were police evidence tapes of the investigation surrounding this event, correct?
There was the 911 and the non-emergency number.
Yeah, several of them, correct?
That's correct.
Okay. I want to focus your attention particularly on one, though I realize that several were played. When the decision was made to play those tapes, who actually took care of the process of playing the tapes?
It was the mayor's office, and it was myself and the mayor.
Okay, so both you and the mayor actually did the physical playing of the tapes, correct?
To the best of my recollection.
Okay. Was there any conversation with law enforcement before that as to how to accomplish the playing of the tapes for these witnesses before it happened?
At that point, they weren't witnesses, they were parents.
Is that a no?
Please repeat the question.
Yeah, okay. The question was whether or not you had any conversation with law enforcement as to how to play these tapes to these people. You say they weren't witnesses, let's just call them people. Were there any conversations with law enforcement as to how to accomplish this playing of the tapes, yes or no?
No.
Okay. So that you and the mayor just decide on your own as to how they would be played?
The decision was made to make them public, the purpose of showing them to the Martin family so they heard it first as a courtesy to the family.
Absolutely. I understand both the courtesy and the sensitivities that you were dealing with, sir. My focus is a little bit different than that, however, okay? Here's my focus.
Okay.
When the actual decision to make the tapes play for the Martin family, was it your decision? Was it the mayor's decision as to how that would occur?
The decision was made just to allow them to hear them.
Okay. Was there any consideration given to the idea of playing them to those individuals separately, one separate from the other, so as to not infect their view or what they heard one to the other?
And no, there was not.
So the way that it occurred, then we know from other testimony, was that the tape was played, and again, I know that there were several tapes. The tapes were played with the entire family present in one room, correct?
That is correct.
And were you the one playing the tapes?
I don't recall exactly who was playing it. We used a computer.
Well, if you would, give us the setting as to who was doing what with the tapes.
It was a disc that we were using a laptop so that they can hear the tapes.
Yes, sir. And who was doing what?
I don't recall specifically. It was either myself or the mayor.
Who was present?
The mayor, the Martin family, and the attorneys, Mr. Crump and Miss Natalie Jackson, and the Trayvon's brother, and then there was another individual, and I don't know his name.
Was there any law enforcement present?
No.
Was that a decision that you and or the mayor made to keep law enforcement out of the room?
We had asked the family, I asked the family if they wanted law enforcement, and they said they'd rather have law enforcement not in the room at the time, and so we obliged their request.
And did you discuss that with Chief Lee in regard to his desire to be in the room?
At that point, we just informed the chief as well as the other officers to not be in the same room.
Do you recall how many times the tape was played?
Which tape?
Let's focus on the 911 tape that had these screams for help on it.
No, I do not.
Were you there for all the times that it was played?
I was in the vicinity. I wasn't always in the room.
Okay. Was either you or the mayor, that's Mayor Triplett, correct?
That is correct.
Was either you or he in the room at all times the tape was being played?
I do not recall.
How many times was the tape played while you were in the room?
I do not recall.
More than one?
The tape that has the screams, yes, that was played more than once.
And was that at the request of anyone in particular?
I believe it's at the request of the family.
Anyone in particular in the family?
I do not recall.
Did they give you any reasons for why they wanted to hear it more than once?
I think they just wanted to hear it again.
Did they make, did you record or take any notes as to any responses they had regarding what they heard on the one tape of particular concern?
No, I did not.
Did you record the event of this happening in any form or fashion so that law enforcement or others might have it?
No, we did not.
Was it recorded by audio or video?
No, it was not.
Was anyone there like a court reporter just to document exactly how it occurred?
No, it was not.
Was any consideration given by you or the mayor at all to do it in a fashion that could record it should law enforcement or anybody else need it for future purposes?
We were releasing it to the media that evening, and we just wanted the family to have the courtesy of hearing it first, and we did not have it recorded.
Okay, and I'm sorry, so I don't mean to banter with you. My question was fairly specific as to whether or not you gave any consideration to the concept of recording it so that if law enforcement or anybody else in the future needed it, it would be recorded. That event of the first time half a dozen family members listened to that tape was recorded at all. Is that a yes or a no?
It's a no.
Just a moment, Your Honor. And just to be clear, the attorneys that you say were present were not city attorneys, they were the Martin family attorneys, correct?
That is correct.
The only two people representing anybody in Sanford, from law enforcement to the police, law enforcement to the administration, was yourself and May Triplett.
That is correct.
Nothing further, Your Honor. Thank you.
Thank you, Carl.
May I proceed, Your Honor?
Yes, you may.
Mr. Bonaparte, the bottom line was that it was the decent thing to do to play it for the family before it was released to the public.
That was our intent.
And that's why it occurred the way it did. Is that correct?
That is correct.
Thank you, sir.
Any redirect?
No, thank you.
Thank you. May Mr. Bonaparte be excused?
Yes, sir.
Thank you very much, sir. You are excused. Please call your next witness.
I hate to approach. There's a witness that we want to appear in a unique way. I want to talk to the court about that, if I might. And I didn't know if this might be a time for the jury to take a break at 3:10.
Well, why don't you approach first and find out. Gentlemen, we're going to take a 15-minute recess, so if you'll please put your notepads face down on the chairs and follow Deputy out of the courtroom. Doing okay? Please be seated. Court will be in recess for 15 minutes.
We are just trying to get this witness on that screen, and we're close, I think.
Okay, and the witness knows to have the do not disturb on there?
Yes, actually, we've used a program that isn't susceptible to that.
All right, so we'll wait for the jury to come in until we have this up and going?
Yes, Your Honor, I think that would make sense. I'm going to just for the record purposes, have to be made in front of the jury. Obviously, this is a compromise of how this witness is testifying, but it's one that the defense is requesting. The state has acknowledged or agreed to it. And my client have just discussed with him, and he is okay that we present this witness through this fashion.
Okay, is that correct, Mr. Zimmerman? Okay.
Yes, sir.
Okay, thank you very much. You could be seated. Yes, you may.
tight for just a second. Okay. You need to show a photograph? Eloise, I'm going to show you something through a camera. I want you to tell me if you can see it, okay? You can't really see me right now because the camera's pointing up, correct?
Correct.
Can you see a document that I'm showing you?
Yes.
Okay. That's the way I mean. No, you really can't see it there, but you can. Thank you, Ron. And just for your planning purposes, we've canceled a couple witnesses based upon some of the testimony. So at this point, this will be my last witness, and we will go into the proffers of both experts. It's a little early, but that also compressed everything down, so we're probably going to be done tomorrow.
Okay, let's bring the jury in.
Can you hear me?
Yes.
Great. This is the microphone I'm talking to this. This was the pick up to.
She won't be able to see. Be able to hear the clerk to swear her in to swear.
Yes, you can hear me now, Eloise, correct?
Yes.
Madam Clerk, would you just introduce yourself?
My name is Lisa.
Can you hear that?
Yes.
You just heard Lisa? Perfect.
Very fresh, Ron.
Please be seated. Mr. O'Mara, call your next witness.
The defense would call Eloise Dilligard, Your Honor.
Okay, go ahead.
Ms. Dilligard, can you hear me?
I can.
Okay. The clerk, Lisa, is going to swear you in. You'll be requested to raise your right hand. So I would ask that you do that. And if you would.
Do you solemnly swear or affirm testimony presented will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good afternoon, ma'am. And I first want to thank you. I understand that you're homesick and appreciate you spending some time with us today. I think I've asked you your name. Tell me your name again.
Eloise Dilligard.
Okay. And and if you would spell your last name.
D as in David, I-L-L-I, G as in Gary, A-R-D as in David.
Thank you, ma'am. And back in February of 2012, did you live at the retreat at Twin Lakes?
Yes.
How long had you lived there at the point of February 2012?
By that time, it was about 2.5 years.
Okay. You have since moved out of that location, correct?
That's correct.
Okay. I want to take you back to the time that you lived at the retreat at Twin Lakes and ask you if you knew somebody by the name of George Zimmerman.
I did.
And how long had you known him?
Ever since we moved in October of '09.
Would you consider yourselves friends?
He was my neighbor. We spoke on a friendly basis, had no problems with one another.
Okay. And were there times that you became aware that he was involved in a program called Neighborhood Watch?
Yes.
Okay. Did you ever see him in the neighborhood patrolling or doing anything like that as part of Neighborhood Watch?
No.
But you did know him as a friend or a neighbor?
as a neighbor, a friendly neighbor.
Okay. And focus your attention now, if I might, on February 26th, which of course is the night that Trayvon Martin was shot. Do you remember that night?
I do.
What I'd like you to do, if you would, is to tell the jury what first brought your attention to the event that you eventually came out or came to find out was the shooting we're talking about.
I was coming from Walmart down Reinhardt to go to Oregon and make a left, and a policeman approached me from the rear. And of course I thought, well, I didn't do anything wrong, but then I only to find out he wanted to go around me, so I pulled over. And as I was coming up Oregon to go into my neighborhood, I noticed that the police were going into the neighborhood. So when I pulled in, I looked down from the mail station down to the left and saw that there was crime scene tape going up, and I didn't want to go directly down, so I came around the right-hand side where I lived to go around the back way and asked a couple of guys that were standing outside, and they told me they didn't know what's going on, but there was another policeman coming. So I then proceeded to come back around and go back around by the mail station toward the crime scene area.
Okay. And do you recall what the weather was like during that time?
It was very rainy that night.
Okay. And at some point, as you got closer to what you call the crime scene, did you notice any vehicles that were familiar to you?
Yes.
And whose vehicle? And what vehicles were they?
It was George's truck.
And could you describe that if you would?
I believe it's a gray Honda Ridgeline.
Okay. If you could, tell the jury as best you can where within this area you noticed the truck.
Because of the way our road is for Retreat View Circle, it was more like on the curb or nearing the curb down by where the crime scene was.
Okay, let me ask it this
way. Which I believe was on Retreat View Circle. I'm not really sure exactly.
Okay. Do you know the area that has come to be known as the T intersection, which is very close to where the incident itself occurred?
Yes.
And though you may not have known the names then, there's a woman who lives in the end unit right by that T intersection by the name of Jenna Lauer. Do you know her?
No, I don't.
Okay. If we were to, I would ask for you to accept as a premise that she was living in that first condo or townhome just at the intersection of the T intersection and the sidewalk. Would you know what I was talking about?
Yes.
Okay. And to fast forward a moment, this was an area where you had testified in deposition that you actually had some conversations with police. So I'm just trying to geographically locate. If we were to presume that Jenna Lauer's townhome was that first one in that row of houses, where was the truck parked in reference to that?
If she was in the first one, then the truck would have been parked looking toward the east. It would have been slightly south of where her condo would be.
So if you were to walk out her front door, would you be looking sort of right at the truck?
Well, not right at it, but you would have to look more to the right if you were walking out of her condo, if her condo is facing Retreat View Circle.
Okay, because that would then put the truck parked on the curb as you would walk out her front door, it would be parked to the curb on the right-hand side of that street?
That's correct.
Okay. Now, you say Retreat View Circle. Is that the street that actually circles around, or is the perimeter of the complex itself?
It does.
Okay. Is Miss Lauer actually on a street that comes off of Retreat View Circle?
If I'm visualizing exactly where you're talking about, I believe her condo would be facing Retreat View Circle, yes.
Okay. How would it be, the front door, if I walked straight out her front door, would I eventually walk right into the clubhouse area?
No, you would have to walk down the street to the west.
Okay. Let's talk then about wherever the truck was located. You saw it in reference to the crime scene. You saw it in that area?
Yes.
Okay. And we may come back to a map in a minute and see if we can show you a map of the area. But let's move to the point where you came up to the area where the crime scene was. Describe what you first saw.
There were quite a few people standing on the sidewalk. There were people who were closer down to where the yellow tape was. And I kind of looked around, you know, to see if I saw George, because I saw his truck. And after I didn't see him, then I recognized the lady from one of the HOA meetings, and I asked her what happened. And she said, I believe,
Ma'am,
second.
Ms. Delegard, when you hear one of us say an objection, that means the court has to inquire. So I just hold on to your testimony for 1 second. You didn't do anything wrong. Just want to check with the court.
Okay, what is the objection?
Objection, hearsay.
Sustained as to what somebody else said.
Your Honor. Did you know the person's name who you spoke to?
I don't know her. All I know is she's from Pembroke Pines.
Okay. So you had a conversation with her about the events that she perceived?
I simply asked what was going on, and that was her reply to me.
Okay. And at some point then, did you speak to any law enforcement officers?
After I could not find, or after I didn't see George, I did attempt to talk to some of the other residents that was there. And after I felt like, well, okay, I'm not in harm's way, I was walking away, and a policeman came up and said to me, "You don't want to talk to me." And I turned around and I said, "I don't know what I can tell you because I wasn't here when anything happened."
Okay. And then what did the law enforcement officer say to you?
He then replied, "Well, we're trying to find someone who may know the people involved in the shooting."
Okay. And did he have any further conversation with you or show you anything?
He just asked me would I mind staying up, and he was going to go and take a picture and bring it back to the group of us that were standing there to see if we could recognize either the victim and or the suspect.
Did that officer happen to identify himself to you by name that you can recall?
He did not, and I'm usually pretty receptive to look at a name badge, but, you know, with everything going on, I don't remember.
Okay. So at some point then, did he show you a picture or two of people who were involved in this event?
He came back with what I believe was an iPhone, and I'm only saying that because I own one, with 2 pictures.
Okay.
And I, along with the others standing there...
Let me interrupt for a moment to ask you if you could identify either by name or by description the other people who were present during that time.
There was a young Caucasian man. I can't remember his name. It was either Jeremy or Jonathan. And then there was a couple there. They were married, but I did not get their names.
Okay. And were they then present when this picture or these pictures were shown?
They were.
Okay. Were you able to identify anybody in either of those 2 pictures?
Yes, I was.
And who was that?
That was George Zimmerman, my neighbor.
Okay. We have seen those pictures here quite a bit in the courtroom. I'm not going to show it to you directly right now unless I have to. But was that a picture where Mr. Zimmerman had a bloodied nose?
did have a bloody nose, yes.
Okay. And there was describe the difference, if any, you saw between the picture that you saw that night and the George Zimmerman who you knew before that night.
His nose was very bloody, and to me, it looked very disfigured, like it was, let's see, I'm looking at him, so then it looked like it was somewhat to the left or right. But I know it was not the way I knew him. His face was the nose was very disfigured and a lot of blood coming from it.
Okay. Did it take you a minute or two, or how long did it take you to even figure out that that was the same person?
I mean, his face still looked the same. The only difference was the disfigurement and the blood in his nose.
Did you advise the law enforcement officer who was present of this person, George Zimmerman's name?
Yes, I said, that's my neighbor George.
Okay. And did anybody else, as you can best recall, identify the person as well?
Objection as to hearsay.
Sustained.
Don't answer that. After you identified George Zimmerman as the person in the picture, were you shown a second picture?
I was.
And that was somebody, was that anyone who you identified?
I did not know the person's name. I had seen him in passing probably earlier that day, but I mean, I didn't know who he was.
Okay. And do you know now that that person was Trayvon Martin?
Yes.
After then you identified George Zimmerman, what was the next thing that you did, or who'd you talk to about that event?
Are you talking about that night?
Yes, ma'am.
If I can remember correctly, I think the first concern was where his wife was, if his wife was there.
Okay, was that your concern, you mean?
Yes, because I mean, I knew he was married and I didn't see her, and they're my neighbors, and once I saw his face and what looked to be, been hurt, my first concern is, where's his next of kin, his wife? Okay, and what'd you do about that? Well, after, there was nothing else I could do at that point. Once I found out that, as I thought, I was no longer in harm's way because my husband was out of town, I went back down to my house, parked in my driveway, got out of the car, and went up to George's residence and knocked on the door to see if Shelley was there. I rang the doorbell, I knocked, I heard the dog, but nobody came to the door. Shortly thereafter, Shelley pulled up behind, perpendicular to the driveway. She didn't pull in because I was walking away. And she asked me, where is...
Your Honor, I would ask to be heard on that hearsay objection, if need be. It's not all for the truth of the matter of what Ms. Zimmerman may have said, but it just sets the...
Well, I don't want speaking responses. Please approach.
Yes, Your Honor. still there?
I'm here.
Perfect. Thank you very much for the patience. Well, I think we were talking about that you had a conversation with Shelley Zimmerman.
Yes, a brief conversation.
And after that, what did Ms. Zimmerman do?
Once I concluded my conversation, she sped off around to the crime scene.
Okay. Now, I may have taken you out of time a little bit. I want to go back. When you were there with the police, well, let me ask you this. Did you go back to the area of the event at all that night?
Yes, I did go back down there to make sure she was okay.
Okay.
But to see her, so I got back in my car and I went home.
Okay. My understanding was that you were present during, that you were questioned by law enforcement to the extent that you've told us about. Were you present during any other witnesses' discussions with law enforcement?
Yes, the young man that was there alone, and then the other couple spoke to the policeman in terms of what they knew.
Okay. I don't want you to tell us precisely what you heard them say, because law enforcement may have already testified to that. But were you there when those people gave their statements to law enforcement?
I was there when they gave their verbal statement, but I was there when they did their written statement.
Okay. I'm going to ask you if you could be a bit more precise. I know that you don't recall names. I believe you said one might have been Jeremy and another one Jonathan. Was that correct?
That's what I think I remember about the names, but again, I'm just not sure.
That's fine. But do you recall, were there three people? I think you said one female and two males, or were there any more than that who gave their verbal statements to law enforcement in your presence?
In my presence, there was a couple, a male and a female, and then there was a gentleman who was by himself.
Okay. Did you give any verbal, except for what we've talked about so far, did you give any verbal or written statements to the police that night?
No, other than he asked me my name, and I gave it to him, and I gave him my phone number.
Okay. And then, and now I think we'll go back to the time when you left the area of the event, first ran into Miss Zimmerman, went back looking for her, didn't find her, and left the second time?
Correct.
Okay. At some point then, did you give statements to law enforcement regarding what you knew or heard about the event?
Yes, there was an FBI agent who left a card on my door and requested I call him. So I called.
Okay.
And he and another agent came to my house and interviewed me.
And you gave them a statement about whatever information they asked you about, I presume?
That is correct.
Okay. At some point, did you have an opportunity to listen to what we call, and have been calling during this trial, the Lauer 911 tape? And for your purposes, that is the tape that has the this voices in the background screaming for help. Have you had an opportunity to listen to that?
Yes.
Okay. Could you tell me the circumstances or the setting around the first time that you listened to it?
The first time that I heard it was when it was played on one of the local news channels.
Okay. Were you by yourself or with anyone else?
You know, I don't remember.
Okay. How many times have you listened to the tape?
Besides that time, well, it was played over and over, but I would probably say maybe 2 or 3 times.
Okay. Did you hear a voice screaming for help in the background that you were able to recognize or identify?
I heard the voice screaming in the background, and of the 2 that we are discussing, the deceased Trayvon and George, I've only heard George talk.
Okay. Whose voice do you believe that was in the background screaming for help?
Based on the fact that I've only heard George's voice and it's a light male voice, I would say that it was his,
And by his, you mean whom?
George Zimmerman.
And when you say you've heard him talk, tell us again about how long you've known him.
By that time, it was 2.5 years.
Okay. An opportunity to hear him both speak to you and speak to others in your presence?
That is correct.
Ever hear him yell for his dog or laugh at a joke or anything like that you can recall?
Never heard him yell at the dog. I mean, whatever commands he gave the dog were very, just like a voice talking to someone next to you. But again, from what I heard, he has a light male voice.
Okay. I'm going to ask you then, I'm going to try something that may work. I'm going to show you an exhibit. It states Exhibit 1, and just see if there's any chance that this can be done in a way where you can identify the picture. And then I'm going to have you try and walk us through a location where you may have seen George Zimmerman's truck, okay? So what you're seeing now should be blocked pretty soon by a picture. Can you see that picture?
I can see the picture.
Okay. Let's just see if this works in any form or fashion.
You need to bring it up a little. It's going out of my focus.
Okay. Let me try something else then.
That's better.
Okay. For you, maybe. Hold on for 1 second.
Sure.
Does that work? Can you at least...
That works.
All right. I'm going to move it a little bit to an area. Okay. Can you describe what is barely on the screen at this point? Can you see that?
The only thing I can see is a blue line, a little bit of grass, and the white border on the picture.
Can you see the pool that's in the center of the photo?
I can.
Hmm? No, it's not. What do you mean? Your Honor, if I might. Okay. Unless we start talking about mirror images, Your Honor, that's not going to work, so I'll move on to another area of inquiry. Ms. Delegard, I'm going to try to do verbally what we were just going to do visually. And ask you this. You are familiar with the complex, correct?
I am.
Okay. You sort of gave us a walk or a drive-through as to how you entered into the complex. Can you tell me what entrance you came into that night?
I came in the entrance that is directly in front of Bentley Elementary School.
And is that the one that when you drive in, you have the clubhouse immediately in front of you and just to your right?
That is correct.
Okay. From that point, and I know we're testing your memory since you don't live there anymore, from that point, as you're coming in Oregon, I know that you took a sort of back route over to your complex because you took a right on Retreat View Circle, correct? When you first came in.
No. If you say the back route, then you're talking about the part of Oregon that goes up to 46A or Johnny H.E. Thomas.
Yeah, I confused it by saying that. My understanding... One moment, if I might. Okay, sorry about that. Can you hear me?
That's okay.
All right.
I can hear you.
I think I confused my question a moment ago. My understanding was that when you first came into your subdivision, you realized that there was some crime scene tape, correct?
Correct.
As you're coming into the main entrance with the clubhouse off to your right, which way was the crime scene tape from where you were driving in?
To the left or to the east.
Okay. And that would have been, is that the normal way that you would go from that main entrance to your residence? You would go to the left?
No, I would go to the right.
Okay. All right. Now, what I would like to do is start at the Oregon main entrance with the clubhouse on your right. And if you can sort of walk or drive us to the area where you did drive up to get a better view of the area of the crime scene itself.
If I were to drive in to the entrance that was directly across from Altamese Bentley Elementary, I would have made a left rather than a right to go down to where the crime scene was.
Okay. And where on that scene then would you have seen George's truck?
Oh boy, it wasn't even 3/10 of a mile down because it's not that far.
Okay. Do you have a present memory today as to where the truck was?
It was parked on Retreat View Circle, just to the left of where you're talking about the T area was.
Okay. Let me ask it this way. I'm going to refresh your recollection with some testimony potentially. Could the truck have been parked not on Retreat View Circle, but on the 2nd Street in, so that, you know the 2nd Street in I'm talking about? So if you don't take...
That's correct. Yes.
Okay, you don't take your first left onto Retreat View Circle, but you take your second left onto Twin Trees? Twin
Trees Lane, I believe it is.
Could that have been the street that you turned down and saw Mr. Zimmerman's truck?
It could have been. All I know is that it was on one of those curves.
Okay, that's okay. Nonetheless, wherever that truck was, it is your testimony that it was directly in front of, maybe a touch off to the right, of what we've identified as Miss Lauer's townhome?
Yes.
Okay. So if we were to use Miss Lauer's townhome as the focal point, you would walk out or look out her front door and look just to your right to see George Zimmerman's truck where it sat that night?
That is correct.
Okay. I have a moment, Your Honor. Thank you, Your Honor. No further questions?
Okay.
I'll try and assist as best I can with the compromise of having it this way.
Okay, thank you. Cross?
Ms. Delegard, can you see me all right?
No.
Kind of, sort of.
It's looking straight up. That's what she sees.
Okay. Can't see me still?
I can see you through the just beyond the little projector. Yes.
Okay. I don't know if you remember me. I'm Bernie Della Rionda with the State Attorney's Office.
Yes, I do remember you.
Okay, great. I just have a few questions and then we'll get you out of here. Okay, or we'll leave you alone, I should say. Since you're at home. Yes, ma'am. The bottom line is that day you came into contact with a police officer who told you there was a suspect and a victim, showed you some photographs. You recognized one photograph as George Zimmerman. The other photograph, you didn't know the person. You now know it's Trayvon Martin, correct?
That is correct.
Okay. And you said you had seen him earlier the day in the retreat at Twin Lakes, correct? Just walking around?
Right.
Okay. And then finally, you were asked about the voice. You mentioned you saw it on TV, correct?
Correct.
And you didn't have a point of reference. All you knew was George Zimmerman's voice, but you had never heard Trayvon Martin's voice, correct?
That is correct. I've never heard his voice.
Thank you very much, ma'am.
You're welcome.
Any redirect?
A sick woman in her bed who came with us. I think we're done with her and do appreciate her coming.
Okay.
Ms. Delegard,
Yes.
we are done. I appreciate your time. Thanks very much for doing this from your home, and I apologize for the interruption. I hope you feel better.
It's okay.
Thank you. May Ms. Dillagard be excused from
yes.
being recalled?
Excused by the defense, yes.
Okay, you're excused. That means that you don't have to appear again. Thank you very much, ma'am.
Thank you, Your Honor.
Thank you. Okay. Yes, and when you're finished with that, if you'll approach for just one moment. Okay, ladies and gentlemen, there's some more matters that we need to take care of tonight, and so I'm going to let you go home at this time. It's 4:21. Before, as you're starting to get your notepads in order, I'm going to give you my admonitions. During the overnight recess, you're not to discuss the case amongst yourselves or with anybody else. You're not to read or listen to any radio, television, or newspaper reports about the case. You're not to use any type of an electronic device to get on the internet to do any independent research about the case, people, places, things, or terminology. And you're not to read or create any emails, tweets, text messages, social networking pages about the case. Do I have your assurances that you will abide by these instructions? Okay, with that, put your notepads face down and follow Deputy Jarvis back into the jury room. And we'll have the jury back at 9 a.m. Please be seated. We're going to take a 10-minute recess, and then we're going to continue on with the animation issue and the proffering of the testimony of Mr. Connor. And at 8 o'clock in the morning, we will be back in court before the jury comes to discuss another issue regarding witness Mr. Donnelly. Court will be in recess for 10 minutes. Please be seated. We're back on the record, and I see Mr. Shoemaker is sitting on the stand, and Mr. Manti is ready to go, so let's go ahead with your cross.
Thank you, Your Honor. Mr. Shoemaker, in going through your CV, my understanding is that you received a Bachelor of Fine Arts degree in graphic design in 1985, am I right?
Yes.
And as far as additional degrees or anything like that, that is the end of it, am I right?
There's always ongoing education, and I've been educated beyond the college.
I understand, but nothing in terms of graduate or postgraduate work that resulted in a degree?
No.
Okay. And nothing, sort of, you're not being held out as anything like an engineer or physicist or anything like that, am I right?
Correct.
Okay. Graphic design, essentially you take computer software and, for lack of a more specific way to put it, you draw things or create things.
That's one version.
Okay. What's another?
There's a lot of different types of design, information design. There's a lot of different things that you can do with those tools.
All right. As far as your prior experience in testifying, I think you said 20 criminal actual cases where you were appeared in court?
Declaration or testified.
Okay, I want to know specifically where you testified in a court in a criminal trial in front of a jury. How many?
17.
17. How many of those was your testimony ever even really objected to or challenged at any kind of pretrial hearing or anything?
You mean challenged, or what do you mean?
How many times did whatever side you were testifying for, and I understand it's always been for the defense, but how many times did the other side challenge or object to you being permitted to testify?
Whenever I was qualified as an expert.
So there was always some kind of pretrial hearing?
Whenever I testified in court, there's always been a pretrial hearing.
Okay. So 17 times. And how many of those involved animations created with the motion capture suits?
Probably about a dozen.
A dozen? Can you tell me the last one? Give me the title of it.
It was Green, I believe it's People versus Green in Placer, or Auburn County, I believe. Or, yeah, it was in Placer City, or Placerville, sorry.
Placerville?
Yes.
I know that you have also testified that you often create these animations based upon such things as surveillance footage, like you showed us the one with in the parking lot and that sort of thing. How many of these involved a situation like this one where you had no film or anything like that and you were basically inserting figures?
It's very rare that I have film to be able to match the animation to the film.
Okay.
So that was pretty much the only one where I've done the matching onto a security camera.
How many of these then did you involve figures that are actually in what I'll call, just term a melee or a fight between the two of them? How many times have you done that in court in front of a jury?
Twice.
Twice?
That includes this one.
That includes this one?
Most of them they're not person-on-person fights. Most of them are shootings. It's mostly just shootings.
As I understand it, most of what you did in these other cases are the animations that you create are you take bullet trajectories that you can, physically measure and implant those or embed those into your animations and illustrate them. I think there's a few I've read about where you use a red line or something like that to show how it goes, right?
Essentially, yes.
Okay, so you're taking the raw data, just like you use total station data here, and you're drawing lines or putting figures in places where they could have been, but not like this case where you're describing a physical ongoing fluid situation between two people.
There's some that I've worked on where it's multiple gunshots, so you've got movement from the first one to the next one to the next one. So it's a sequence of events.
Okay, but not interaction between the two physically. You're talking about measuring trajectories again and things like that.
Correct.
Okay. So what is that last one, or the only time that you've actually testified in court in a scenario similar to this one? Tell me when and where that was.
The last one using the suit, or?
Using the suit, involving more than just, involving a physical fight between two or more people where you've had to recapture a fluid situation in court in front of a jury.
That was a Greenberg.
Greenberg. Okay. And tell me a little bit about that one.
That one was an ex-police officer came up to a vehicle and shot the person that was in the vehicle. So I had to determine the position of each of them and their positioning when he was shot, their movements.
Okay, so that involved, again, some distance between the two of them and a shooting? One inside a car and one outside a car, or something like that?
Close approximation to each other, yes.
Okay, but one sitting in a car, and I think you said one shooting into the car from outside? Is that?
He was within the door, open door of the truck.
Okay. Not, as in this case, where you're trying to describe a ongoing scrum between two or more people?
Correct.
Okay. So this would be the
first time.
I have
one that I'm currently working on now that, not this one. There's one I'm working on now that is the same as that.
I know about working on. I want to just focus right now for the moment on things where your testimony has been accepted for court purposes in front of a jury in a criminal case. And it sounds to me, if I'm not mistaken, like this would be the first time this particular scenario has arisen where you've been called upon to do that in court in front of a jury.
The suit that I've used has been accepted in court in 2 other cases.
I'm not just talking about the suit. We're talking about all the variables that we've just mentioned, where you're using the suit, inserting figures that are physically interacting with one another in a rolling fight in court in a criminal case in front of a jury. This would be the first time, right?
With this close contact, yes.
Okay. And I think you said, at least according to your CV, you're actually the only company in the country using the wireless motion capture suits for reconstruction purposes.
Correct.
So there's no issue about whether your peers or fellows in the industry are doing the same thing for this kind of thing. You're the only guy who does this that has those, right?
Correct. There's a limited number of the company that makes the suit differentiates it from all the other suits that are available.
And while I think I understood you to say that you are you know how to use the software, you don't know anything about the inner workings or the algorithms. You're not a code writer or software engineer or anything like that. Am I right?
Correct.
Okay. So if the program were not working properly, unless it shut down completely or started giving you crazy results, you wouldn't necessarily know that, would you?
I verify whether it's operating correctly or not.
Okay.
It's been calibrated at the factory, and also every single time that I use it, I calibrate it myself.
Let me go to the suits in particular. In this case, what you did is you got the raw data, I think you said, from the total station, and then you went out to the scene and you did your mapping thing, and then you put 2 people in suits, right?
Correct.
Okay. And out there at the scene, basically you told them what to do, right?
According to, yes.
Okay. Who were these people? Were they male or female?
2 males.
How big were they?
They were relative size to Mr. Martin and Mr. Zimmerman.
How tall were they, and how much did they weigh?
The one who represented Mr. Zimmerman was, I believe he was about 5'8".
Okay.
The person that was representing Mr. Zimmerman was...
So Mr. Martin?
Or Mr. Martin, sorry.
Okay.
Was approximately 5'11".
Approximately?
5'11" or 6 foot.
Do
It's not really that important for the person that's wearing the suit to be the exact size of the person that you're doing the movements for.
All I want to know is, do you even know exactly how big they were? Did you measure these people?
He was 5'11".
How do you know that?
I'm 6 foot. He was virtually the same size as I
So
was.
you did an eyeball estimate based on him standing there near you?
That's all that was necessary.
How much did they weigh?
That wasn't relevant for the reconstruction of it.
Is that do you know or not? I mean, I'm just asking.
They were similar stature to the people that I was representing with the motion capture suits, to Mr. Zimmerman and Mr. Martin.
How long were their arms and legs?
Average size.
Does that mean you did not measure them?
I didn't measure their arms.
Okay. And they got into poses. As I understand it, what the suits do is they give off pulses of energy, whether it's light or whatever it is, that are documented by these cameras that you set up. Is that how they basically work?
No, that's not the way mine...
Tell me how they work.
Mine has 16 accelerometers, and just like your iPhone, when you move it, it will register the movement. So with these 16 accelerometers, they send a wireless signal to my laptop, which has antennas that accept the signal. Then they take that and they apply it to a figure represented on the laptop.
They meaning what does? You said they take the signal. What takes the signal?
The antennas that come in go into the software, and it's applied to the character that's in the computer. And the
pulses given off by the accelerometers, are they...
The pulses from the accelerometers, it goes into, there's 2 transmitters that fit on the back of the suit, and those send the signal to the laptop.
So does each accelerometer have its own sort of unique code or pulse?
Yes.
Okay. And when you're rapidly moving around, are you telling me that you can differentiate, or that the antenna differentiate among each of them?
Yes.
Okay.
And you also have a green light to make sure whether it's functioning properly or not.
Whether what is?
Whether each of those accelerometers are functioning and sending a signal properly.
The version of this animation that you played for the court this morning, is that the final version now?
Yes.
Okay. How many prior final versions of this have there been? In other words, how many have you tendered and then had to change again?
There was 2 prior versions, and they were adjusted for more accuracy, according to the witnesses.
Well, and that's sort of where I want to get to, is you actually you adjusted based on witnesses. You haven't actually ever read or listened to the actual testimony from the witnesses, have you?
There's police reports that...
Courtroom testimony, not police reports.
Not the courtroom testimony, no.
In fact, what you did is you changed them based upon what Mr. Zimmerman's attorneys told you people said in court.
Yes.
Okay. And that actually apparently was different enough from the way you'd originally created the animation that you have changed it at least twice.
Just to be more accurate, yes.
Do I understand that most of what you do is, when you say reconstruct a crime scene, you take known points, things that are mapped and known and static in their position, shell casings, trees, sidewalks, that sort of thing, and that is reconstructing a crime scene. When you start adding figures and animation to it, what are you doing?
That's also creating the crime scene. What I do is I take coroner's reports, all the discovery, specifics about the scene, total station data, if it's available, my gathering of data, and I put it into context. Sometimes when a jury receives, say, a coroner's report, for example, and they talk about the angle of a bullet trajectory, the jury they get that angle, but they don't really know how that applies to the scene, or how is that relevant, and what position they would be in the scene. So what I do is I take all the different aspects of the case and put it into context.
All right. Exactly which pieces of evidence, let me rephrase that. Exactly which testimony did you incorporate into this animation?
There was Jeremy Weinberg's.
Did Jeremy Weinberg testify in court, to your knowledge?
Are you talking about testimony, or are you
Yes,
talking
sir.
about police reports or
Specifically
discovery?
testimony. I understand you had available to you a bunch of stuff. I want to know what actual evidence, courtroom testimony, was incorporated into this animation.
It was Jennifer Lauer's testimony, John Good's testimony, and Selma Mora, I believe, her testimony.
Okay. You show in this animation an initial contact between 2 figures, represented, I assume, to be Trayvon Martin and George Zimmerman, right?
Correct.
And whose testimony did you use to describe that initial, to depict that initial encounter?
Part of it is off of the, from the discovery that you gave us was...
I'm sorry, maybe I wasn't clear. Whose testimony did you use?
Oh, testimony?
Yes, sir.
Your Honor, maybe you could clarify, is he talking about trial testimony or just pretrial testimony?
Well, I think that it has to be consistent with testimony or evidence presented at trial.
Certainly,
That's
and
what
of
the
course,
case
all
law
of,
says.
and all of Mrs. Zimmerman's statements are in trial, so if the witness is aware of that...
Well, the witness could testify what he used, and that's what the question is.
I think he was confused by trial testimony.
Okay, well, I'll go ahead. Please let me finish. It has to be trial testimony or evidence. So the question to you is, what trial testimony and or evidence did you use to incorporate into your animation?
For the initial contact, it was Jennifer Lauer's statement.
According to what you understand her statement to be, you believe that she saw that occur?
She didn't see it occur, she heard it occur.
Okay.
That was the point.
You are, however, depicting it visually, right?
Correct.
Okay. She certainly didn't testify that she could depict it visually, right?
She just pinpointed the initial contact point, where it started.
She pinpointed it?
At the T intersection to the left of where she was in the condo.
Somewhere to the left of her condo is where she first heard things, correct?
Correct.
Did she ever say that it must have started there? It's not mine. Mine's here.
It was on vibrate, and it's not vibrating anymore, but it's not yours. Okay, go
No,
ahead.
Your Honor. Oh, I'm sorry. Your indication is that she, according to you, somehow testified that she knows that it must have started there?
I have a question.
If you want a clarification, you can ask Mr. Manti what you
Okay.
want clarified.
So for evidence, which the judge was asking, does that include police reports?
No, sir. I want you to assume that anytime I'm asking you about actual evidence or testimony, I mean something that has gone on in this courtroom during trial, okay?
Okay.
What someone said outside of court, for right now, I want you to assume that that is not evidence, okay?
Your Honor, that's what I was trying to clear up earlier. It may not be asked to Ms. Lauer, but the witnesses got to identify, you got to understand what's in trial. And if we
Okay,
can
I will
put-
explain that to him, but I don't want you,
Try
by
not
your
to- try not to
objection,
torture.
by your objection, trying to infer to this witness how he should answer.
Exactly.
So, it would be anything heard by the jury in this courtroom, either heard or seen, by way of testimony or evidence introduced. That's what he means
Well,
by
I'm
a trial.
not sure what that is because I was not allowed to watch the trial, so.
Well, then that's your answer.
Okay.
So then if I were to ask you, does this animation accurately show what has been testified to in this trial, is your answer you don't know?
I'm not sure what the proceedings, what went on in court.
Okay,
So according to the evidence that I've received and from your office,
well, I'm not talking about the discovery matters and all the stuff that you used initially for the first set of animations or the underlying stuff, and I'm not talking about what a lawyer may have told you. If I were to ask you, does this animation accurately show what has been testified to in evidence in this courtroom, is your answer, you don't know. And again, I'm not...
my answer to that would be yes.
Your answer is...
If it's not in my consultations with the attorneys, it would have changed. So it's been adjusted to testimony in court.
None of which you have heard or observed yourself.
Correct.
And none of which evidence you have actually seen yourself.
None of the evidence which has been in court, yes.
Okay. So, part of this animation shows this initial encounter where these two figures kind of walk up to each other. And I understand you believe that the victim in this case, Trayvon Martin, was left-handed. Am I right? You said that?
I believe so, yes.
Okay. And you don't show anybody jumping out of a bush, for example. No?
There was no evidence to support that.
Nothing. Okay. And you don't show anybody just sort of emerging out of the darkness or running out of the darkness. It's just these two people kind of walk up to each other and stand face to face for a while, right?
For seconds, yes.
Okay. The animation also, you do show and plot the location of various items, cell phones, flashlights, sprinkler boxes, right?
Correct.
And sprinkler heads,
Yes.
right? A couple trees.
Yes.
All right. And that's sort of in almost a 40-foot swath along that sloped ground that you've described, right?
Correct.
Okay. However, the animation I saw kind of just takes a big white arrow from the point of that initial walk-up encounter and zooms to a place 40 feet away where essentially we then start to show the two figures bound up together, right?
Correct.
And the reason for that is
Because
when did they get teleported or what?
that just shows the direction of Mr. Martin and Mr. Zimmerman, consistent with witness testimony or witness reports, police reports, and with the trail of evidence going down that direction.
Okay. The trail of evidence, you'd agree with me, is just a trail. It by itself doesn't have a direction, right? In other words, whether it's going left to right or right to left as you're looking at it, the place where things are found doesn't independently have a direction until you start bringing in what other people have said about how it happened, right?
Correct.
Okay.
The reason for the arrow is moving from the one witnessed event down to the next witnessed event.
Okay.
I didn't add anything in between there in terms of movements of the figures.
Because the animation cannot show it because you have no idea how it actually happened, right?
Correct.
Okay. Now, when we get to where the figures again reemerge, you have a figure that you show to be, I guess, represented to be witness John Good, right?
Correct.
How tall is John Good?
6 foot.
And you know this how?
I was given that information from the attorneys.
Okay, so again, not from anything that came out in court, but from the attorneys?
Yes, you got it from Mr. Good.
Okay. And where was he standing?
There's a sliding glass door, and the right side slides over. He was on the right side of the sliding glass door, the right door, about a foot out from the door.
About a foot? And where do you get that from?
Mr. Good.
From Mr. Good's in-court testimony?
From consultation with the attorneys.
Okay. And as far as where on the patio he's standing, did you just pick a spot where you put the figure?
It's just straight out from the door 1 foot.
So you don't know whether he stood to the left of the door, to the right of the door, straight out from the door, wherever. You just picked a spot.
I didn't pick it. That's where he said he was standing.
Where he said he was standing when he was here in court?
Through consultation with the attorney.
Okay. Was that before court?
I'm not sure when it was.
You have no idea?
It was during trial, but I'm not sure when.
Okay. And he told you exactly where on the patio Mr. Good was standing?
Yes.
Okay. That patio is how big by how big?
I don't have the exact measurements. I believe it's there's 2 pillars on the corner, and I believe it's about 7.5 feet from one pillar to the other pillar.
Did he tell you he was standing within 1 foot of this pillar or 1 foot of this pillar?
He
Or
told
anything
me he
like
was
that?
standing 1 foot straight out from the one door, which is where I placed him.
1 foot.
Yes.
All right. Let me start with something else about the animation. It is true, is it not, that, and I should rephrase that, I'm not really starting. It is true, is it not, that the animation actually contains artificial light? In other
Correct.
words, okay, so it purports to show things even though you know it was dark outside.
Correct.
Okay. And my understanding is that you made intentionally no effort whatsoever to accurately document the lighting conditions or anything else.
Because the most important thing with the video is
that a yes or
seeing
no?
detail. Yes.
Okay. So the most important thing on the video is seeing detail, even though you know that that wouldn't have been the detail that night.
Correct. There's plenty of other people can testify to the lighting conditions.
Okay, so if I were to ask you if the lighting conditions portrayed on that animation are an accurate representation of what they were that night, you would say no.
You're correct.
Okay.
I would say no.
And in your decision about where to place the people, now your decision about where to instruct the people who are wearing the suits to go and what positions to assume, that was all done months before any in-court testimony, right?
Not months. It was probably within the month before.
Okay, within a month before, but certainly prior to any trial proceedings.
Correct.
Okay. And you told them based on your best estimates as to what materials you'd been provided by the defense attorney.
Based on the police reports and the interviews, yes.
Right. And how many interviews did you actually read?
There was Jennifer Lowers and John Goods. There's a couple, there's 3 handwritten reports.
Handwritten, like witness statements, you mean?
Yes.
Okay. And that's it?
Yes.
Okay. So based on those, you told these people wearing the suits where to go and what to do?
Based on that, plus based on the 911 call.
Okay.
And timed it with the 911 call.
Well, let me get into that. The 911 call is actually placed by Jenna Lauer, correct?
Correct.
Jenna Lauer saw none of this, correct?
Correct.
Okay. Yet you build into, and John Good, from whose perspective a lot of this is shown, was not on the phone with 911 at the time, right?
Correct.
Nonetheless, you take Jenna Lauer's 911 call and show figures doing certain actions at certain points in that 911 call, right?
Correct.
Now, I understand why you might be able to pinpoint the gunshot in the 911 call, right?
Right.
But as far as any of the rest of it, do you have any idea where those figures were actually at any point in the audio of the 911 call and what they were doing?
The only figure other than Mr. Zimmerman and Mr. Martin is Mr. Good.
I'm talking about Mr. Zimmerman and Mr.
I
Martin.
think he was in the middle of explaining the answer. I request he be allowed to.
Were you finished with your answer?
No.
Okay, you may finish your answer.
Who specified when he came in during the phone call, during the 911 call. On the video, he specified when he came in, how long he was out there, and when he went back in.
I'm sorry. On what video did Mr. Good say that he came in during a specific point of Jenna Lauer's 911 call?
That was through consultation with the attorneys, his modification, adjustments of the video and its placement.
I'm sorry. Are you telling this court that you were told that John Good stated exactly where he was during portions of Jenna Lauer's 911 call?
How long he was outside?
Okay, not how long he was outside. I want to know, you have matched specific audio from that phone call to specific actions both by John Good and the 2 figures on the ground, right?
Correct.
And what I want to know is what in-court testimony or evidence you were actually provided that tells you John Good saw 2 figures doing X at the time Jenna Lauer was saying Y.
There's not any in-court testimony on it.
Okay. There's not any out-of-court testimony about it either, is there?
There's consultation with the attorneys on how long he was out there, when he went back in, and when he came out.
Okay, and this is, so again, you're integrating the visual perspective of one witness who's has no idea what Jenna Lauer, right? John Good has no idea what Jenna Lauer might be doing because they're not even in the same house, right?
It's not just based on Jenna Lauer's call, which he couldn't hear at the time, but he can base it on when the gunshot went off.
Well, I understand when the gunshot went off. But what you're telling this court is prior to the gunshot going off, or even afterwards, but certainly prior to the gunshot going off, that John Good, visual witness, and Jenna Lauer, audio witness, neither of whom know anything about what the other's doing at the time, that you can somehow match up exactly what John Good is seeing at the exact moment Jenna Lauer is saying something?
If you take the 911 call where the gunshot went off, and if Mr. Good said that he was in the condo a particular time before the gunshot, you have a point when he went into the condo. He has a particular time of how long he was out there. So if you backtrack from the gunshot, you can determine from those when he came out and when he went back in.
Those times, of course, are absolutely not exact. Those were all complete estimations, correct? And right? I mean, John Good never said, I got a stopwatch and I can tell you 30 seconds before the gunshot I went inside. Nothing like that, right?
It's an estimation on his part,
In
correct?
fact, okay, and therefore it is also just nothing more than an estimation on your part. I mean, you can only put in...
It's based on a witness that was there that said how long he was out there.
Okay.
And how long it was
Here's what I want.
before the gunshot went off.
Here's what I want to focus on, sir, is that animation is very specific. You play a portion of that audio recording in conjunction with supposed actual video or simulated video from John Good's perspective, all based on nothing more than estimations.
By the person that was witnessing it.
Okay. And therefore, by you as well, because you can only put in what you've got to work with, right?
Correct.
Okay. So none of that could be said to be exact or accurate to the point that you can say for certain that that's what he was seeing at the time Jenna Lauer was saying a certain word. Right?
I don't think it has to be specific to the exact word that she was saying.
Well, your animation, though, makes it very specific, doesn't it?
Yes.
There's nothing in that animation that tells me the call is generally going on now, and I'm not sure exactly what part this is. That animation shows exactly and sounds exactly that these things are going on at the same time, right?
Correct. This is a scenario according to witness and evidence.
I'm sorry. Which witness and which evidence that came out in court? Or are we back to estimations based on what attorneys told you?
Consultation with attorneys.
Okay.
On his movements.
Would you agree with me that there's no way John Good could ever say, at the time Jenna Lauer was saying this, I was doing this?
I don't think that's what he based his
I'm not
time
asking
for being out there.
I'm not asking what you
He
think.
can't say exactly according to what she was saying.
And in fact, he was gone from any visual view while Jenna Lauer is still on the phone and for a period of time before that gunshot ever happens.
Seconds.
Okay?
It's
But
not
no
a
one
period.
knows, no one has clocked exactly how many seconds that might be because nobody had a stopwatch on it, right?
Correct.
Okay. Nonetheless, that animation purports to show it, right?
Yes.
So is the animation purporting to be more accurate than we know the evidence really can be?
The purpose of him involved in the animation isn't so much whether he was outside for 10 seconds versus 7 seconds. It's putting him into the location and showing what he was able to see at that time.
Well, but you don't know what he was able to see at that time because you don't know exactly what was going on with the call, right?
his estimation is based not on the call, but on when the gunshot went off.
It is estimation.
They're overlapping.
It is estimation upon estimation upon estimation. So when I ask you if that animation purports to show more exactness, more accuracy than the actual witness testimony and evidence, would you agree with me?
I can only do it to the point of the witness.
I understand there are limitations to the animations. What I'm trying to get is this was created, but you're not pretending that it's an accurate depiction of what went on. You're positing it as an estimation, right?
According to the witness that was involved.
Whom you've never actually heard testify.
Correct.
Okay. You would agree with me, too, that there is a point in time where Mr. Good is not seeing anything, but you still show things going on in the animation as though we were looking from his perspective, right?
You'd have to be specific on what point.
Okay. There's a point where the figure that represents John Good turns and exits stage left.
Correct.
Nonetheless, we're still treated to a view of two figures on the ground.
Correct.
What witness testimony are you relying on for your depiction of those figures and what they're doing at the time, since John Good is no longer there?
That was based on Mr. DeMaio's positioning of Mr. Zimmerman and Mr. Martin.
You didn't hear him testify today either, did you?
That was in consultation with the doctor.
Okay. And that conversation was a 20-minute phone call last Saturday, correct?
Yes.
And that was after you had actually been deposed twice and thought you were done making changes to the animation, right?
Correct. That was the first time I was able to talk to him.
And you changed it. You had that conversation because you were asked to call him, right?
I wasn't asked to call him, no. I asked about the doctor. They said he was standing by for me to talk to him, and so I talked to him.
It wasn't your idea to make yet another animation after you'd been deposed twice and said you were done until you were set up with speaking with this doctor, right?
No, it was my idea from the start that we needed physical evidence of the positioning when the shot went off.
And are you saying that the current animation is based on physical evidence?
Based on the evidence or the testimony, a consultation with Dr. DeMaio.
Difference. It's not based on the testimony as far as you know. It's actually based on your 20-minute phone call to the man on Saturday, right?
Correct.
Okay. And I think you also told me yesterday that the one thing you know for sure is that the entry of the bullet wound, again, based upon that phone call, was directly 90 degrees straight on, right?
Correct.
And that's why you have the figures at the end of that animation, so not at the end, but in what I'll call position 3, or third position as you've labeled it. You tell me that they're parallel to one another, right?
They're horizontal to each other, yes.
Okay, and not only horizontal, but parallel, because that's how you show them in the animation, right?
Yes.
Okay. So virtually stacked on top of one another, like Lego blocks or something.
No, there's space between them.
And that space is based on what?
It's based on talking to my conversation with Dr. DeMaio, and also in creation of the scene to be able to fit the characters together.
How big is that space?
From where? Between the one person and the other?
Sure, between the two bodies. How big is that space between those two people who are parallel?
Between the clothing or between their bodies?
Well, let's start with between the clothing.
It varies. In my third position, I'm not quite sure. I haven't measured between the two bodies, but from the ground, it's approximately 13 to 15 inches.
Approximately? And you haven't measured between the two bodies?
That wasn't the purpose of the final positioning. The purpose of the final positioning is to show who's on top and who's on the bottom.
The purpose of and I'm not talking about the final positioning, I'm talking about third position now.
Correct.
And the purpose of that is to try to create something that resembles the defense theory. I understand that, right?
Not to resemble what the defense theory is.
Is it to resemble some other theory?
Dr. DeMaio's, his positioning of them.
Okay. Based upon your 20-minute phone call to him?
It doesn't take long, yes.
Okay. And he told you that they were X inches away apart from each other and at X angle to one another?
The positioning of Mr. Martin bent over Mr. Zimmerman.
Is that a yes, that he told you exact distances, or is that a no?
The distance varies according to what my conversation with him was. It can vary between 2 inches in one spot for the clothing and 4 inches in another.
Well, that's distance between the clothing and the gunshot wound to the chest of the person who got shot, right?
Correct.
Okay. Have I asked you about that space yet, or that measurement?
Well, that will depend on positioning.
And all of that
person on
stuff,
top.
I'm sorry, were you finished?
Yes.
All of that stuff varies, as you said, is estimations, right?
Yes, but in this particular positioning of their particular positioning, the purpose of their positioning wasn't to get so specific that you could measure and that you could have a camera there measuring exactly the distance between them and show that point of view. Otherwise, I would have put a camera there to show that point of view. The purpose of it was to show who is on the top and who is on the bottom.
So the purpose of it is not to be accurate as it actually happened. It is simply to show positions of figures?
Correct. Otherwise, I would have put the camera in another location to be more specific.
So do you know whether that animation accurately depicts how those figures were in relation to one another that night?
Yes, according to Dr. DeMaio, that's the position that they're in, which is consistent with his findings.
That position being parallel to one another with an unknown distance between
They're not completely parallel in the third view.
I'll let the animation speak for itself. So if I were to ask you, are you basing this on your phone conversation with Dr. DeMaio or his actual in-court testimony about the possible positions of these people? You would say it was the phone call.
Yes.
Okay. I think you said earlier that sometimes when you measure bullet trajectories, especially as it goes into bodies, you use a metal rod of some sort?
I create a rod in the computer.
Did you do that in this case?
I wasn't showing the bullet trajectory in this.
So, and in fact, that animation doesn't show the bullet trajectory, the firearm, or anything like that, does it?
That wasn't the purpose of the animation.
I understand, but it doesn't show any of those things, does it?
No.
And in fact, you were actually specifically asked to leave the gun out of the animation, weren't you?
No.
Did you ever tell me you were?
I don't believe I was told.
Page 27 of last Wednesday's deposition, counsel. Okay. This would be deposition number 2. May I approach you on?
Yes, you may.
Mr. Shoemaker, do you remember talking to me? I guess it would have been last Wednesday. That would have been your second deposition in the case. You were still in California?
Yes.
On yes, I did. All right. I'm going to show you here, page 27, and I'm going to begin at line 4. Do you see that question answer?
Correct. It wasn't a.
Go ahead.
I don't believe it states that I was told to leave it out. It says in consultation with the attorney.
Do you remember the question, were you requested to leave the gun out or did you make that decision on your own? And your answer was, I didn't make that decision on my own. I believe it was just consultation with the attorneys. Remember
Yes.
that question answer?
It was in consultation with them.
Okay.
So my input and the attorney's input.
So you specifically decided not to put the gun in.
That's not the purpose of this video.
Is that a yes or a no?
I did not put it in.
Even though you certainly knew that that gun was there that night.
Correct.
Okay. So the video omits that.
Correct, because that's not the purpose of the video.
The conditions in which you filmed these folks in the suit.
You mean recorded?
Right. I'm going to start with just, you filmed them, I assume, outside in the daytime, rolling around so you could see things, right?
Recorded them, yes.
Okay. And
Not
did,
filmed.
when you recorded them, I mean, obviously, well, maybe not obviously, let me ask it this way. Were these folks moving in a rapid pace as though they were actually fighting one another, or were they getting up, assuming a pose, and then waiting for your direction to get up, go, and assume the next one?
Let me object, Your Honor, to this and the relevance. Though they were moving in previous, may I speak to the objection? No.
Yeah, well, your jury's not here,
Okay.
it's fine.
While in previous animations, we had movement, hands swinging and things like that, in response to some concerns about the state, we actually eliminated all of that. So as I mentioned to the court, and as you've seen, they are individual frame videos, so question of animation, of movement, is no longer relevant for the court's consideration. That's my purpose of a relevancy objection.
Can you clarify that?
Well, I would beg to differ because, of course, the very first part of that animation most assuredly contains movement.
Absolutely, but I think what we're talking about was the part where they were moving from that location down. That was
Well, clarify what your question is,
well.
please.
Any point in the video, all right, the animation, when you are reproducing and filming the motion capture suits in action, right?
Yes.
Whether it's the first interaction between these people, the subsequent positioning of the bodies, any of that, okay?
Yes.
And I know that at least some of that motion is still on this animation, right?
The initial movement.
Okay. Talk to me about the conditions in which that was filmed. I assume it, for example, was filmed in the daytime.
Correct.
Okay. I assumed it wasn't raining.
Correct.
Grass wasn't slick.
Correct.
Okay. There weren't these other items of physical evidence out there.
Correct.
Okay. Did you go out ahead of time and place markers down where you knew the items would have been according to the measurements that you'd received ahead of the filming?
We measured the areas from the drain boxes and the sprinkler boxes to get the correct position.
Who told you what distance the bodies were from the drain boxes and the sprinkler boxes?
Placement of their position was based on the shell casing, position of the shell casing, position of Mr. Martin's cell phone, and where it was in relation to Mr. Good's condominium.
Okay, so I guess let me ask you like this. It can be a couple different types of questions. First, when you're filming this motion, this interaction between these people, are you trying to go to the exact location where you believe it happened based upon the testimony, or are you just filming this in action and then later on you plug that stuff into wherever you want to on the animation?
It's best to record it when you're on the scene, to record it in that location, because you can interact with like the slope of the grass and other elements. But once that's on the scene, and the scene is created in the computer, then you can take that, drop it into the scene, and adjust it so that it's most accurate.
So when you were at the scene, you hadn't already, for example, measured exactly where the shell casing was and like put a dot, or had you?
We laid out little markers.
You did lay out
where they were.
markers. Okay. Now, do I understand then, in the second part, or second series of questions, you then just took the figures and put them in exact locations vis-a-vis things like the shell casing and the porch. In other words, say, for example, 6 feet from the porch and 3 feet from the shell casing. You put the figures in a specific place, right?
Correct.
And you did that based on what evidence and testimony as to the exact location of the figures?
Are you talking about the ones straight out from Mr. Good's condominium? All the still figures from that? Those were placed there based on Mr. Good's testimony and in consultation with the attorneys.
Okay, let me talk about position 3, for example. My understanding is that you placed the figures where they were in the third position based upon your belief as to, your knowledge of the location where the shell casing was found, and your belief as to the ejection of the shell casing from that firearm that's not in the video, right?
Correct.
Okay.
That's one. And relative to the position where Mr. Zimmerman was found.
You mean Mr. Moore?
Or Mr. Martin, sorry.
Okay, but that's position 4, right?
Correct.
All right.
But
Position
3 is relative to 4.
Okay, I'm going to stick to 3 for the moment, all right? You said that you put the figures in a certain position relative to the shell casing. Now, to my knowledge, no one testified about being this close to the shell casing. So is this an estimation on your part based upon you thinking that the gun must have ejected to the right and the shell casing must have gone X distance?
Correct. It's just in proximity to the shell casing, so that the shell casing is on the right of Mr. Zimmerman.
On the right, but in other words, 2 feet to the right, 3 feet to the right, 4 feet to the right. You really have no idea exactly how far that would be.
It can't be that far away from where Mr. Martin ended up. So the proximity of evidence marker number 6 has to be pretty close proximity to the third position.
I understand generalized proximity. What I'm getting at is, would you agree with me that how high the gun is up off the ground might affect how far that shell casing goes and therefore where it lands?
There's a lot of variables that could have...
A lot of variables. So, again,
not innumerable variables, but...
None of those variables for which you had actual direct evidence, right?
Just that a shell casing ejects from the right on a 9mm.
You just found it. We know where it was found, but we have no idea where it came from. We know where it landed, not where it took off.
We know approximately where it came from.
I'm asking, your animation shows these figures in a very specific spot. What I'm just asking you is that an estimation based upon your estimation about how the shell casing got there?
It's based on their last position and based on their previous position and based on their last position and based also on the shell casing, location of the shell casing.
The last position, the fourth position,
correct,
is what happened after the defendant claims that he shot Trayvon Martin that Trayvon Martin fell off him, that he then jumped on Trayvon Martin's back and moved a portion of his body, right?
Correct.
And we have absolutely no idea exactly how far that happened. We just know where the body ended up being found, right?
It's in close proximity to the final position.
I understand it's all in proximity. This whole thing happened within a 40 square foot area.
Well, you're not really giving me specifics. Are you talking 5 feet from where I have them? Are you talking 3 inches from where they are? Or
Well, what I'm asking you is, why does your animation give me those specifics?
because it's to the one side of the shell casing, it's to the other side is the cell phone position. Plus their previous position is just up the slope from their third position.
The animation itself is based on a series of estimations.
Can I interrupt you for just 1 minute?
Yes, sir.
I saw that animation one brief moment from a computer, and although I remember generally the things that you're talking about, but specifically positions and stuff, it would be helpful to me if we had the animation up and you had him explain the positions that you're talking about, because
Do you have your laptop still there with you, sir?
have we figured out a way to put
I
it up?
think we can get one of these several computers that has the animation on it to work now.
Okay,
So if
can
take
we
about 2
please do
minutes.
that, because I'm really trying to follow the testimony, and without looking specifically at each figure or position you're talking about, 3 and 4, it would be helpful to the court if I had that in conjunction with the testimony.
Sure.
So can we try to do that?
Absolutely, Your Honor. You're doing yours. Let's try something that's PC friendly, right? That's our best chance, I think. I'm sorry? Your laptop
Can we
is
get the
working?
screen down?
Yeah. Okay, let's get a projector warmed up and your laptop cranked up. Why don't you question it from your table? If you roll. Look it up first.
And if I could, I think you have stills of position 3?
You have it here?
I'm not
Sure,
sure.
you can stop it, right?
Yeah, I can stop it. I don't believe I have position 3.
Is there a position 3 still? No. Go ahead and just fast forward it now to position 3. Okay, right there's the one.
Okay.
Okay, so.
You want to run it?
Start right there. Use-
Okay.
So now we have an illustration, sir, of third position, right?
Yes.
Okay. And I know the things in the yellow circles are items of evidence, physical things. One of them is the final resting place of Trayvon Martin's body. One is the shell casing, right?
Correct.
Okay. And the place that you have these vis-a-vis those items in the yellow circles is an estimation.
The
right?
placement of the yellow circles?
No,
is
sir.
an
The
estimate?
placement of the figures with respect to the yellow circles.
Correct. They're positioned in between the items of evidence.
They're just generally speaking in between them, but as far as telling me that they should be in exactly that location as opposed to a few degrees to the left, a few inches or a few feet to one direction or the other, you couldn't really tell me, because that's, of course, not what you're trying to do with the video, right?
Correct.
Okay.
Their positioning relative to each other is the purpose of the video.
Well, and you also, speaking of that, even their position relative to each other, you couldn't tell me exactly what angle the person's head who's on top there should be, right?
Correct, because it wasn't still, so.
Right. The whole thing is actually moving, so again, this is in sort of an estimation.
What part of it are you talking about as an estimation?
The actual positions of the figures. And I'm talking not...
It's not an estimation, it's a placement according to Dr. DeMaio.
Dr. DeMaio told you they looked exactly like that?
Their positioning, yes.
I'm sorry, he described that exact degree of tilt and everything to you?
Within 2 inches.
How many inches did he say Trayvon Martin's head was off the ground?
That wasn't relevant.
Okay, so the answer is, again, this would be an approximation, because you don't know the exact answer to that question.
Approximation of his head?
Yeah.
Yes.
Okay. As far as these white things that are depicted here, these are the sort of the sprinkler boxes, the hard plastic boxes that are out there?
Sprinkler boxes and drain boxes.
Okay. Those hard metal or plastic covers, whatever they're made of?
Correct.
Okay. Now, you also, do I understand it, reviewed at least one of the statements of the defendant, in this case, George Zimmerman.
That was supplied to me. I'm not sure which one you're talking about.
Did you use any of those to create this animation?
Any of the animation, or what part of the animation you're talking about?
Any part of it.
The initial, some of the initial portion at the T intersection.
Okay. And that is it?
Yes, all the rest are based on the other witnesses.
Okay. So all the rest of it is based on something other than what the defendant's statement was. And which statement of the defendant are you talking about?
The video walkthrough.
Okay. That is the only one you used?
Yes.
Is there some reason you didn't use any of the others?
Because I had other witnesses that placed that in the police reports positioned them throughout the animation.
Let me be more clear. You only used it as it relates to the beginning of this video, where you see the two figures walk up to each other and then one of them punches the other, right?
Correct.
Okay.
And I used it in conjunction with Jenna Lauer's testimony about that is where the initial conflict took place.
Is there a reason that you only used the video walkthrough statement as opposed to any of the other several statements? Or did you just pick that one because it was the longest or whatever? I mean, I'm just asking.
I had other witnesses that laid out the scene from then on.
Okay. Talk to me about, and if we can, I'm done asking questions about this, Your Honor, so. Thank you. I'm not even going to start with that.
You can just close it.
Okay. Talk to me about any types of validation that have been done with this particular method that you use to create animation.
Any other validations on?
Right, on either the several types of software or programs that you have used, have those, other than just buying them and assuming they're working right and that they're not at least failing to work for you, are you aware of any sort of validation studies that have been done on any of them?
Validation studies on the motion capture suit.
Only on the suit?
Motion capture suit, and also the 3D software that I use. It's used by engineers, and with all the time that I've spent using it, if there was some inaccuracy in any of the measurements or in using the software, I haven't found any.
Let's talk about how accurate it is. Are these things accurate to what measurement? In other words, are we talking hundredths of an inch, thousandths of an inch? What are these measurements designed to be specifically accurate to?
As accurate as you want, thousandths of an inch.
What did you set them to here?
Just what was relevant to what I needed in terms of positioning of the items, measuring, for example, from the porch to the shell casing, and
okay.
There wasn't anything in this that required thousandths of an inch of accuracy.
And I think I perhaps asked it and didn't follow up earlier when I asked about when you're directing the people who are wearing these suits and they're engaging in whatever behavior that you're having them engage in. Are you telling them to sort of go at it with a simulated fight, or are you telling them to simply, pose this way, stop, move, go this way, that sort of thing?
Just move according to what the witnesses wrote in their police reports, in terms of what position they were in, what they were doing, for example, ground pounding or that type of movement, and just to how they would naturally interact with the ground and the slope and the sidewalk.
So you were sort of almost like directing a movie, saying to an actor or an actress, go here and do this. They weren't just doing it on their own?
Correct. It was based on the location of evidence on the scene, the type of surface they were on, what was written in the police report in terms of what they were doing at that location.
When we're talking, for example, about the actual motion, for example, at the first part of that tape, where there are figures in motion, did you have them attempt to simulate the actual speed of that, or did you just simply have a person in a capture seat make that motion and then you adjusted the speed using the software?
The swing and the reaction to the swing is, it wasn't sped up. That's the natural movement.
So that's as fast as the actual actors happen to do it?
Correct.
Any idea whether that's accurate as opposed to simply another estimation?
It was just a movement portraying that occurrence.
So as to whether it's...
And how somebody doing that motion, recording somebody doing that motion.
If I were to ask you, can you tell this court for certain that it is an accurate depiction of the motion and the blow that it's supposed to depict, you'd have to tell me no, right?
as an accurate movement of somebody swinging and striking another person in the face.
Just as the actor decided to do it.
As a human would move. There's other ways of doing that reconstructionists do animation, which is hand animating on the computer, where you take a 3D figure, move an arm, advance it some frames, move the arm again, and so they're just estimating about the way something really moves. With the advantage with the motion capture suit is you put the suit on, and that's the way a person will move.
But that's the way that person on that day, while you had the suit on them, moved.
Correct.
Okay. You can't tell me that's the way that if we assume it's one figure is Trayvon Martin and one is George Zimmerman, you can't tell me that that's actually how they did it that night.
This is just portraying one person coming up and striking another person in that manner. With respect to their heights.
Do I understand that the conclusions, if we call the animation a conclusion or a depiction, that this is not necessarily your opinion, but it is what you have attempted to create based upon essentially what you've been told by lawyers mostly?
No.
No?
It's my reconstruction based on what I was given in discovery, all the different things in discovery that was mentioned, putting the scene together with my actually being out there with the motion capture suit data and fine-tuning it with consultation with the attorneys. So it wasn't, it was something that was created based on evidence and testimony and written reports, not solely based on what an attorney told me to do.
Correct me if I'm wrong. All the actual in-court testimony would have been funneled through the lawyers.
Correct.
Okay.
Since I wasn't able to view in court.
All the actual action out there is estimated based upon your interpretation of what you were given in discovery.
A reconstruction, yes, based on evidence that I was given in discovery.
Okay, and an example of that, again, just to use the example again, is the shell casing. As to, you know where it landed, but you don't know exactly how it got there. So your depiction of the figures in location to it is simply based upon your estimation of where it would have been and where they would have had to have been in some proximity.
And also their previous positioning prior to that, seconds before, and the position, again, of the shell casing.
Okay. And as far as you know, you're the only one who has done this sort of thing with these motion capture suits.
Correct.
Okay. Anything else you want to get to? Thank you. No other questions?
Thank you. Redirect.
Yes. Just to start with the last question first, then we'll go back to the beginning. These motion capture suits, is this just a next generation of motion capture suits than those that existed before with the balls all over them?
Correct.
And
There's
it's
a
just,
lot
more accurate, would that be correct?
more accurate. There's less cleanup time, and the data is a lot cleaner than other motion capture or motion suits like this. And you can also take it into different environments, and it's a lot more flexible that way.
Because these motion capture suit accelerometers are wireless, correct?
Correct.
Do you have to be in direct line of sight with your computer antenna and all of those accelerometers to actually get the signal?
You don't have to be in direct. I could record somebody that goes through the door and on the other side of the wall. Okay. It just has to be within range of the wireless.
So while this is a new generation, are the motion capture suits generally accepted in your industry as a way of capturing motion.
Yes, it's the most accurate way of capturing a person's movements.
The newest and better, but not much different than in concept than what the older motion caption suits capture?
Yes, they're restricted by the fact that they have to be recorded with a camera.
Okay.
And the disadvantage of that also is you don't have data, you can't see the data on the movement of an arm, for example. On this motion capture suit, you can see data of all accelerometers.
And those accelerometers then are hooked in together to software that then recreates the movement of those various accelerometers in the context of a body?
Yes, it captures it all, yes.
Okay. You could put 4 of them on a Frisbee and fly a Frisbee. Could you put them on a Frisbee and fly a Frisbee, and those accelerometers would kick back information to your computer, and then you could recreate the Frisbee spinning as it flies?
Yes, it's also been used. They've also done recordings of jumping out of a plane and recording somebody skydiving with it.
Okay. And then being able to recreate that.
Yes.
Just going back to the beginning, in the concept of the beginning parts of the animation and the modifications of it, have you ever waited until after a trial is over to create your animation? It sounds senseless in the question, but I want you to answer it. Are your animations normally done in anticipation of and in presentation to trial?
Yes.
Okay. And are they normally done with the available information like discovery that's available to you?
Yes, they are.
Okay. And then is that when you have that information available to you, will you go back and modify your animation, your presentation based upon new information if it's given to you?
During trial or before trial?
Whenever.
Or?
Even if before trial. If I were to come to you and say, here's, in this particular case, here's a new piece of evidence, here's a new witness statement we were unaware of, and it may impact on your animation, would you then go back and fit that into the facts that you utilized as the foundation for your animation?
Yes.
And have you done that in the generation 3, or the most recent generation of video that you created, or animation, based upon consultation with me and saying such things as, did you in fact modify the animation as we discussed matters?
Yes, the whole purpose of it is to get it as accurate as possible.
And did I then discuss with you certain testimonies in trial that led to modifications?
Yes.
For example, on some of the stills that you had gone through with the judge, was there changes in those stills based upon actual trial testimony as opposed to deposition or statement testimony?
Yes.
And did you simply take out one text and put in another?
Correct.
And object to continue leading.
Trying to move it along, Your Honor, and make it.
You can lead.
I understand. Were there changes that you made to the stills based upon testimony?
Yes, it's not a change it's more of a defining it better.
Where did you get that information from?
Consultation with you and Mr. West.
And what was discussed with you during that consultation?
What came out in court and testimony.
And based upon that consultation with either Mr. West or myself, did you make those modifications to the stills?
Yes.
As to the, we were talking about the point of, have you ever waited until the middle of trial to begin the creation process of an animation?
No, I like to begin it as soon as I can, as far ahead of trial as I can.
And in the information that you were forwarded in this case, was information from Mr. Zimmerman's various statements given to the police forwarded to you as well for your consideration?
Yes.
And did you incorporate any of that information into your animation?
Yes.
One part, go ahead.
I look at what his video testimony was and just verify that there's no conflicting or nothing that conflicts with what I used in creating the scene.
Okay. And you had all of his other statements available, the interview statements of the various law enforcement with you, available to you as well, did you not?
Correct.
And the significance, what significance did you attend to Mr. Zimmerman's statements, all of those that are now in evidence presented by the state, in assisting you in creating any portion of your animation?
The initial conflict, or the point where the conflict.
And was that specific to Mr. Zimmerman stating that he was struck?
Yes.
And in a location approximate to the location where he said he was struck?
Yes, where he said he was struck, backed up by Jenna Lauer's positioning of the sound where the conflict started.
And back then, of course, what did you have in addition to Jenna Lauer's statement that you utilized to place the initial location of the altercation?
What did I have?
Who else did you have?
Jeremy Weinberg's police report.
Did you even have other witnesses who said the location was there, such as Jane Sudiker, who was in the apartment back behind the T? Did you have that information available to you?
Yes.
Okay. And was all of that then part of what you utilized?
Yes.
Was there any specific evidence that was found at the scene to assist you in determining that that was the estimate or probable location of the initial part of the altercation?
Yes, the first piece of evidence was the Mr. Zimmerman's flashlight keychain.
How did that assist you in laying out the location that is shown on the video, on the animation, about the initial part of the altercation?
It gives you a direction. So you have the initial conflict that took place at the T intersection. Then you've got the flashlight, which goes down to the direction where the next witness testified that they were located.
Okay. Mr. Manti many times suggested this is just an estimation. Will you acknowledge that if we look at that animation, it is somewhat of an estimation as to their initial location?
Correct.
But is that estimation in conflict with any of the evidence that you are aware of in the discovery that you reviewed?
Are you talking about their initial location? No, it's not.
If, for example, I was to have you recreate the animation of a shell casing discharge and the way it spins from out of it spinning to the ground, would you be able to create an animation that accomplished that?
Yes.
Would it, however, be an estimation to a certain extent of how many actual spins the shell casing may have made in its trajectory to the ground?
Yes, because that would be in the computer where you would rely on the physics in the computer to do the reconstruction of it. But even in the real world, when you do that with any gun, it's going to, each of the ejections are going to vary.
Is there an inherent estimation that exists in the entirety of your industry of, be it accident reconstruction or event reconstruction?
Is there
an estimation variable that exists in every animation that you make?
Correct. There's certain scenarios that you can create, but there's not an infinite number of scenarios. Those that are in conflict with the evidence, with witness testimony, those obviously can't be done that way. So the scenarios that can be created are consistent with testimony, witnesses, and evidence and the scene.
As an example, in your modifications of the animations, did you change, was a decision made in consult with me and others not to show movement of the bodies from the initial location until the location at rest? Was that a decision made?
Yes.
And why was that decision made?
Basically because from witness testimony, we know which direction they moved in, but it's not defined anywhere exactly how they got from that one position to the second, to the position by Mr. Good's condominium. So rather than try to create something, that's why I used the arrow to just show the direction that they had moved into the next position.
Was that then a decision by you as the creator of the animation to avoid creating animation that wasn't documented by witnesses?
Yes.
And then why did you then pick up again, and we're going to go to the last video and just use the stills, where did the information come then to place those people where they were?
The initial position, where it's labeled initial position, that came from John Good. The second position, that also came from John Good.
The initial position.
I'm going to back it up and ask him to, well, it was working. As soon as the projector warms back up, I'll do it, but I'll have him testify to that. Let's be careful that we all talk about the same positions. I'm going to make some definitions and tell me if we can live with those. Initial position was the event that started at the T intersection. Is that, can we use that? Or is that, or do we want to define that as something else?
If we could define it as something else.
Okay, we'll define that as the T intersection event.
Okay.
Then tell us what you mean by the first event.
The first event is the first visual that John Good had on their position. Okay. It's labeled initial position.
Okay. Give me 1 second to convince your computer to work. Okay, that was the one where you had the testimony. It's about to come up here. The first position that you're speaking of.
It's going backwards.
Sorry, give me 1 second. I'll try and get it back to where it needs to be without sounding like the White Album from the Beatles backwards.
You can just grab the little white ball and slide it around.
Just don't use Max. Sorry. Okay. I'm just going to run it through to try and get us all caught up. This is the T intersection event we're talking about?
Yes.
And while we're talking about this, let's talk about some of the frailties inherent in the animation. You do not suggest that there is any witness that specifically identifies, for example, in this case, Trayvon Martin walking just along one side of the sidewalk. Is that correct?
Correct.
That is an estimation based upon George Zimmerman's testimony that he was approached from the left and the back?
Correct. And there was no, I didn't find any evidence or witnesses to dispute.
Okay. So then we have this. That information right there, does that come, where does that come from that gave you the foundation to create that portion of the animation?
From Mr. Zimmerman's video walkthrough and also from Jenna Lauer's and Jeremy Weinberg's police report.
And to a certain extent from Ms. Sediker's also location of the general event?
Yes.
Okay. Now we see the arrow, which we talked about a moment ago. And is that what you had talked about being the arrow instead of having the actual figures move without any witnesses to identify them?
Yes.
Okay. let's stop here for 1 second. This is what we now know to be John Good's sliding glass door.
Yes.
Based upon additional communication either with me or with him, was his position in the area of the sliding glass door modified?
Correct, it was.
And if you would advise to the court how it was and why it was how it was modified and why?
Initially, I had him just coming straight out from the middle of the sliding glass door, but after his refinement of his position, I placed him on the left side, the left sliding glass door, 1 foot out from the middle of the door.
And was that based upon the consultation regarding his specific testimony or his specific recall?
Did the gentleman object to leading?
I'm just trying to move it along, but I'll change it.
Sustained.
What was it based upon, and what information was given to you and from whom that helped you modify it?
It was based on consultation with you and Mr. West on the feedback of Mr. Good in the placement of him in the scene.
Did Mr. Good, from our conversation, look at a animation and then ask for modifications?
Correct.
And is that the modifications that were changed on here?
Yes.
Now, this is where the 911 tape comes in, right?
Correct.
And there was questions concerning why the timing of the 911 call began. So, tell me, was there a point that existed in both Ms. Lauer's 911 call and Mr. Good's testimony as presented to you that was an intersection that allowed you to relate the two together?
Yes, it was the gunshot.
If I might approach the witness for a second, Your Honor. If you're going to see it as well. In effect, do we have a timeline of Jenna Lauer's 911 call with a gunshot at what you know to be about 45 seconds?
Correct.
Whatever it might be.
45 seconds.
And then do we also have a timeline of John Good's testimony and lining up the gunshot on his testimony?
Yes.
And if you line these two up, does that then give you a timeline from which you can estimate John Good's actions on the animation?
It's pretty much just taking the 911 timeline, taking the timeline which Mr. Good had with respect to the gunshot and just matching up that one event.
Let's do that for a moment from your testimony and trying to relate these two. What information did you have from John Good as to where he was when he heard the gunshot and what he had done how many seconds before that?
He was on his way up to make a 911 call, and the time that we had, if you go to the gunshot, you can, if you back up on Mr. Good's timeline, he gave an estimate on from when he went into the condominium till the time that the gunshot went off.
Okay. And did you then simply, if you will, calibrate your animation to Jenna Lauer's phone call, did you then use Mr. Good's estimation of how long it took him to leave the area he viewed until he heard the gunshot before?
Well, I have a question, and let me interject, because in reviewing my notes, Mr. Good testifies that he also called 911, and he was on the phone with them and connected at or about the time of the gunshot. Was that used? Was that 911 call by John Good used in your comparison with the 911 call of Ms. Lauer?
There was no gunshot on his 911 call.
No, but his testimony was he heard the gunshot while he was dialing 911. And in fact, I thought he said he was waiting for that call to connect. So we would know when that call connected in relation to the Lauer 911 call. So did you use that as your basis for the timeline of this 911 call and the testimony of Mr. Good?
He was still waiting for it to connect.
Yeah, my question is, did you use that? Did you consider at all in making this timeline in connection with the animation? Did you? That's a known time when he was calling. His testimony was he heard the gunshot while he was dialing 911. In fact, he was waiting for the call to connect when he heard the gunshot. Did you use his 911 connection in doing the comparison?
I used his estimation from how long it took him to get up to make his call.
Okay.
To further the court's inquiry, if you were to have the time of the phone call and estimate from there the time it might take to connect, would that help calibrate the animation even more refined?
Yes.
Okay. And would that be able to be accomplished tonight, for example, if I gave you the timing of the call?
I wouldn't be able to re-render and redo the animation, but I can do some marking when he came in.
Not to just discourse with you as you're on the stand, but if there was a few second difference, it would require simply moving the audio track of the Lauer call, would it not? The animation would stay the same?
Yes.
Okay. Because that's the only relation, would it not be? As if the gunshot is relating the timing of Lauer's call, that would only change the audio track a few seconds one way or the other, would it not?
I believe it would affect Mr. Good's time that he went into the apartment or into the condo.
Okay. Well, let's go forward on that, presuming that your estimation of your use of his estimation as to how many seconds from leaving the view of the scene to hearing the gunshot is close to accurate. And
well, go ahead, because I don't want to interject what my notes say, but I'll do that in argument when you're doing your argument.
Well, I don't want to miss an opportunity to clear up an inquiry if we can. It's the three of us right now.
Is there any objection from the state?
Objection as to the court asking questions?
Yes.
None whatsoever.
Okay. My notes, and of course the record will correct me if I'm wrong, the only times that Mr. Good gave was that he was at home. It was between 7:05 and 7:15 p.m. when he was watching TV in his living room with his wife, and he heard the noise outside. The other times that he gives on cross was the entire time he was watching was 8 to 10 seconds. He doesn't say where within that time frame he saw the 8 to 10 seconds, but we do know from his testimony that he was dialing 911 and waiting for it to connect when he heard the gunshot. So I don't know how long he was in the house before that gunshot and he's dialing 911, and I don't know what the 8 to 10 seconds were if he says it was either 7:05 or 7:15. So the problem that I'm having to relate to that right now is the use of the Lauer 911 call in conjunction with Mr. Good's testimony. I don't understand where that timeline is coming from based upon John Good's testimony.
My understanding of his testimony, and again, the record, I'll need to review the actual transcript, was that he left the area of the view of the scene, turned around, and immediately grabbed his phone and started dialing.
What time did he go out there? 7:05 or 7:15
He
or
went out
thereafter?
there,
Because I'll read you my notes, and of course the record is what
Yes,
is
Your Honor.
correct. These are just my notes. But he said from 7:05, it was between 7:05 and 7:15. They were watching TV in the living room. He heard a noise outside. First, it was a faint noise, and he didn't think anything of it. He couldn't hear words. Then he heard the same noise, just louder. Seemed like it was getting closer. He couldn't hear any words, and he didn't know if there was more than one person. He went to look out of his glass sliding door, which had the blinds drawn. He cracked the blinds. There was a light on the porch. He could only see someone or something out there. He opened the blinds and the glass sliding door. He took one step onto the concrete, looked like a tussle, could not see an object, and then he described how they were, the vertical on the ground. He yelled out, "What's going on?" Then my point being is he doesn't give another time other than when he heard the gunshot was while he was trying to connect with 911, so that would give us a time. And he said in cross that the entire time he was watching was 8 to 10 seconds.
Right.
Did that begin when he was looking out the blinds, the crack of the blinds, or did that begin when he took a step out onto the porch and observed that? I don't know. That wasn't testified to, so I'd like to know in this animation where Ms. Lauer's 911 call fits into his testimony.
I can tell you this, that his call connected at 19:17:15, that is in evidence.
So that's 7:17.
7:17 and 15
seconds.
seconds.
Uh-huh.
You know that Ms. Lauer's call started at 19:16:11, and that it is 45 seconds into the call, or at 7:16:56, that the gunshot goes off.
And that's different from the timeline that you have up on here in connection with where he was and what he saw.
I disagree, but I understand the court's concern.
Well,
That of course, the way where I believe it lines up is if you use the gunshot as the precise moment of the two calls, not that it was on the call, but if it took Mr. Good somewhere around 15 to 20 seconds to get the call, place it, and wait for it to connect. We don't have that testimony, but we do have Ms. Lauer's testimony, who also testified it took about 20 seconds or so for her to make the phone call and connect. So if you...
Like, he didn't say he said he was waiting for it to connect. And we'll have to look back, I guess, in the record to see if my notes were correct on that or not. And I'm saying these are just my notes.
Sure.
But as I recall him saying he had dialed the 911 and was waiting for it to connect. So that a few seconds here or there, but then again, where's the 8 to 10 seconds that he viewed this?
And where's the 30-second gap between the connection time and the gunshot call and everything else? The court has hit upon the central problem here, and that is there is no hard and fast ability to say that this is an accurate depiction. That's been the state's perspective all along.
Well, and the case law says it doesn't have to be exact.
But it has to be
and,
accurate.
So I don't necessarily have a problem with other parts of it.
Mm-hmm.
But when you're trying to overlay a 911 call with the animation, I think it has to be closer to exact than not closer.
I understand, and I might be able to fix that by recalling Mr. Good to get a couple of questions answered by him, so I want to make sure that focus, well, I have the right to, so
I'm shaking my head because we're having the hearing now.
I understand.
I'm not going to have this hearing go on for days and days. This is the hearing now, and I guess I should not have. Can I please finish? Okay. I guess I should not have commented because then this wouldn't come up, and then I could just rule on it after you're finished. I'm not making these comments to cause you to call Mr. Good into this hearing. We have a transcript of what his testimony is, or we could have a transcript as to it. I'll stop talking, let you finish with your evidence, and then I'll make my comments.
I guess my response was going to be to the court that if it is accurate, and it seems to be undisputed and in evidence, that Mr. Good's phone call was connected at 7:17:15, and that if we have evidence from Ms. Lauer that the decision to make a call to 911 and its connection is about 20 to 25 seconds, and that's in, then if you were to back it out the time, then I think you are within seconds of when the gunshot was heard on Ms. Lauer's call because of this reason. We know that the gunshot was heard per Ms. Lauer's call at 7.
Let me stop you here. I didn't mean to go into an argument. I'd like you to finish with Mr. Schumacher, and we can get into that.
An argument? Yes, Your Honor. I think we're at the point where we took some time that did you utilize Ms. Lauer's call and Mr. Good's testimony as to when, in relation to when he left the view of the scene, when he heard the gunshot?
Yes.
And is that how you then backed out the time, gunshot that Mr. Good heard, back in time and sort of went in reverse to when he was viewing the scene?
Correct.
And do you recall the time lag that you utilized in order to calibrate that back to the Lauer phone call?
The time lag between
when he said, going forward in time, when he said he turned away from the scene to when he said he heard the gunshot?
I'm not sure the exact number of seconds.
Can you let the judge know then what you used in determining when to start the Lauer tape in relation to the video?
Well, in backing it out, his going back inside from the condo is based on consultation with you and from his feedback on the video.
Okay. So, does the necessity of being absolutely accurate, is that...
Whose feedback on the video?
Mr. Goods.
When did that happen?
Oh, consultation, in consultation with Mr. Omar.
Can you tell me what date that was?
No.
I can.
Was it after the trial started?
Yes.
He was under sequestration as a witness, and he was subject to being recalled.
And I was going to have him view the video to document it, and he said there were problems with it.
It was consultation with changing parts of the video.
Absolutely. As an expert.
Go ahead.
As an expert, Your Honor.
Mr. Good's not an expert.
No.
Mr. Good's a witness under witness sequestration.
Absolutely. And he was being used to authenticate the animation, since it's his view. He had problems with it, and I attempted to address and fix his problems with it through this expert.
None of which, by the way, has been disclosed to the state until this moment.
Go ahead.
Let's then go forward with the animation.
911, do you need police, fire, medical? Maybe both. I'm not sure. There's just someone screaming outside. Okay, what's the address that they're near? Is this in the Twin Lake Homes in Sanford? Yes.
We just talked about how this was calibrated, but let's move forward to the initial position. What information did you use to identify this as the initial position of the two?
His comment about, the initial position of
this
Mr.
position
Zimmerman.
we're looking at now.
That was in consultation with you about from testimony.
Okay. And we also at this point, or did you change this from true animation to still?
Yes, just to eliminate, just to mitigate any random movements, because there was a lot of movements going on, so this was just to show the position, one person's position relative to the other person's position, according to Mr. Good.
And was this then done in order to make it more accurate?
Yes.
And to avoid any or other inaccuracies?
Yes.
Okay. And is it a male or female?
And then what was this change from the first position to the second position dependent upon?
Also based on consultation with you and from his testimony.
And again, no animation at this point to avoid the concerns you just talked about?
Correct.
It sounds like a male.
And you don't know why?
I don't know why. I think they're yelling help, but I don't know. Just send someone quick, please.
Okay. Does he look?
And advise the court, if you would, how the determination was made to use the third position.
The third position was from consultation with Dr. DeMaio, and also proximity to the prior position, which was just seconds before, and also to the items of evidence around that area.
Did it also include the final resting place of Mr. Martin?
Eventually.
And is the one we're about to see, that last position, then related to this third position?
Correct, which is marker number 6, which is one of the things that comes into play on the position is also you have a slope there. So it's interaction with the slope.
Is that a slope that's better identified by one of the posters that were viewed by the court earlier?
Yes.
And as we're talking about that, does your computer program have such physical laws like gravity in it so that things will fall in the way they're supposed to fall based upon gravity?
It does, but in this case, those physical properties were provided by the motion capture suit.
Kurt?
I can't see him. I don't want to go out there. I don't know what's going on. So they're sending him.
Again, was the decision at this point not to have animation a change from a previous generation?
Correct. It's just to show position.
And this is the position. I'll continue it.
So you think he's yelling help?
Yes.
All right. What is your decision number?
Before we move, this is the position that was modified based upon your conversation with Dr. DeMaio?
Yes.
And to what extent, again, was it modified?
Leaning over Mr. Zimmerman, just to verify that position with the doctor.
Was the leaning over something you got from Dr. DeMaio based upon his viewing of the clothing and whatnot?
Yes.
And what he discussed with you was his anticipated testimony?
Correct.
Regarding the clothing and the positioning of the bodies?
Yes.
Three.
That was 3 on it.
Thank you.
And now it's about to go to the 4th.
First gunshot.
And what you have identified as the after shot position? What information did you utilize to come up with that?
That was their position based on Selma Mora's report of what she saw after the shot.
Okay. Any other information, whether it be from Mr. Zimmerman's testimony, other witnesses' testimony, or eventual identification of the body location, was that used as well?
It was also consistent with Mr. Zimmerman's video testimony.
I see that there is a green circle. I've moved away from it to know the number. I think it's number 6. What is that green circle identified there for?
That would be the location of Mr. Martin.
Based upon what?
Based on the marker from their total station data.
Okay. all of these data that you use, these data points, are from their total station, correct?
Correct.
And what you added to was some of the grading?
The slope, yes.
To gunshots? Yes. How many? This one. Jimmy, get down.
And why is it stopped right here at this location?
That's the location of Selma Mora, and it's also from that viewpoint, the video uses a 50 millimeter lens, which is what a person perceives when they're looking at something. So this was to show her vantage point and what she would see.
Okay. And then the screen goes black until the entirety of the loud call is completed?
Yes.
No further need for the lights, Your Honor, though I have some other inquiry. There was a concern raised about the lighting conditions. In your other experience with creating animations, are there times when you have to accomplish a lighting change or a weather change or something to make the animation worthwhile?
Yes.
Tell the court about that.
Well, if it's something about whether, if you want to focus on whether somebody could, an eyewitness could really see what they saw, or the effects of weather on something, if that would be your main focus for a video, then you would create it that way. But the problem with that is, as you see in the courtroom here, there's ambient light, and it's really hard to get a totally accurate depiction of the lighting conditions. And
So
it'll vary according to what projector you use, and also even what printer you use if you're using posters. So in this video, the focus wasn't on reconstructing of the lighting, but it was more important to see what detail, the detail of what was going on in the video.
Was this animation then created with that, if you will, artificiality so that it could actually be viewed by those people who have to view it?
Correct.
Obviously, it's much lighter in the animation than it would be that night, correct?
Correct.
Did you attempt to make it accurate in other ways, such as utilizing a proper weather that was available to you for that night?
Yes, I added rain to it.
What was that based upon?
That was based on historic weather data that I got,
And
that I received.
Add any wind to it to the extent it may have had any impact?
I didn't add wind to this. It was 7 miles an hour going northeast.
Was there anything that wind, in your experience, that wind would have added to or subtracted to in an animation of this nature?
Not in this case.
You were asked whether or not the software calibrates itself, or somehow, how would you know that it's working accurately? Can you give the court any further insight as to what happens when the software doesn't work accurately, or when it crashes or does something that it's not supposed to be doing?
You can verify something easily by just measuring an object, that you know the size of that object and just measuring it, like you do in the real world.
And have you done that in your animations generally?
Yes.
And have you done it in this animation?
Yes.
How is that done?
Well, if you want to measure the size of an object, you can just grab that object and choose the dimension tool, and it'll give you the height and the width of the object.
Is that also the way you recreated we'll call them avatars of Mrs. Zimmerman and Mr. Martin, by getting their height and their approximate body size, and then using, what tool did you use to then create those avatars?
The figures were already created, so I didn't waste time on the creation of them, but I adjusted certain things on them to match the size of the figures and the clothing that they were wearing.
For example, if I was to be in your motion capture suit at 6'2", would you have to take that avatar and make it smaller to 5'11" to be Mr. Martin?
Correct.
And is that what was done to give them the relative sizes that they have in these animations?
Correct. And even though you're using somebody that may not be the exact size when you're making the recording, when it imports the motion file into the software, you specify an exact size that it will come into the software.
So you were able to make Trayvon Martin's avatar 5'11"?
Yes.
Okay. And putting on his shoes, whatever size his shoes might be, to give him that additional height?
Shoes and the top of his hood.
Okay. And do you know what the height turned out to be based upon those additions to his height?
Approximately around 6'2".
In the still that you used concerning the moment of the shot, with that view that you had of it, would a gun in Mr. Zimmerman's right hand have been visible?
No.
Would the flash of the gun have been visible from that angle?
No.
Would you have had to have created another animation from ground level or from just behind Mr. Zimmerman's head in order to show the gun?
Correct. If that was the purpose of what I was trying to create, to put all that information into a video or a still image, there would be a lot more attention to that. But in this, that wasn't the purpose of this video at all. There's other people that can testify to the gunshot and the positioning of the gun and all that. This was just to show the position of who was on top and who was on the bottom.
And what was the purpose then? What was the purpose of doing it limited to that?
Well, I believe that's the main thing. With Dr. DeMaio's input, the person that was shot had to be the person that was on top, and the person doing the shooting was the person that was on the bottom.
Just a moment, Your Honor.
Thank you, Eddie. Recross.
Thank you. As far as the representations of the figures in third position, I noticed that between second position and third position, the positions of the hips relative to each other change.
Correct.
Okay. As far as I know, that wasn't based on, at least you didn't tell me earlier, that it was based on any particular witness statement, testimony, or eyewitness observation. Right?
Some of that was based on common sense.
Okay, I'm sorry. Let's back up. And the common sense is that if you kept Trayvon Martin's figure positioned as he is in second position above George Zimmerman, there's no way that firearm would have been accessible to George Zimmerman. Isn't that what you told me?
In the second position where they were on the sidewalk?
Correct.
Correct.
So you had to move them in third position in order for the George Zimmerman figure to be able to even think about accessing a firearm that would have been carried on his right hip inside his pants. Right?
Correct.
And you didn't do that based on any actual testimony. You said you just did that to be able to put those figures in a particular position.
They were in position relative to each other. The position they were in when Dr. DeMaio mentioned about that, Mr. Martin being shot, and also accessibility of the gun.
Did Dr. DeMaio testify to your knowledge about accessibility of the gun?
That's common sense.
I'm sorry, did he testify about it, or is this just another assumption you're making?
He didn't. I I didn't hear his testimony.
In fact, nobody did, as far as you know.
I didn't hear his testimony, so you're asking me about something that I had no knowledge about.
You had no knowledge about it, but you made it, included it in that animation.
The gun had to be accessible.
That's
That's common sense.
Well, if the gun had to be accessible, if we assume that in fact the figures were positioned as you had placed them. Right?
Correct.
So it's another assumption.
So that
built
the
in.
gun is accessible.
Right. If, for example, the testimony was, or a statement was, or some evidence was, that the Trayvon Martin's figures were up at the armpits of the George Zimmerman figure, obviously the gun would in no way be accessible, right?
Not only the gun, the accessibility of the gun, but you're also talking about the position of the of Mr. Martin when he was shot.
So it would be impossible. So you're telling me you couldn't create an animation to fit that scenario.
With him straddling the shoulders of Mr. Zimmerman in position 3, no.
Right.
That's a scenario that wouldn't occur.
And as for position number 3, I think we talked earlier about in order to depict their angles, when you have the angle of the shot being, I think as you put it, 90 degrees earlier, straight in?
Yes, that's what the coroner, also in the coroner's report.
Okay, not left to right or anything like that, straight in. Right?
He mentioned 90 degrees front to back.
Okay.
But he mentioned 90 degrees front to back, but in my conversation with Mr. DeMaio, he mentioned 90 degrees, but slightly from, I believe he said from very slightly left to right.
So you have notes of your conversation with Dr. DeMaio?
Just one.
Just one? Is that the only note you took?
Yes.
Just that about the 90-degree angle or not?
I already knew about the 90-degree angle from the coroner's report, so it wasn't, I didn't have to retain that.
What I'm asking is you just opened up a folder and looked at something. I'm just wondering what it was.
It was just my note on left to right from Dr. DeMaio.
Any other notes you have from Dr. DeMaio?
Just that.
Just that. Okay. So the position in position 3 that we've seen, we talked earlier about how the bodies had to be some distance apart from each other. In other words, the chests of the figures, for example, had to be a distance apart.
Correct.
Because you have to account for not just the clothing differential, right?
Correct.
You have to account for the length of the arms involved, right?
But you don't know what position the arms were in.
Exactly. And you have to account for the length of the gun involved, right?
Well, you're talking about a lot of different variables that I didn't portray in this video.
I understand. So none of them are accounted for here, right?
The main thing that's accounted for with this is Mr. Zimmerman and Mr. Martin, their positions, and the position of Mr. Martin over top of Mr. Zimmerman.
Yes or no, none of those variables I just mentioned are accounted for in any way in that third position animation.
Variables in relation to the bullet trajectory and the
spacing of the bodies, the lengths of the arm, the length of the gun, the distance of the gunshot clothing, all of that. It's not accounted for there because all you want to do is show the position of the bodies, right?
position of the bodies consistent with Dr. Mayo's consultation.
Okay. So no, none of those variables I just mentioned are accounted for in this animation, right?
The variables that you mentioned aren't impossible in this scenario.
Didn't ask if they're not possible. Is that what you said?
Are not impossible.
Okay. Is that a
There
way of
is
telling
space
me
between Mr. Zimmerman and Mr. Martin in this video?
Is that a way of telling me that they are not depicted here in this animation?
They're in this animation, but they're not expounded to the point that you're talking about.
So I can tell from this animation
You can tell?
I can tell from this animation the length of distance between, for example, the gun, the ground, the body of Trayvon Martin. I can tell all that from this animation.
If you use photogrammetry, if you know the measurement of one item, you can figure out the measurement of the other. But
I'm not talking about what else I would have to do. I just want to know if I can tell it from this.
the figures in this are to scale. So if you're looking at this scene and you wonder about the size of the individuals involved, they're to scale. So there's nothing that has changed throughout this video in relation to the scale of them.
They're to scale in terms of their height, right?
Correct.
And that's it.
They're to scale in terms of their height and their appearance according to photos that I received.
I thought you told me you didn't take measurements of the other parts of their bodies.
I had coroner's photographs of Mr. Martin.
I'm asking about other photographs. What I'm asking about is, does this animation show me, can I tell that spacing and those lines just from watching this animation, or do I have to go delving deep into the data that you've compiled underlying that program?
If you knew how to do it, you could tell it from the video.
Let's assume I don't. Let's assume the judge doesn't. Let's assume that the jury doesn't.
That wasn't the purpose of the video. That's why you're not looking at what you're trying to look for.
Thank you.
You're looking for something that's not in the video and expecting something that wasn't the purpose of the video.
It's not there, right?
The purpose of the video isn't to examine the bullet trajectory and the location of the gun. The purpose of the video is to show relative positions from one person to the other and the position of Mr. Martin on top, where he had to be consistent with Dr. DeMaio's testimony when the gun went off.
Would it shock you if Dr. DeMaio might have testified that there was another position possible for those two bodies?
He mentioned that there was a variable of about 2 inches.
That's it?
Correct.
No other questions, Judge?
Thank you. Any redirect? May Mr. Shoemaker be excused?
Yes.
Thank you very much. You're excused.
Thanks.
Any other witnesses from the defense?
No.
Any witnesses from the state?
No, Your Honor.
Let's have argument. This is from who?
The state.
Okay.
Are we in a presentation under Daubert that you want that initial, or are we talking about applicability to this case in this animation now? It seems we've gone one to the other and maybe back.
Yes, we have. The state yesterday had indicated that it was not a Daubert issue, and this morning indicated it was a Daubert issue. So I don't know where the state stands as to the request regarding that.
As I put in the second supplemental motion this morning, I do believe that there needs to be a Daubert analysis or Daubert-Frye analysis, Frye, of course, now being essentially one component of Daubert, so I think we can handle that, as well as a Pierce factor analysis. I think both of those have to apply to this, both the testimony and the animation, so I'm asking for both.
Under Frye and then Daubert, the main consideration with Frye, of course, is that is it generally accepted in the community? I don't think there's been any counter-argument from the state that this is a type animation, though it's a new generation, that the underlying foundation of this animation, which is the idea of taking data and incorporating it into an accident reconstruction or an event reconstruction event, has been admitted in courts a lot. It's been by this very witness. He's testified for the last 14 years in this. He's never been disqualified as an expert upon his attempt to have it in. I will acknowledge to the court that I did not present an enormous amount of industry-wide evidence because, quite honestly, I did not realize that it was going to be a contested issue today. However, I think even this expert alone has presented that in his industry, he stays up to the day-to-day or week-to-week information flow concerning the accuracy of the data and the software that he uses. that he has been involved in the industry since, I think, 95. And for the past 14 years, he's focused his inquiry and profession on this area, and that he's presented many, many times, and again, has never been excluded. So to the extent of whether or not it is generally accepted, I would suggest that it has been and is. Under this now new sort of Daubert inquiry they look at, I think for the purpose of this inquiry, I think the court needs to look at this and say, even though it has been generally accepted in the past, would it assist here today? And that is sort of a Pierce consideration as well. Will it help this jury in a consideration? I do think that as to that, and we're going to do a sort of a Daubert-Pierce analysis together, because I think what needs to happen is that this court needs to be convinced that it's accurate, and not that it's perfect, but that it is accurate depiction based upon the information available when it was created. It has been, of course, created and recreated several times. With the most recent generation of it was, in fact, based upon some trial testimony, because I perceive that an expert has not only the right but the obligation to make sure that their testimony they're going to present, in this case basically the animation, uses the most up-to-date information available, and that is trial testimony. It's difficult for the state to argue it's not based upon trial testimony, and to say that he can't have the trial testimony available to him, even through consultation with counsel, to make sure that it is as accurate as it can be. Within that context, we have taken away some of the frailties of the animation. And that is, it's no longer really an animation, but for the initial animation of the initial strike by Mr. Martin against Mrs. Zimmerman, which came solely from his testimony, but all of that is in evidence now. And
where's the testimony that Mr. Martin is left-handed? Because that animation at the T shows a left-handed punch.
The strike, the injury is to the left side, the right side of Mrs. Zimmerman's body, and he had testified that he had gotten struck by Mr. Martin when he first looked up and got struck, and the injury was right here. That's where it's from. And quite honestly, to the extent that the jury has to look at that and say, I think that that is absolutely the most reasonable assumption that they can make. Never did he say he was right-handed. I don't care if he's left-handed or right-handed. As to that fact, he hit him with a left hand, because that's the area of the impact.
Who testified as to that?
Mr. Zimmerman.
He testified he got punched in the face.
And the injury, I'm sorry.
He didn't say from what hand.
That's correct.
Nobody testified that that injury came from a left-handed punch. And Sabrina Fulton testified that Trayvon Martin was right-handed. So I don't have any testimony in the record to show that that was a left-handed punch.
May I give you the
Yes, you may.
insight? Dr. Rao testified. I'm sorry. Yeah, Dr. Rao testified, and she used her. She gave us a graphic identification, and she also testified that the injury came across the nose. We have to realize, of course, Mr. Zimmerman facing Mr. Martin, so you know what I'm talking about with the positioning of them. It was Dr. Rao who testified that the punch came in this way. She actually said it went up, which we have contraindications of by Dr. DeMaio, but she testified that the punch came in effect, from left to right because it hit him right here, and she testified that the abrasion was on the inner right side of Mrs. Zimmerman's face caused by the knuckle. So to the extent that you're looking for evidence to support that, certainly there's no evidence to support anything else. Ms. Fulton said, my son is right-handed, but that means that might be the hand you want to use first. I don't know. But the specific evidence from the medical examiner, Dr. Rao, was that it came from the left side and hit Mr. Zimmerman on the right side of his face. So that is what is the basis for the left strike in that animation.
So are you saying that nobody could ever hit somebody with the right hand and cause that injury coming from the left side?
Well, I think that, I tell you what, yes. Now, I don't know if that means that the animation is invalid, but I just have to get it this way by asking Mr. Manchow to stand up for a second. And if he's going to swing at me with his right hand, I suppose if I turn this way, somehow it might come across. So, yeah. So, yes, it could be. But since we only have Mr. Zimmerman's testimony that they were basically standing in front of each other, that he approached him from behind. Mrs. Zimmerman turned to him. His testimony does say that. Reaching down to get his phone, looked up and got hit. That testimony seems to be that they were face to face. Could Mrs. Zimmerman have turned all the way around this way and then Mr. Martin's right hand got him like that? Yeah, that's a possibility. I think that the testimony would suggest, both when we look at Mr. Zimmerman's testimony that he was basically face to face, and Dr. Rao's testimony that the more likely event was a left-hand throw.
I didn't hear her say more likely event it was a left-hand throw.
No, I just said that.
Okay, you said her testimony was.
Oh, no, I said with her testimony.
Okay.
Then there was my words, it's more likely a left-hand throw. So that was where that part of the animation was created. So we have that part of the animation, and then we took out some of the more concerning parts of what is animation, because after that part of the animation, really what it is still photos or still animations based upon specific testimony. And yes, that was modified based upon John Good saying in his testimony that it happened in certain relation to the 911 call of Ms. Lauer, which is why that was placed in to give context to it. And the main reason for that context is because we know that we have a reverse timing of when...
Let's talk about Ms. Lauer for a second, because in my notes it does not indicate that she saw anything.
No, of course she
and
did not.
Mr. Schumacher is testifying that the testimony at the T, or the figures at the T, is based upon her, I don't know if it's the first illustration or whatever, it's based upon Ms. Lauer's testimony. She's never said that she saw anything.
No, she said she heard.
Well, but hearing and seeing, and the animation is presented by Mr. Schumacher, he said, based upon her testimony. If we all only know what she heard and none of us know what she saw, how do you get that position in?
Okay. Here's my response. Ms. Lauer testified that she believed that the altercation that she first heard, which was the back, forth, and back conversation, occurred out of her condominium to the left near the T intersection. I can pull up her exact testimony because I think we actually have it, but generally
she testified on that date the bamboo blinds were drawn down. She and her husband were at home around 7 p.m. She was watching TV in the living room. She was on the love seat facing the glass sliding door. Whether it was raining, the glass sliding door was open. Her view to the backyard was obstructed at night by the blinds. She heard voices from outside her backyard, couldn't tell the words. The voices were coming from her left, sounded like a loud talking. Voices sounded like the same volume, tone, more flustered than confrontational. She muted the TV. She heard scuffling around like sneakers on pavement or grass. Combination of pavement and grass. She gradually went to a grunting noise. It gradually turned into grunting. At first it sounded like people standing up, and then sounded like wrestling, rolling on grass. And that's when she decided to call 911 as soon as she heard the scuffling noise. And it took her about 30 seconds to connect to 911. She didn't say she saw anything. She could tell the voices were coming from her left, and she could tell that it got closer because it got louder. First vertical, then they were scuffling around pavement and grass.
She never said she saw anything at all. That animation is placed in that location based upon what she said, where she heard it come from. And I think if you go further in your notes to where the cross-examination occurred, I talked to her about the first, there were the three parts of the conversation, sort of like the red car, blue car, red car was the way I presented it to her. So hopefully those are in your notes as well, because in my conversation with her at that point, I focused her more on the beginning, the initial conversation beginning at the T intersection.
My point being that that animation position Mr. Schumacher said is based upon Ms. Lauer's testimony.
Of what she heard, where she never saw anything, but she heard
Okay,
it.
can I see that position again? Oh.
Would they still work?
Yes, it would help.
Okay. Yeah. 1 second, I'll just give you something.
Thank you.
If I might,
Is that the new one?
this is the one you have. If I might approach you.
Please, thank you.
So that's her trial testimony that was.
Can I keep this up here
Yes,
so I
please.
can refer back to it? Thank you.
So in any case, that was, you're right, she did not see anything. And yes, in that sense, the particular placement is an estimate on voice. But I think in her cross-examination, when I cross-examined her, she was more specific that it happened in the area of the T intersection. And is it 4 feet away, 6 feet away? But that is a frailty of the animation based upon non-visual testimony. So then the question under this Daubert-Pierce matter is it accurate? And we're talking about that now. The other accuracies of it were limited by, we used John Good's specific recollection as to he testified at trial to these sort of 3 different positionings. That's where we got it from, where he said, first they were sort of vertical, then they were sort of, he didn't get the words right, but parallel and on top of the pathway, and then they were further down, and that's where 1, 2, and 3 come from directly. Then he left. And we kept him in that position because there is no other evidence to support changes. Could they have jumped up, gone 10 feet, and run back into the same position? I guess so, but there was no evidence to support anything but what John Good last saw, so we kept it static. And then the positioning was changed slightly, and only, I think, from more like this, which was the mounted position that we saw before, to more like this because of Dr. DeMaio's anticipated testimony that the shot went in, but that the gravity effect of the shirt and the can in the shirt and how that would pull it down made sense. Again, I argued to you yesterday when we were talking about this, could it be like this? Yes. Now we know from Dr. DeMaio's testimony it might be like this, but that as the bodies go up, then the can pulls it more straight down, and so the idea of having it billowed with gravity means it's more like this. Is it an estimation within that context? I acknowledge that. But at least Dr. DeMaio's testimony lessened the angle much more so because of the gravitational effect on the can. And that's quite honestly it for the animation as far as whether or not it's accurate, because that's a premise for whether or not it would assist the trier of fact. And I would suggest that with all of the information that we have in this case, and with the various witnesses, none of whom are direct witnesses except for Mr. Good, but all of whom have almost this vantage point changes to offer to it, that an attempt by the defense to present that in a way that does in fact support the defense presentation of what happened, and we have now, I think, presented an enormous amount of evidence to support that that animation is accurate and would help the trier of fact in presenting the way the defense says the case happened in comport with the facts, that it would in fact assist the trier of fact in trying to get an understanding, a graphic understanding as to how the situation unfolded that night and how things may have ended. So to the extent that Pierce requires that, I think
But the distinction in Pierce is that the state, whether it's the state or defense, is not the distinction. It is that the state intended to introduce that into evidence, and the court ruled that it would be demonstrative only. And it seemed to make a difference in the analysis that the court did based upon that, because it did not go back to the jury as evidence in the case. It was used for demonstrative to assist the expert in their testimony.
I agree that's what the Pierce Court did. I did not find that the Pierce Court outlined an exclusion for it becoming evidence, just as the state has entered into evidence their timeline. If it is accurate, if it would assist the trier of fact, this court has already, in this case, allowed a presentation to be presented by the state in putting together various facts in a graphic way that I presume that they believe assists the trier of fact in some way that helps their case. That's exactly what an animation is, and there's no reason why it shouldn't be admitted into evidence. I do agree with the court. I think Pierce made a distinction between the two, but I don't know that it was a ruling that I can't imagine it being a ruling to suggest that information cannot be entered as evidence. I think in that case they decided not to. Just to make sure that we follow through the criteria of Pierce, I do think that he was qualified as an expert. He's been qualified in other state and counties before, and that it is certainly applied to the evidence offered at trial. Again, Pierce, while it says that, we know that it's not strictly limited in that the evidence has got to be, the animation has got to be consistent with the evidence. It can't go into some matter that is not otherwise presented to the evidence. It can't show something that for which there is not an evidentiary support. Does it need to be a perfect frame-by-frame rendition of the evidence? I don't believe that Pierce or any other case suggests that it needs to be that. It just needs to be accurate. It needs to fairly depict the circumstances to which it suggests it does. And are there frailties to it? Yes. Is one frailty the fact that if this was in real light, it would be all dark and black? Yes. Is that something that I would then need to explain to the jury, as with every other piece of evidence? You have to take it into context. A gun out of a holster doesn't mean anything when the evidence suggests a gun in a holster? Sure. But that doesn't mean it's a fatal frailty of the evidence. It just simply allows the jury to see what could have been seen by the witnesses, and then they can extrapolate from that to the darkness that we all know existed. So anyway, under that context, I think that we've met Fry now Daubert, and even though Daubert sort of suggests that if otherwise generally accepted in the community, this court can act as, in effect, a gatekeeper to say, I'm not letting that get to this jury without a further foundation of its acceptance and relevance and assistance to the jury, that we have proven that.
Okay, thank you very much. Mr. Mantine?
Your Honor, the state's position is that this animation is a supposition inside a riddle wrapped in an enigma. I've provided the court with two sets of cases, one of which is essentially more Daubert-oriented, and the second of which is Pierce and a companion case from the state of Florida. I'm going to start, if I may, with the Daubert line of cases. First of all, the burden's on the defense to satisfy this court by preponderance of the evidence that the standards required for admission of this type of evidence have been satisfied. In Valenti v. Textron, there's the reference, and I'll refer to court, it's Valente, which is the first case in the stack I've given you, a 2013 decision from the United States District Court, Eastern District of New York. But essentially, what I want to refer the court to is the second page of that opinion beginning in Head Note 3, where they set out the sort of Daubert factors. There are a number of them. They are neither exhaustive nor necessarily all-inclusive. However, the ones that have been designated are, number one, whether the theory or technique has been or can be tested. Two, whether it has been subjected to peer review and publication. Three, the technique's known or potential rate of error, and the existence and maintenance of standards controlling the technique's operation. Four, whether a particular technique or theory has gained general acceptance in the relevant scientific community. And I would further posit that then there becomes a question of whether the methodology is either proper for this case or properly applied to this case. In other words, the relationship of the technique to the methods which have been established to be reliable, and then the qualifications of the expert in question. For starters, no witness, or nobody actually, even including this witness, if I understood his testimony correctly, he has never testified before in a criminal courtroom about exactly the sort of thing that he is attempting to testify about here. He has at times put things together or consulted with attorneys, but this is the first time ever with these motion capture suits in conjunction with the other things that he did, that he is attempting, even he, attempting to do this. And nobody else, by his own testimony, in his entire industry, does exactly what he does with the same methodology and same equipment. Now, we could quibble about whether or not all this is a new generation, but that's not what the witness said. What the witness said was, I've never actually testified under circumstances like these before, about circumstances like this before, nor do I believe, since I'm the only one who does any of this, that anybody else has. And he's kind of right. Secondly, as it relates to this, I'm going to refer to the next page of the Valenti opinion, where they go on to quote some additional cases, but at the very beginning, top of that left-hand column, they give you a quote from GE versus Joyner, which was the United States Supreme Court case from 1997. Nothing in either Daubert or the Federal Rules of Evidence requires a district court to admit opinion evidence which is connected to the existing data only by the ipse dixit of the expert. Court may conclude that there's simply too great an analytical gap between the data and the opinion proffered. And I submit that's sort of what's going on here, and we've been having these conversations about the gap between the data of the 911 call vis-a-vis the animation, and the gap between the actual testimony of witnesses. And
Let me interrupt you just
Yes,
because I interrupted Mr. O'Mara, and I don't mind interrupting people.
Fair is fair.
What would be the difference if this Mr. Schumacher came off the stand and did a drawing of what he considered to be the crime scene investigation? The computer just is assisting that drawing.
Well, I put it this way. It's not exactly just assisting the drawing. This witness couldn't draw a correlation between alleged 911 recordings and the perspective of another witness.
Well, I'm not talking about that. You're talking about his use of the computer program and software. I don't agree at this juncture that is necessarily falls within the Daubert test, because this witness could make those drawings. The issue of relating the 911 call to the animation is maybe a different argument, but what would prevent the defense from having this witness testify to crime scene reconstruction, get off the stand, take an easel board, make a drawing, and at the same time having that witness playing the 911 call and saying to the witness, could you point to where you believe that these events occurred on there? That's the difference between whether it is a Daubert or it's just an admissibility issue.
The best answer I can give the court is we wouldn't have to be worried about whether or not the drawing is purported to be accurate. The reason that this animation is being asked to be used as substantive evidence, as well as a demonstrative aid, but substantive evidence, we wouldn't have a witness step down, draw something on that easel, submit it as an exhibit.
Let me interrupt you again.
Yes, Your Honor.
If the court were to allow it only as a demonstrative evidence, would you have the same argument?
I would have the same argument from a different point of view. In other words, I think the standard is much higher for submitting it as an actual exhibit, and I think there are more hurdles to jump. I would still be objecting for some of the same reasons, although not all.
Would you be objecting for a Daubert determination if it were demonstrative?
I think probably not, because I think Daubert really applies to evidence that's going to be given to the jury. If I'm assured that it's not going to be given to the jury, I think since it wouldn't be testified to, it would be, if we're talking about using it as a demonstrative exhibit, the witness who would do that, Dr. DeMaio, about the position of the bodies and things, has already testified and done, and he didn't need it. He testified quite clearly to his positions on, or his beliefs and opinions about the positions of the bodies and things like that without even referencing this. He didn't need it. All the other witnesses testified and they didn't need it. So I would say that I wouldn't necessarily mind if counsel wants to use something sort of like this, I guess, as part of a closing argument. If that's the kind of demonstrative aid we're talking about. But I think my objection to it being a demonstrative aid is one of the foundational issues in that regard is it necessary for the witness to help explain their opinion? And the only witnesses who would need it have already testified and didn't need it. What we're now talking about, I guess, if we're talking about, for example, the idea that Mr. Shoemaker would come in here and use this as a demonstrative aid to explain his own testimony is only a function of what he's been told by the lawyers and everything else. There's nothing that would be required for the witness testimony to be explained by this. It would simply be a reinterpretation of what has already gone before by that witness. That would be inappropriate from the state's perspective. That's not the use of it. That's not the purpose of a demonstrative exhibit. So that's a long answer to the court's short question, but I think I made that position clear. It depends on sort of demonstrative aid meaning exactly what. If it's used by counsel closing argument, different story and a different analysis altogether. If we're talking about a witness, not Mr. Shoemaker, coming up, playing this thing and telling everybody what he thinks it means, yes, I do have concerns about that. And I think some of them are Daubert related. But he wouldn't have to, if it's not substantive evidence, meet every one of the Daubert prongs. I'll agree with that.
Go ahead.
Okay. There has been no testimony offered or presented so far as would be the defense's burden about the known or potential rate of error, the maintenance of standards, anything about peer review and publication. What we've heard is that they use it for the movies. Great. This is a murder trial. This isn't Casablanca. I mean, we're not talking about, this isn't Iron Man. It's one thing to say, I'm going to strap suits on people and create a complete work of fiction. And it's another to say entirely, I'm going to create something that while it is fiction, I'm saying is a representation of a certain perception of reality. Those are two very different things. So there's been nothing submitted as it relates to whether or not these things satisfy those prongs. Further, I'll continue in the Valenti opinion over to page 6 of the court's opinion. And it's under Head Note 8. And again, they begin quoting another U.S. Supreme Court case, Kumho-Tyer, 520, that's Kumho. The reliability of the expert's methodology in reaching conclusions must be evaluated against the specific facts at issue, not generalized theories. And down further on the bottom of that page, in other words, simplifications that are permissible to recreate a collision may not be appropriate to recreate, for example, a non-impact rollover. The reasonableness in general of using a specific methodology does not mean that using the methodology is reasonable to draw a conclusion regarding the particular matter to which the expert testimony was directly relevant. Validation is the process of making sure that despite the simplifications that have been made, the model still accurately predicts the way the object is trying to simulate behaves. Never a more clear illustration of that than, for example, the very beginning of this video, where the evidence and actual testimony is that A, Trayvon Martin is right-handed, where the witness is apparently under the impression that he is in fact left-handed. Again, just going to we want to talk about frailties. This is getting to be so frail it needs traction. The idea that you assume, based upon the location of an injury on the body, that it was struck with a certain thing in a certain manner is an invalid and unwarranted assumption based on the evidence. It is not hard for a right-handed person to punch someone on the left side of their nose. It requires a half step, a side step, a turning of the head, any number of things. But to sit here and say that it is punch with the left hand to depict it graphically and say, it is my expert opinion that this is how it happened, without a foundation in the evidence, is exactly what they're talking about when we talk about a lack of validation and the lack of the ability to apply the generalized methodology that we use to make movies to the particular facts in this case.
Well, that's not a methodology issue, that's a fact issue. That's the applying the facts to, inputting the facts into the computer.
And more importantly, creating a result once you have input those facts.
But it's a fact, it's the inputting of the facts that's the issue. It's not the computer's going to do whatever you tell it to do. So if you tell it to do A, B, C, you're going to get that result. If you tell it to do D, E, F, you're going to get a different result.
And if your methodology is to make assumptions that aren't warranted by the evidence, then that is the problem.
But that's not the computer. That's the assumptions being made, the input into the computer.
Agreed.
Okay, thank you.
That is a large problem here as well. Moving to page 8, again, peer review. There's been no testimony about that. Page 9, error rate, unknown, cannot be determined. No testimony about it. Nothing involved in this case. Moving to page 13, the next factor, reliability and relevance. They're talking in here about a particular expert, one of several that were discussed in this case, and I'm going to refer to the right-hand column beginning with the first full paragraph. In this case, that expert merely reiterates without any basis the conclusions that plaintiffs seek to advance in this litigation, which is not proper expert testimony. Expert testimony should not merely reiterate arguments based on inferences that can be drawn by laypersons. Those can properly be advanced by the parties in their summations. That is, again, exactly really what this is it is an attempt to have an expert in graphic design come in here and advance the arguments that are being presented by the defense, both most of his input coming directly from the attorneys. I won't even get into the whole violation of sequestration issue at this point. Or from a 20-minute phone call to a witness who hadn't testified yet, and I think the court has figured out by now, his testimony today isn't exactly what this witness had expected it to be. So when you've got the situation where the expert just comes in and reiterates the arguments, the positions of the bodies, the space that must be between the angles at which they must be, the particular placement of the hips, those are arguments. There's no eyewitness testimony to any of that. Those are arguments that are being advanced by counsel based upon what they claim are inferences. The gun had to be accessible, so it's common sense inference. Well, that's a question for the laypersons on this jury. That is something they should be doing, and that is something counsel can argue to them, but it's not the proper subject of expert testimony. I'll move to, I think it's the third case, and that's the Scordill, S-C-O-R-D-I-L-L case, which is a district court opinion from the Eastern District of Louisiana. And again, these are cases that sort of discuss the applicability of Frye factors to situations such as we have here. And it's beginning on I think it's page 5 of the copy of the court's opinion, under B, demonstration videos. Beginning in that second paragraph, the standard by which the court determines the admissibility of experimental evidence depends on whether it is being offered to reenact the accident or demonstrate general scientific principles. And here they're talking about experts who went out and sort of conducted a filmed experiment based upon what they believe was their theory of the case and tried to match it closely. Continuing into the next column, if an experiment recreates conditions similar to the accident but does not intend to replicate it, the court will balance the probative value of the evidence against the potential for misunderstanding by the jury, take steps to minimize the misleading effects. Further on down the line, and here we get to sort of a Rule 403 analysis, at the bottom of the last, or the beginning of the last paragraph on the page, the court concludes the video demonstration is likely to confuse and mislead the jury, and its prejudicial effect substantially outweighs its probative value. The idea that you don't have to be exact is correct. I'm not saying that essentially if we don't have a contemporaneous movie made of the incident in this case, that nothing could be advanced as a demonstrative aid, for example. I will quarrel about whether it can be substantive evidence. But that's not really the standard. The idea is if what you've got is not accurate enough, and in this case it's not enough to simply say I'm generally in the vicinity, I'm in some proximity. They are the figures in this case and the positions of the case and the positions of such things as their hips and the length of space between them such that whether firing a gun is possible. Those are all intentional assumptions and all intentional things placed into that animation. They were done with a purpose, and they're not necessarily accurate or based on any actual testimony. The problem is that their arguments masquerading as evidence. The next case is the Salvatore case. That's S-A-L-V-A-T-O-R-E. And I'm particularly talking about page 5 of that opinion. And here again, we're talking about attempted video accident reconstruction. In this case, they talk about the witness themselves, talking about there's I believe it's note 7 there in the left-hand column. With regard to the simulation, the witness in that case, Cusumano, C-U-S-U-M-A-N-O, would not be qualified to provide a video attempting to reconstruct the accident. He's not an accident reconstruction expert or a biomechanics expert, holds no degree in engineering, not qualified to provide an opinion as to the accident reconstruction. Now, I have heard that this witness has testified that he has done reconstructions and been accepted as such before. The bottom line is he's a graphic designer skilled in manipulating software and making movies, but actual reconstruction of events within a crime scene as opposed to reconstructing the parameters and static elements within a crime scene, I would submit, are two very different things. Most significantly, I'll point out to the court that when this witness has testified before, what he said was, I do things like I analogize bullet trajectories where I can take mathematical measurements and draw exact lines and extrapolate the positions of figures from those exact things. Not I put people in positions based on surmises of experts or other witnesses. Down towards the bottom of that column, the last paragraph, there's a higher threshold for admissibility of visual demonstrations that attempt to recreate an accident because they are significantly more likely to confuse the jury than depictions which merely illustrate principles forming an expert's opinion. Again, the expert opinion referenced in these videos are not those of Mr. Shoemaker. They are, if anybody, the only expert opinion is that of Dr. DeMaio, who didn't need it, didn't talk about it, didn't reference it, testified without it. And then continuing in the upper portion of the next column, thus for demonstrative evidence closely resembling the actual incident, courts generally require the proponent to establish that the demonstration shares substantial similarity with the accident conditions. By contrast, if a demonstration does not appear to recreate the accident, Rule 403 generally does not require a foundational showing of similarity with the accident conditions. This is being purported, at least, to be a recreation of this crime scene or the events taking place within this crime scene. That being said, the higher standard applies. And if we accept the higher standard applying, the conditions aren't anywhere near close enough. We'll start with the obvious, the lighting. We'll start with the more obvious, the depiction of visual positions, not based on any eyewitness testimony, but based on a 20-minute phone conversation with another witness who sort of described his general theory about how it must have happened. That's not a substantial similarity with the actual conditions. The idea that we have no idea how we go from the T 40 feet down, so we'll just throw an arrow out there, doesn't explain or doesn't say that this is a substantial similarity to condition. What it says is, I don't know. And that's really where it ought to stop. Further, even as it relates to Dr. DeMaio's testimony, his opinion as he testified today was that at the moment of the gunshot, he believed the defendant's statement was consistent with what he understood the physical evidence to be. Not even that it is how it happened, not that it was the only way it could have happened, only that his interpretation of the defendant's statement, that is Dr. DeMaio's interpretation of the defendant's statement, in his opinion, was consistent. Mr. Shoemaker is taking Dr. DeMaio's statement to him about a statement of the defendant that Mr. Shoemaker claims he didn't use in connection with position 3, the position of the shot, at all. He said the only time I used anything this defendant said was as it relates to that first punch. That was what he testified to. So we're, again, talking about sort of relay through relay through relay. That's not the standard for the admissibility of this evidence. Further, I think as it relates to the Daubert issue itself, if this evidence is admitted either as substantive evidence, which I submit it shouldn't even be considered for, or even as a demonstrative exhibit, the court should fashion a significantly strong admonishment to the jury along the lines of this is not pretended to be an accurate depiction of the events. This is a representation of a possible scenario. So even if it's submitted in some form to the jury, they ought to know that this is not being testified as this is how it happened. And nobody should represent that it is, nor should they be confused by any indication that it is. If we were talking about simply some stills created by Mr. Shoemaker showing the location of physical evidence, and without figures, probably wouldn't have a problem with it. Even when we start to add figures, as long as the figures aren't purported to have significance in certain ways that they are depicted, in other words, I depict the arms doing certain things even though I don't know how long they really are and whether it would even be possible for them to reach somewhere given a certain angle of a body, like the video depicts them doing, or their hips are in a certain position, just because I know that there must have, common sense tells me he had to have been able to access the gun without any actual evidence that that's where they were.
I guess that's where Mr. O'Mara, and I need to interrupt you,
Yes,
Mr.
sir.
Manti.
Yes, sir.
Mr. O'Mara, I'm trying to figure out the purpose of the introduction of this animation. I don't see where it's assisting an expert in testifying as to what happened. Can you respond to that, please?
Yes.
Mr. Manti, I'll get back with you.
Sure. The animation itself is substantive evidence because just as the state has taken a distillation of other pieces of evidence that they wanted to present to the jury in a format, that's what this is. The reason why it's substantive evidence is that it takes pieces of evidence that exist, various witness statements, and it puts it together in a way that does assist the jury, because what they did is they've taken certain pieces of evidence from Mr. Zimmerman's statement regarding the shot to Dr. Rao's testimony concerning the injuries, and put it in context with everything else that was happening, run, in effect, a timeline, just as the state has already presented.
But your animation does more than a timeline. Although you voice over the 911 call, the Lauer 911
Yes.
call, the animation does more than a timeline. It's depicting positions of Mr. Martin and Mr. Zimmerman based upon
John Good's testimony.
Pardon me?
John Good's testimony. I mean, in effect, I'll give you an example to compare it to. We have before the jury one of the witnesses, Adam Pollock, mounting me. Was that exactly how Trayvon Martin mounted? No. But it's an example and it instructs the jury in a visual way how it could occur. We have Ms. Morris prance around the courtroom to give an idea.
But the jury's not taking that back with them into the jury room to play over and over and over again as how a reconstruction of what happened.
Well, they do have the state's compilation exhibit that they put into evidence, which is their timeline on top of their timeline, on top of phone call and whatnot. So they've distilled down.
But they did not interject animation figures into that timeline as to what was happening with the two individuals during those calls.
Certainly, this is an animation depicting what happened during those two individuals based upon John Good's specific positioning of those people.
Well, it's more than that. The animation's depicting a lot more than that, based upon Mr. Schumacher's common sense, based upon an assumption that Trayvon Martin hit Mr. Zimmerman with his left hand, based upon a phone conversation with Dr. DeMaio that was not necessarily his testimony in court. So it does a lot more than that. Dr. DeMaio testified that the position of Trayvon Martin could have been at different angles. He could have been leaning down, or he could have been pulling back. That's my recollection of the testimony. So I need you to respond to that.
My understanding of Dr. DeMaio's testimony was in response to them saying he could have been pulling back and George Zimmerman pulling his shirt. Dr. DeMaio said, well, no, that would pull the shirt to one side and then the bullet markings wouldn't match up. So I don't think that Dr. DeMaio gave the alternative suggestion that is now being propounded by the state.
I think Mr. De La Rionda had asked him, given the fact that Mr. Martin's sweatshirt or hoodie may have been wet, and the fact that he had a full can of, I don't know how many ounces, in his pocket, may determine the position of his body at the time of the shot.
And I think Dr. DeMaio's response was it has to be leaning over because it has to be pulled away 2 to 4 inches. And then Mr. De La Rionda then said to him, well, could it be such that he was trying to back away and George Zimmerman grabbed his shirt with one hand and then shot him? And Dr. DeMaio's response was that would by nature pull these shirts towards one side. Then if you shot and released the shirts, the holes wouldn't match up anymore. So I think Dr. DeMaio specifically countered the suggestion by the state that there was pulling back with a holding onto the hand. But I don't want to re-argue his testimony, that's what I would call it to be. To answer your question, and why it might be substantive evidence as opposed to just being demonstrative evidence, I would suggest that the absolute minimum is certainly a demonstrative tool to be used by me to present the evidence just like I can get up there and draw something myself. I think that's, not to presume too much from the court, but I think that's a given that I could be able to use this in a closing argument. But whether or not it gets in this substantive evidence is, as I said before, what it has taken is a distillation of known facts, and all those facts may be contested. He could contest that it is a left-hand shot. That's fine. That doesn't mean that the presentation, just like we can contest any expert, they could have brought in their animation expert. They could have brought in Dr. Rao and did to say it may have happened some other way. Let's not forget, Dr. Rao's animation, had she had one, would have been 1, 2, 3, 4, right? That's what her animation would have been. Specifically contested by our suggestion as to what happened, but her testimony was her presentation.
But that doesn't go back to the jury room to be played over and over again. That's what I'm grappling with. The difference being that whatever the witnesses testify to, and there's an instruction to the jury about the believability of the witnesses, they can believe some, all, or none of their testimony. And they discuss that, but to have an animation that goes back to the jury room that they can play over and over and over again, like they can the 911 call, that they can the reenactment and those other things, gives a certain weight to something that this court is not particularly certain that comports with the evidence presented at the trial.
understand the court's concern. I do think that it's a proper distillation of certain pieces of evidence that in and of themselves are unassailed by contradictory
Do you
testimony.
have any case law to provide me?
No, Your Honor. I rely on Pierce, and I will cite back to the court some of the portions of the case law presented by the state, just to say that once you determine that it is in fact substantially similar, and that's the only determination that needs to be made as far as the admissibility of the evidence, that it is substantially similar to the evidence that has been presented, then it is admissible. And that's about two of the cases. Valente is one of the ones.
Well, both sides are basically agreeing that Pierce is the only case in the state of Florida that relates to computer animation. Is that correct?
I did, I think, provide one other one, which is General Motors versus Porritt, P-O-R-R-I-T-T. I will agree that Pierce is the only criminal case.
Okay, and does the defense agree with that?
Yes, ma'am.
All right, so when I look at the Pierce case, they proffered the computer animation as demonstrative exhibit to help Detective Babcock explain his opinion to the jury and also as substantive evidence. And the trial court ruled that the computer animation would be admissible as a demonstrative exhibit only, and made the particular findings that it did in that case. They cited to trying to look for the citation of this quote in here. It may be People versus McHugh. I'm not sure, but it says, when the results are useful, they should be accepted. When confusing, they should be rejected. And that the presentation be relevant, that it fairly and accurately reflect the oral testimony offered, and that it be an aid to the jury's understanding of the issue. Okay. Any other cases? I'm going to read your cases. There are no other cases by the defense. I understand both arguments. I need to go back here and read it. You're smiling because I've cut you off so many times. Go ahead.
And I promise I'm not going to take you along with this, Judge.
All right, because we have another issue we have to address.
I know. I just want to make a couple points. Number one, Mr. Shoemaker didn't even mention Dr. Rao. He didn't use her at all. Number two, there's an underlying assumption by the defense here that the nose injury arose from the very first punch, which is depicted there in the animation, but they also claim there were many others landed that could equally have done this, so it didn't have to be the left hand at all. Number two, you can't compare this to, Madam Clerk, could I have that timeline? Because the timeline actually was every bit of it, the phone numbers as well as the times, testified to directly by a witness here in the courtroom, and the underlying data, that is the phone records, the numbers, and the connect and disconnect times, are likewise also in evidence for the jury. None of the underlying data upon which Mr. Shoemaker relies here are actually physically in evidence before this jury, other than perhaps Ms. Lauer's 911 call. The map of the crime scene isn't what he's testifying about. It's the movement of the figures about within it. None of that is underlying data that is in evidence. Number three, as far as the pullback versus verticality, I just want to recap Dr. DeMaio's testimony in respect as it relates to whether or not the victim could have been in a different position pulling back when he was shot. Dr. DeMaio actually absolutely testified that was possible. Mr. O'Mara's distinction came when he was asked whether the witness, the victim and the shooter could have been actually both standing up vertical when it happened. It is then that he said, well, I think if that was the case, you'd have to be pulling that hoodie. Of course, the hoodie is very baggy in and of itself, but those were the two things. Number three, the Pierce case makes pretty clear, in that case, Detective Babcock, who is the witness that prepared the animation and was testifying about it, would be the equivalent of Dr. DeMaio in this case. It was necessary for that detective to explain his interpretation of how he believed this occurred. That's not Dr. Shoemaker. I want to make that crystal clear. If there was any witness who could use this as a demonstrative exhibit, it was Dr. DeMaio, and he didn't need it. And finally, just the Porritt case. Because the conditions of the test in this case were not shown to be substantially similar to those during the actual rollover, the videotape evidence was inadmissible. The closing remark of that, the court cannot use discretion to decide that despite a plain lack of substantial similarity in conditions, nevertheless admit the evidence. So I think the Pierce case makes clear that this has to be accurate, not exact, but accurate. What we're talking about is Mr. Shoemaker's assumptions, not only all not in the record, but he is talking about statements made out of court by an expert to him over the phone, police report information, testimony or statements from witnesses who have not testified, a la Mr. Weinberg, and those sorts of things. All of that is built into that animation. He said that he didn't just base it on actual courtroom testimony because he hasn't heard a word. Hasn't heard a word. Everything Mr. Shoemaker's got, this isn't to discredit him, but it's to point out the frailty of this exhibit, has been filtered through the arguments of counsel.
I didn't.
I think that's a signal to me, Your Honor.
No, I didn't touch it. The lights automatically go off at a certain time in the courthouse. Is there a way that we could get them back on in the courtroom? If I touch. Okay, we're back on. Okay, so you're finished with your argument. All right, I'm going to reserve ruling on this, and I'll let you know when we reconvene at 8 o'clock in the morning. The next issue is Mr. Connor, the proffering of his testimony. Could you please tell me what is it that Mr. Connor is going to testify to in a few short words? Because if he's going to testify to, you're seeking to have him testify to what was found on Trayvon Martin's phone. I can just look at what it is that you're seeking to have introduced without having his testimony proffered and make that decision. Is that what he's going to be called for? Is that he was able to obtain certain information, either text messages, videos, or pictures off of Trayvon Martin's phone?
That's correct.
Okay, can I please see what it is that you're intending to introduce through him? And I don't need to hear his proffered testimony.
Your Honor, I believe there needs to be a proffer of his testimony.
No, there needs to be a proffer of what you're seeking to introduce by way of pictures through him. I don't need to go through.
In order to explain it to the court so that the substance is clear, it's necessary for Mr. Connor to talk about how and where he found the information on the phone.
All I need to know is that he found information on the phone. That doesn't go to whether or not that information is admissible. His testimony of what procedure he did to find something on the phone is not the relevant factor for what you're trying to do. What you're trying to do is introduce certain either photos, emails, or text messages. That's what I need to look at. So can I please see what it is that you would be seeking to introduce by way of evidence through Mr. Connor?
Yes, I can outline that, yes.
Well, I'd like to see what it is. You have it there in your hand.
Yes, Judge,
okay.
I do. I have several pieces of information that were obtained in different ways from Mr. Martin's phone. As the court is aware, this issue is actually ongoing because of the way the discovery has gone in this case. We got a report from the state on June 4th, and we're still trying to process that. But from information that we were provided in discovery sometime in late February, Mr. Connor was able to do some of the extracting. So there are two main issues. One relates to several conversations by Mr. Martin attempting to acquire a firearm.
These are conversations that are audio conversations, or are they written?
They are text messages that were obtained from his phone, but that's a secondary issue. We'll have a separate exhibit.
Well, no, it's not secondary because that's an authentication issue. If it is his verbal, if it's his voice, then that may not be an authentication issue. If it's a text message, it is an authentication issue.
Yes, and I need Mr. Connor to talk about authentication, but to cut to the chase, if you will, on the crux of the matters that relate to the fighting issue. That is the crux of this proffer. It's Mr. Martin's text messages about being in a fight, about the effects of that fight on him, that he got into a fight, that he lost the first round, won the second and third round, bloodied the guy's nose, wasn't done with him yet. A confirmatory text message with another friend, Michael French, confirming that he was in the fight and explaining that he, meaning the opponent, got more hits in the first round because he had me on the ground and I couldn't do anything. A Facebook post from Mr. Martin's half-brother, Demetrius Martin, asking Trayvon Martin, when you're going to teach me how to fight? And the first text message I was paraphrasing, the one is to a person named Lavandria. I have the text of that here. I have the, this was in a hidden file in Mr. Martin's phone that was password accessible only, in addition to the password required or swipe code to get into the phone. So this was a second level of access that was necessary. I can mark them individually or as a composite. One came from the hidden text messages that Mr. Connor found. One came from a hidden Facebook post that was in an application that was hidden. And then another from the Cellbrite extraction report from Michael French. So I would like to offer Mr. Connor's testimony to explain how he was able to access the phone and what steps were taken that would show that really, realistically, only Trayvon Martin could have created these texts or engaged in these conversations.
Okay, state.
So I'll mark these here for the court to review.
Okay, we'll mark them as composite exhibit NN for the defense, for identification. And
it's a three-part. The first one with Lavandria is the more detailed text explaining about the fight that he had just been in and the 3 rounds, etc. The other one has to do with the sort of confirmatory text message to this fellow Michael French shortly the next day. And then, of course, the separate Facebook posting by Demetrius Martin to Trayvon Martin's Facebook asking when he was going to teach him how to fight. We also can authenticate another way, if the court wants me to go ahead and proffer that as well.
did you have some others that you, I have the CV of Mr. Carter marked as 00 for identification for the defense. Was double N the 3 sheets that you gave me all that you're seeking to have introduced through Mr. Connor?
Well, that's the stuff that relates specifically to the fighting. And then there are other exhibits that relate to the gun. And I'd like to, if we could, deal with the fighting issue, because that's the crux.
Okay.
That's the crux of this. Let me assemble, I guess, the other material on the gun. That consists of, Your Honor, some pictures that were retrieved from Trayvon Martin's phone that were taken by that phone of that show a hand wrapped around a firearm, believed to be a Smith & Wesson firearm. We'll provide that. And then there are a series of conversations that occur around February 18th, just before Mr. Martin is coming to Sanford, Florida, where he has several conversations with several people attempting to acquire a firearm.
Mr. Guy, you want to address Defense Exhibit double N for identification?
Sure. Judge Guy, I don't have a copy of it.
I can provide Mr. Guy another copy. He does have this information. In fact, we got it from him.
Judge, we do have it, but it's in volumes. I didn't know specifically what they pulled out. Judge, we're right back where we started with the motion in limine that I filed before the trial. In the Munoz and Singh case, where in an instance where two people do not know each other, specific acts are inadmissible because they don't help the jury with the reasonableness or apprehension that a defendant may feel because he has no idea who this person is. This is not reputation evidence, which otherwise might be admissible under these circumstances. Furthermore, in addition to an authentication issue, how do we know what whoever wrote this is talking about? I mean, this could be a verbal fight, this could be a play fight, this could be a slap fight. We have no idea. It would completely mislead the jury and be prejudicial. It's the kind of thing that is inadmissible for a reason. It would do nothing to aid this jury. It doesn't tell us about Trayvon Martin. It certainly doesn't tell us about what George Zimmerman knew about Trayvon Martin, and that's why the court granted, I think, this initially, is because there is no evidence that they knew each other. And therefore, specific act evidence, which this is completely inadmissible. If I can just touch on the gun, if the court will allow me to, or not.
I really haven't heard the argument or proffer from Mr. West about that. He just mentioned that he intended to, so I'd rather you wait.
I guess in summary, my objection is it's inadmissible. It's rank speculation as to what any of this means, who sent it, what it was about. If you look carefully at these, there's no context to them. They're pulled out at certain times, and we don't know any conversation that surrounded them. It's just completely misleading, and therefore it shouldn't be allowed. And I provided the Munoz and Singh case to the court
Can I have that?
prior to trial. Singh, S-I-N-G-H. Judge, that's all I have regarding the text regarding fighting.
Any further argument from you, Mr. West, regarding the text?
Yes, I have a substantial argument, Your Honor. But I want to proffer Mr. Connor's testimony if the state claims that these are out of context, because we can put them in the context on which they were on the phone.
Well, I'll allow you to proffer as long as I don't go into a long proffer about Mr. Connor's qualifications and his background and all of that. I would like to keep it just to where he found this for the purposes of the proffer. So if you can limit it to that, I will allow the proffer.
Also, we can ask Mr. Connor to testify. I do think his qualifications are important.
I have him here in a CV. For the purpose of the proffer right now, I don't. You said he got them from a place that was a second-level access. If you would like this court to understand what he means by that, I'm happy to hear that proffer. For the purposes of this proffer, I really don't need to go into his qualifications. I have his CV here. It's 00. I can read it.
Yes, ma'am.
So
the other issue I'd like to point out to the court before we do the proffer is that Mr. Guy's argument completely misses the point as to why this information is admissible. This isn't reputation evidence under Munoz. This is evidence that directly relates to the physical abilities and capabilities of the individuals at issue. That's a jury instruction that the court will give that directly relates to Mr. Martin's knowledge of fighting, that he had participated in a fight, that he knew, in fact, what it was like to be on the bottom.
Well, Mr. Connor is not going to testify as to what was intended by this, is he? Just where he found it and that he found it.
I'm suggesting that Mr. Guy's argument was misleading as to why it's admissible and the significance of it legally. So I don't want the court to think that I'm not responding to the argument because it wasn't the right one.
I'm really at the point where I want to hear the limited proffer from Mr. Connor. I'm not at the point to hear the arguments.
All right.
I understand that Mr. Guy gave an argument, but I told you I'd like to hear the limited proffer. So if we could get Mr. Connor in here, we can do that and take it a step at a time.
Right here, just put it in front of you.
This is a composite exhibit that relates to the gun matter, so I'll mark that as well.
All right, that will be double P.
Do you solemnly swear from the testimony presented will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Your Honor, for the purposes, could my client be outside the courtroom for 5 or 10 minutes, but continue with the proffer?
Are you waiving his appearance?
Yes, I am.
Okay, he may do so. Lisa here, they probably will need to use this. I'll wait until he...
There's another exhibit, it's a composite exhibit that I'll ask Mr. Connor to speak with briefly as well, that contain some photographs that were found on the phone.
Defense composite double Q.
I do.
May I inquire?
This is double Q. Yes.
No, that one.
Isn't that the one she
Double Q.
I'm sorry,
Double Q.
it is, yes, that's double Q. Good evening.
Good evening.
Please state your name for the record and spell your last name.
Richard Donald Connor, Jr., C-O-N-N-O-R.
Sorry, Judge. Oh, thank you. Mr. Connor, prior to you taking the stand, we marked a copy of your CV, and it's been admitted into evidence. Is that correct, Your Honor?
It has not.
Would I so move?
Well, this is a proffer, so if Mr. Connor were going to be testifying in front of the jury, you can move it in at that time.
In order to save time, I would like it admitted into evidence so the court can review it and consider it part of his testimony
Well,
today.
unless there's an objection from the state, I'll review it as a composite, but because when something is marked as evidence, it goes back to the jury. The court hasn't made a determination yet as to whether or not Mr. Connor is going to testify, so I don't want that as an exhibit going back to the jury.
I didn't mean to suggest that it would be admitted into evidence for the jury. It would be admitted into evidence for this proffer for
Well,
this hearing.
then it wouldn't be marked as double N. It would be marked as one for this hearing. So do you have another copy, or do you want me to take that double N?
I have another copy. I was suggesting perhaps that since the jury doesn't get things that are only marked for identification, if the court marked it as defendant's proffer 1, then we would
Well, I'll
keep
have
it
to
straight.
remark that one unless you have another one that you would like to provide. Either way, doesn't matter.
I can retrieve that one, so I have one, and substitute another.
Well, the clerk can just mark that as Defense Exhibit 1 for this proffer. I just wanted to know if that's what you wanted to do.
Sure.
Okay, thank you.
So, Mr. Connor, does your CV that's now in evidence for this proffer as defendant's 1 generally describe your background and training in the area of computer forensics?
Yes.
In addition to the training specifically as a computer examiner and in forensic computer analysis, are you also a licensed attorney in the state of Florida?
Yes, I'm a member of the Florida Bar.
Have you testified as an expert in the area of computer forensics to include extraction and analysis of information from cell phones in the past?
Yes.
Are some of those instances set out in your CV?
Yes.
Are you certified by Cellbrite?
Yes, I went to their training. At the end of the training, was certified in the logical and physical.
Are you generally familiar with whatever their most recent software program is for cell phone analysis?
Yes.
And do you have a licensed copy of the current version that's available to the private sector?
Yes.
And did you use that software in whole or in part to analyze the phone that was represented to be Trayvon Martin's?
Yes.
At some point in the discovery process in this case, did you receive what's been known as a bin file?
There were several bin files, yes.
Mm-hmm. Was there a bin file that you received sometime in perhaps late February or early March that was represented to be, in effect, the data dump from the flash memory of Trayvon Martin's phone?
Yes, I believe it was February 23rd.
And did you have an opportunity to use your Cellbrite software and other software that may be available to you to begin the process of analyzing the data on Mr. Martin's phone?
Yes.
Were you able to identify text messages, Facebook posts, and such that had been deleted or otherwise hidden from a cursory examination of the phone?
Yes.
Would you describe generally what your process was insofar as the use of the Cellbrite technology?
Well, when you load the data into the Cellbrite physical analyzer software, it runs a series of scripts basically and analyzes and then parses out the data. For example, the names in the contact list, the calls in the phone call log, text messages, emails, the pictures, videos, songs and music, things of that nature. It parses them out. I think it's called the analyzed data section of the report.
Okay. Did you, when you began this process, did you have an opportunity to look at the report, the printout, if you will, that FDLE had done in connection with this phone?
Yes.
And when you did your own analysis, did it indicate to you there may be additional information on the phone that had not been provided in report form by the state attorney's office?
Yes.
And what did you do then with the bin file, if you will, and your other resources to try to capture or identify what information that was missing from the state attorney's report?
Well, the report is only a report of what the Cellbrite reads and interprets and parses. The bin files is more like the physical image of the phone's data, so it contains all the data, all the files, all the free space and everything. So when I have the bin files and I've loaded it into the Cellbrite Physical Analyzer software, I can then examine any file that's from the phone, whether or not Cellbrite was able to parse it or analyze it.
Was there something that struck you when you began the process of analyzing the bin file and comparing it with the report that the state attorney's office had provided?
Yes, one of the first things that I did was in the Cellbrite report that I received from the state attorney's office, for each section of the report, it lists how many items are there, how many pictures, how many videos, how many text messages, things like that. And so I looked, when I loaded it into my Cellbrite, at the total numbers to see if they matched, and I noticed that one in particular, the picture number was off by about 600 pictures. I had 600 more than the FDLE report did.
Did that make you think there may be some additional information on the phone that was not part of the report?
Yes.
And what did you do in order to try to find those pictures?
I tried to figure out which pictures were different and whether they were all located in the same area or areas.
We're talking about comparing this FDLE report with what your preliminary indications were from your own software run with Cellbrite.
Correct.
When you got the bin file in late February, did it include an updated report from the one that had been previously provided in Discovery without the bin file?
At some point, there was a second report, yes. Somewhere around late February, early March, I believe.
Was it substantially different than the first one in that it contained did it contain any of those 600 photos, for example?
No.
At some point, did you later get an FDLE report that appeared to have some of the additional data that you were later able to find?
Yes.
And when was that?
I believe it was the week before this trial started, first week of June, I think.
That was the next time that report was, that was the next updated report?
Yes.
So let's talk about what you did then in order to try to identify the data that was on the phone but not part of the report that the state provided. So were you able to extract additional information by your own application or use of the Cellbrite software?
Are we talking in general or still talking about pictures? Or?
Identify it however you choose. Once you realize there's more data on this phone than what was in the report, what did you do to try to find it?
I did a couple things. In terms of text, I started running some keyword searches, physical keyword searches against the bin files. I also, one of the things I do is I look through, the Cellbrite report did list the databases on the phone, and I started looking through the databases to see what program or app they belonged to, what they did, and what they contained. So those are the two main things that I did.
Were you able to identify some additional photos that were not part of the report?
Yes.
Did those photos include pictures of a handgun?
Yes.
Did those pictures include a hand wrapped around the grip of the handgun?
Yes.
And when you analyzed that, were you able to determine that the pictures of the hand on the handgun were taken by that phone?
Yes.
Were they?
Yes, they were.
Do you have... I'm sorry.
Mr. Connor, if I could approach, please, and show
Yes, you may.
exhibit PP. This is more than just pictures. If you would take a look at it, though, and generally describe what that exhibit consists of.
Including the text?
Yes.
There are several text message exchanges where Mr. Martin was either trying to purchase or sell a handgun. And then there are there's actually two copies of the two separate pictures, one of the handgun on a table or something, and then the other one where it's lifted off the table is in somebody's hand.
You were able to find those text messages on the phone?
Yes, they're on the phone.
And were some of them deleted?
Yes, they were, yes.
Is your software able to recover deleted text messages?
Well, they were marked as deleted, but they were still, the data was still on the phone. So each picture had a deleted version, although the data had not been overwritten, so it was still there. And there was another version that was still on the phone intact.
When someone who has a picture on the phone or a text message they don't want and they want to delete it, is that a purposeful action taken by the user of the phone?
Objection, I would call for speculation.
Sustained.
Is this something that happens by accident or as a result of the phone itself, or to delete the images and text messages? Does that require the operator of the phone to do something?
Usually, yes.
Explain, if you would.
Normally, pictures, for example, will stay on the device until they're deleted or removed. Text messages, depends on the phone, but will often stay on the device until deleted or removed. That being said, devices go bad, memory cards go bad, and it technically is possible for something to get deleted without the user intending to delete it. So that's why I said it's usually user initiated.
If you were trying to determine as an expert whether this was an action by the user or a malfunction of the phone or something, would you be able to look at the text messages that were deleted within the context of others that weren't?
Yes.
And were some of these text messages deleted and scattered within other text messages that weren't?
That is correct.
As an expert, is it your opinion that these deleted messages were because of an act of the person on the phone?
Objection, calls for speculation.
Your Honor, may I?
It could be deleted by anybody. That is speculation.
Anybody, yes, perhaps, but...
But you're asking him to speculate.
No, I'm not asking him who did it yet. I'm asking him whether the text messages were deleted because of an action someone took.
Okay, well, that question would be allowed.
Yes.
Yes.
Is it your opinion that the text messages relating to the gun that show deleted were deleted by someone on purpose?
Yes.
Were you able to determine if the phone had a passcode or swipe code of some kind?
Yes.
Did it?
Yes.
What does that mean?
That means that you cannot access the data on the phone unless you input the passcode.
If you don't know the passcode, can you operate the phone?
Perhaps maybe an emergency call, but other than that, no.
Do passcodes typically time out? So that if you access a code, access the phone, over a period of time, is there something in the phone that will cause it to become secure so that the passcode has to be re-entered?
Yes. For example, you may have to wait 10 minutes to try again to get in, and that time may increase each time you put in a wrong passcode.
Let's talk about what happens if you put in the right passcode and you get access to the phone. If you put the phone down and don't use it for a period of time, the phones typically have a default where they go back to the point that after several minutes or what have you, that you have to re-enter the passcode.
Yes.
Any reason to think that's not the case with this phone?
I believe there's a configuration file, and I don't recall what it said about the timeout period, but I believe it did have a default timeout period.
One would suggest, I take it, that if it didn't have some sort of timeout, that you'd only have to enter the passcode once and it would remain open forever, essentially.
Until manually locked or restarted.
Which would sort of defeat the purpose of the passcode.
That's generally correct, yes.
Is there any other information you can tell the court about that set of text messages that relate to the attempted acquisition, purchase of a firearm?
Sorry, anything else that I can...
Well, are there identifiers on these text messages, who sent them, and whether or not it was sent to Trayvon Martin or by Trayvon Martin?
Yes, the messages will state which folder they are in on the phone, for example, an inbox or a sent folder, who the other party is, whether the message is incoming or outgoing, the date and time of the message, the status of the message, whether it was read or sent, for example, the content of the message, and then the status of the message, whether it was deleted or whether it's not been deleted.
Is all of that indicated on the extraction reports you have there?
Yes.
Was there a conversation between Trayvon Martin's phone and a person identified by name and number as Ron Cuevas Fulton about purchasing a .22 revolver?
Yes.
Were these conversations concerning the acquisition of a firearm clustered in date?
Yes.
When was that, please?
Yeah, just the ones with Qua Fulton, or all the ones that we have here?
All of the ones that you have regarding what seems to be the acquisition of a firearm.
Between February 18th of 2012 and February 22nd, 2012.
And how many separate collections of text messages do you have there on that?
Several. There's 1, 2, 3, 4. I think there's at least 4.
With different people?
Yes.
Can you identify who those people are from the information on the phone?
Yes.
Who are they, please?
One is Qua Fulton. That's one. There's another group that there's two other people involved in addition to Mr. Martin, but I think they run together as one kind of conversation. That's the other parties are Spoonhead Zach and Jay. And then there's another set of conversations that with another person named Ron. There's conversations with a person named Dario, and another conversations not about purchasing but about a gun with Diamond. And I think that's it.
Did you...
Fruit. I don't think I mentioned fruit.
Fruit?
There's a conversation with fruit also.
This collection of conversations were all between February 18th, 2012 and February 22nd, 2012?
Yes.
Were there some text messages on the phone where Trayvon Martin was talking about coming to Sanford?
Yes.
Are you generally familiar as when he was planning to come to Sanford from reviewing those text messages?
Yes.
Tell us, please.
I believe it was February 20th to 21st, around that.
And
those days.
you know enough about this case that he was killed on February 26th.
Correct.
Let me show you another exhibit. This one is marked Defendants QQ for the proffer. Let me ask you if this is based upon information you received from the defendants.
Yes, it is.
What is it?
This is a picture that appears to be of Trayvon Martin that was resided on the cell phone, his cell phone.
Does it appear to be a self-taken picture?
Yes, it does appear to be that.
Was that picture taken with that same phone that you analyzed?
That I'm not sure. There's no metadata in the image that identifies the device the picture was taken with.
What is metadata?
Best description I've heard is it's data about data. So, for example, in a picture, very often if you take a picture with pretty much any digital camera or cell phone these days, within the picture file itself will be data about the picture, the make and model of the phone or camera, maybe the focal length, the date and time, maybe GPS coordinates, all kinds of data about the picture itself. That's metadata.
Are you able from that metadata to learn more about the circumstances and the device where the picture was taken?
When it exists, yes, it often provides additional detail for us.
You said this photo appears to be Trayvon Martin. Is that based upon other photos that you know exist that depict Trayvon Martin that you've seen either on the phone or online or on TV?
Yes.
Were you also able to extract a series of text messages and other postings that appeared to relate to Mr. Martin having been in at least one fight?
Yes.
Let's talk about how you were able to recover the data on the phone that related to that extraction.
There was data on the phone in a database that was not parsed or analyzed by the Cellbrite software. And so when I went and manually looked at the database, I saw that it contained what appeared to be text messages. And then when I looked at the database and the configuration file associated with the database, the database appeared to be created by an Android app called Super Android SPC, I think. And when I researched that, I saw that it was an application that was designed in part to hide text messages. And basically what it did was text messages that were subject to this application were not put into the main text message database that you think of when you look at an Android phone. It was placed into another database that was only accessible to this Super Android application. So for that reason, I believe it was not parsed or analyzed by Cellbrite, but when I went and looked at it, I could see the data was there, it was in plain text, and I could extract it and analyze it.
How did that get your attention? What made you think there's more here even than what running Cellbrite had revealed to you about the missing pictures and such?
There were a couple things, and I don't remember the exact order or which one was the final tipping point, but one of the things I was doing was running keyword searches, and I was getting hits of what looked like text messages, but they were not in the parsed text messages in the Cellbrite report. That was one indication. Another indication was the SPC database was listed in the databases, but there was no parsed data from it in the report. And then I know I'm missing this one other indication. But I think those were the two primary ones, the search results, and then when I eventually got to look at it, I could see that it contained what appeared to be text messages.
Is that something that you were piecing together, realizing that there was more on the phone than what was indicated in the report from FDLE that provided by the State Attorney's Office?
Yes, and I think you need to keep in mind when I originally got this data, there were certain things I had been asked to look at. So there were other things that I noticed that I was kind of noting in my mind and putting on the back burner until I got to them, and this was one of them. And
thinking that there might be something else going on, you mentioned a hidden app. Were you generally familiar with the existence of those sorts of things?
yes, I knew that those type of apps existed.
And what did you do in order to find the hidden app on this phone and then get access to the information that had been previously hidden?
Probably ought to describe what I mean by hidden. When we're using the term hidden, it's hidden from the user of the phone, unless you know the app and the code. So if you wanted to see these hidden text messages, if you were holding the phone in your hand, you would have to pull up the app, and it had a passcode, and you have to put in the passcode, and then you could view these text messages. So they're hidden from the user of the phone unless you know how to get to them. Once I get the phone, they're not exactly hidden. They're not parsed by Cellbrite, but they're not hidden either. Once I locate the database and I access the database and view the database, I can see the data in plain text. So it's not parsed by Cellbrite, but then again, it's not hidden by the application from me either.
Are you saying that there is a passcode necessary to unlock the phone so the phone can be used, and then a second passcode that would have to be entered into this application to access these text messages?
That is correct.
So in order to get access to the text messages, arguably you'd have to know both passcodes.
Objection to leading, speculation, and argument.
Sustained.
May I have a little leeway with an expert to lead so we just stay on track, Your Honor? I will rephrase it, though. How many passcodes would it take to get access to these hidden text messages if someone handed you the phone?
At least 2.
Would that be the access code necessary to open the phone up for any purpose?
Yes, you'd first, if the phone was locked, you'd have to put in the passcode to unlock the phone. Then you'd have to locate the app that was hiding the text messages and put in the password for that app. And then you would get access to the text messages.
How would, if you were unfamiliar with the phone, how would you know what app that was?
You would not know. You'd have to try to find and maybe see if you got lucky finding the app, and then you'd still have to enter the password.
So for someone else to use the phone, they would have to figure out the first passcode in some way.
The phone passcode, yes.
And then they would have to figure out that there was another hidden app on the phone that had text messages.
Correct.
And then figure out what the passcode was to access that application.
Yes.
And then at that point, would they be able to send and receive texts?
Yes, they would be able to see the texts that were being hidden by that application and probably respond to those text messages.
Well, I suppose if someone had gotten through those levels of security, they could, you said they could respond to the messages or delete messages or something, but...
Yes, they would basically have the access that the user who set up the application, the password, would have.
When you were looking at the context of the text messages, in the regular texting and also in these hidden files, did you consider whether it appeared that someone else was using this phone to send text messages and delete messages other than Trayvon Martin?
That's always something that we look for and keep in the back of our mind. At least I do. So yes, that is something that I took into consideration as I was examining the data.
Were the text messages that you've extracted relating to the gun and fighting, which we will talk about, contained within a larger conversation with the same person typically?
Yes.
And did those conversations appear to indicate a relationship between that person and Trayvon Martin?
Yes.
I'm losing track of my thinking here, but were you able to collect the various text messages from whatever source related to firearms and assemble them in the exhibit before you?
Yes, that is what I did.
Let's move to another exhibit. This one's been marked for identification in this proffer as NN. If I could approach the witness.
Yes, ma'am.
Are you familiar with that exhibit?
Yes.
And what is it, basically?
It's a composite of data relating to fights or fighting.
Did all of that data come from Trayvon Martin's phone?
Yes.
And did you extract it in some fashion or another?
Yes.
You mentioned earlier that there was a database that was accessible through the hidden app as opposed to through Cellbrite.
Again, there's accessing it by the user or accessing it by me. If the user's trying to access the data, they have to go through the special app and the special password. Cellbrite, from my point of view, Cellbrite does not parse or analyze the data, but it is there, and I can manually access it and view it using the Cellbrite software.
Looking at the first page of Exhibit NN, I think is the one before you.
Yes.
The header at the top has an identifier as spc.db log sorted by person.xlsx. Could you explain that, please?
Yes. I created this spreadsheet, and it comes off of the phone, and the database is the spc.db database. That's what it's named on the phone. A database, in this case it's a SQLite database, and a database consists of several tables. So for example, in this is the log table as named by the application, and it's a log of the text messages. There are several other tables. One, for example, may be the contact or name table. It'll have the names of the persons that he was texting with or in the address book, their phone number, etc. So, and this is presented to me in the Cellbrite software in a table, and I can then use the Cellbrite software to export it basically into a spreadsheet, which is what I did. And my software named it by beginning with the name of the database on the phone, spc.db, the table in the database, this is the log table, and then appending the Excel extension to the name of the file.
From a longer conversation in this thread with the person Lavandria, were you able to extract a conversation relating to a fight?
Yes, there were other messages going back and forth between Mr. Martin and Lavandria, and I extracted these specifically because they did relate to a fight.
And does your spreadsheet show the phone number of Lavandria?
Yes.
And you know this to be from Trayvon Martin's phone?
Yes.
And are you able to tell from the spreadsheet and your analysis which of the two sent and which of the two received the messages?
Yes.
Are you also able to identify the date and time that these messages were sent?
Yes.
What is the first line in your exhibit of text?
The number or the content?
I have a larger extraction here. So what's the first line of text on your exhibit?
WYD question mark, which is what you doing.
You recognize that to be text code or slang for what you doing?
Yes.
And who sent that?
Lavondria sent that.
And did Trayvon Martin respond?
Yes.
What did he say?
Tired and sore.
Did Lavondria respond to that?
Yes.
What did she say?
Me too, but what happened to you?
I'm going to ask Mr. Connor that you do the best you can to pronounce the way it's actually written.
That's what I was attempting to do.
Okay. So when Lavondria said, me too, but what happened to you, what did Trayvon Martin say?
Fight.
And what did Lavondria say after that?
The letter Y, exclamation, question mark.
And what did Trayvon Martin say to her?
'Cause man, that nigga snitched on me.
And what did she say to him?
Bay, why you always fighting? Man, you got suspended.
And what did Trayvon Martin say in response?
Nah, we thumped after school in a ducked off spot.
And what did Lavondria say?
Oh, well, damn me.
And what did Trayvon Martin say in response to Lavondria?
I lost the first round, and it's got the kind of the happy face, I guess the colon and the parentheses, but I won the second and third.
And then did he repeat that with a different smiley face, the frown as opposed to the smile?
Yeah, it's basically the same, but it's I lost the first, but won the second and third.
And did Lavondria respond?
Yes. Oh, so it was 3 rounds with a question mark. Dammy, well, at least you won, LOL, but you need a... Actually, there's another couple words on that.
Can you read that whole line?
Yes.
I can show you my copy.
I've got a copy also.
Okay.
But you need to stop fighting, Bay, for real.
And did Trayvon Martin respond to Lavondria?
Yes.
What did he say?
Nah, I'm not done with fool. He gonna have to see me again.
Did Lavondria respond?
Yes.
And what did she say?
No, Bay, stop. You ain't gonna be satisfied till you get suspended again, huh? With a question mark.
And what did Trayvon Martin say?
Nah, but he ain't breed enough for me. Only his nose. But after that, I'm done.
The text that you read said breed?
Yes, but he ain't breed enough for me.
If that were a typo and it were an L instead, how would it?
Objection, speculation. If
I have to sustain as to speculation.
Have you seen typos before in text messages that you reviewed as part of your phone analysis?
My analysis in reading this is that the word breed does not make sense and is not what was intended.
What would make sense?
Bleed.
With an L, bleed.
With an L, bleed.
Judge, I'll renew my remark for my objection as to speculation. As to that
Sustained.
remark, ask it be stricken.
Your Honor, I would not want the record stricken. This is a proffer. This is, unless the court hasn't ruled. Did the court rule on Mr.
Ruled
Van?
on his objection to speculation. It is what it is. What's written there is written there. What the person intended or not, he cannot testify to. What he believes may make sense may not make sense to the author of it. So that's just speculation on his part. My ruling stands.
Have you, in your training and experience and work analyzing phones, computers and phones, have you had occasion to try to make sense out of text messages or computer messages that weren't grammatically or accurate from a spelling standpoint?
Objection relevant.
Overruled as to relevance.
Yes.
in the context of this text message sequence, as you try to sort out the data on the phone and make sense of the conversation, does the word breed as opposed to bleed make sense?
I think when you put it in the context of the rest of that message, referring to not enough and only his nose, yes, I think they're talking about bleeding from the nose.
Thank you. If you would...
It's a speculation.
Were you able to, by analyzing the data on Mr. Martin's phone, find another conversation around that time that seemed to reference that fight?
Yes.
And to whom was that text message?
Michael Suave French.
And do you know that person from information on the phone? Did you have his contact information and other conversations between Mr. French and Mr. Martin?
Yes.
And what is the conversation that Mr. French and Mr. Martin had connected with this fight?
Mr. Martin sent a message to Mr. French stating, yeah, because he got mo hits in, because he got mo hits because in the first round he had me on the ground and I couldn't do nothing. And then Mr. French responded, dang, bro.
Is that the end of that sequence?
Yes.
Did you also find a reference to fighting by a relative of Trayvon Martin?
Yes.
Who was that person?
Demetrius Martin.
And what did where was that information located or posted?
It was on the phone. It was in a Facebook database. I believe the name of the database is FB for Facebook.db. Inside the database, as in the other SBC database, there are different tables. One of the tables in this database is called mailbox threads. And this particular message was in the mailbox threads table of the Facebook database on the phone.
And what did the message on this Facebook mailbox thread say?
It was from Demetrius Martin, and it said, when are you going to teach me how to fight?
Do you know from other information Demetrius Martin's relationship to Trayvon Martin?
I believe there's some kind of brother, half-brother related with the same, sharing the same father.
What makes you think that?
Because there's one other message in the Facebook database in the mailbox thread table from Demetrius to Trayvon, asking Trayvon if Dad had a Facebook page.
You believe, based upon the context of these conversations, that Demetrius Martin was talking to Trayvon Martin about their common parent?
Yes.
Were there other references to fighting or questions? Were there other discussions in the context of your review of the text messages where people discussed fighting to some degree?
Yes.
You didn't extract those for this exhibit because you couldn't find them directly related to this event? Is it, or?
Correct, or because I could not put it in date, time, or who sent them, yes.
Your Honor, I would move the marked exhibits into evidence for the purpose of the proffer, please.
Well, we'll have to take them out of where they've been marked in the case. So NN will now come in as defendants 2 to this proffer. PP will come in as defendants 3, and QQ will come in as defendants 4 to this proffer.
In summary, Mr. Connor, sort of identifying the different places on the phone where you found information to direct the court as to what the overall scope of your work was that's reflected in some of these reports. There was some information in the report that FDLE filed initially that you were able to verify within the bin file?
Yes.
And then there was additional information in the bin file that you were later able to extract that was not contained in any FDLE report that you received prior to about June 4th.
Correct.
And there was information in this bin file that you were able to extract from applications that were hidden on the phone?
I'm going to object for leading and already asked an answer.
The jury's not here. It's fine. Go ahead.
Is that accurate?
Yes.
And to do that, to get the access to the hidden application, you had to download some software, figure out what it was all about, and review what was otherwise not visible on the Cellbrite reports?
No, no. It was not parsed or analyzed by Cellbrite. So I had to manually identify that it was on the phone and then manually go access the file or the data and look at it. The Cellbrite did not present it for me. I had to manually go find it and look at it and analyze it.
And some of that report is reflected in some of the pages of the exhibits before you.
Correct.
As well as some information that may have been extracted through the Cellbrite software itself.
Correct.
And then photographs that you were able to extract from the bin files.
Yes.
That would include the picture of Mr. Martin, the sort of profile picture.
Yes.
And the pictures of the handgun with the hand that we talked about.
Yes.
I don't remember if I asked you this. Were the pictures of the handgun with the hand taken by Mr. Martin's phone?
Yes, they were taken by the phone.
Cross?
Thank you. Mr. Connor, sir, when did you notify defense counsel that you had found some additional information that you didn't believe anybody else had found, or at least anybody else had reported?
I'm sure it was soon after I found it.
So February-ish?
Late February, early March, yes.
And as far as the phone itself, are you aware of whose name that phone was actually in?
I believe it was, yes, I've seen the paperwork. I think it was the mother's, maybe. I don't remember whose name it was in, but I have seen it.
It was not Trayvon Martin's, correct?
His name was not on the bill, correct, or the account.
Okay. And this was actually a phone on a family account, one of several on that account. Am I right?
I believe that's correct.
Okay. And can you tell me, you referenced this discussion over a gun. You said it was between two people and either one or both of them was either trying to buy or sell a gun?
No, there were the different conversations I identified. There were 4, 5, or 6 different ones. In each of them, well, in most of them, Mr. Martin was looking to purchase a gun. In one, there was a discussion about a gun, somebody else's gun, and in the last one, somebody was trying to buy one from Mr. Martin.
And this was a .22?
There were discussions about several different calibers.
Okay. Obviously, none of which he had on his person the night he was shot and killed by George Zimmerman.
That's what I've heard.
Okay. We know what caliber that was, right?
I don't. I'm sure you guys do.
All right. As far as this, these discussions about fights or fighting, in any of them is, let me just ask it this way. In any of these discussions, can you tell me who was operating the keyboard at the time the message was sent, the keypad?
Let me answer it this way. Number one, I was not there when the messages were typed. However, when you view 8,000, 9,000 text messages on a phone, you get a flavor, you get the cadence of the people, and so you get I think I can get a pretty good idea of whether it's the same person or not.
Is that a long way of saying you would like to think so, but no, you can't tell me for sure?
Again, I was not there when the messages were typed, but do they all appear to be by the same person?
Or when the photos were taken, right?
I was not there, correct.
And in fact, as to the photo, what we've called the profile photo, it looks like you have that on the exhibit there as 3 separate dates, 11:15, 11:30, and 2:10?
No, that's the date. That's the data from the phone. It's on there 3 times.
Okay, but it's the same picture.
Yes.
All apparently originally created on 11/15 of 2011.
Probably, yes.
Okay. So we're not talking about 3 different pictures, 3 different profiles. It's the same picture, just repeated a couple times.
Correct. They have the same hash values, which means it's the same picture.
Okay. And that, of course, the profile picture has nothing to do with hands or guns or any of that being visible. It's simply basically just a torso and face shot of Trayvon Martin, right?
Correct.
Okay. And it's not posted in connection with either fights or guns, right?
Posted in terms of text messages?
Right.
Correct.
As far as this deletion, deletion can be accomplished by anybody who had access to the phone and knew the app and how it worked, right?
And the codes to get to it, yes.
So as we've discussed, you weren't there to tell me who, if anyone, actually did any of that as it relates to Trayvon Martin's phone.
I was not there when...
When were the deletions accomplished? Were they done all en masse, or were they done little by little?
I cannot tell that.
Can't tell that?
No.
So, just asking you a hypothetical as an expert.
Mm-hmm.
If a person, parent or sibling or whoever, had discovered stuff in a phone and deleted it, you couldn't tell me whether it was done like that time all at once, or whether, for example, if we assume that the daily user of this phone was Trayvon Martin, he deleted things as he went along. Can't tell me which one of those it might have been.
I can give you my opinion.
Okay, based on, I thought you just told me you couldn't tell.
No, there's nothing in the data that tells me when a particular deleted text was deleted.
Okay.
But as you look at it, you can see that certain ones are deleted, certain ones are not deleted, and you can look for patterns. So.
But as to when that got done, you can't tell me.
That is correct.
Certainly as to by whom, you can't exactly tell me. Although
Well,
I understand you have a suspicion.
I was not there when the texts were deleted.
As far as the material in the phone, any reason to suspect that George Zimmerman knew anything about any of it on February 26, 2012?
I don't know what George Zimmerman.
Certainly no communications to anybody
I
called
saw
George Zimmerman.
No text to Mr. Zimmerman.
Thank you, Judge.
Any redirect?
This idea of this mass deletion of text messages, where the text messages deleted seem to relate to certain subjects.
Certain subjects or certain people. It seems that text messages to and from certain people were deleted. Other ones were not.
Text messages about drugs and drug use that were deleted.
Yes.
Some of the text messages about the guns, trying to get a gun or sell a gun, that were deleted.
Yes.
Is there anything that would indicate to you that someone other than Trayvon Martin got a hold of this phone and deleted a bunch of these messages all at once?
No.
Were there images of pornography on the phone?
Yes.
That were not deleted?
Yes.
Well beyond the scope of the proper.
Your Honor, this directly relates to Mr. Mantai's claim that someone else could have deleted these text messages. If I submit that if some family member got a hold of this phone, they wouldn't have gotten rid of the talk about fighting and guns and left all the pornography on it. I think that the court needs to know what else was on the phone that rebuts what Mr. Mantai is suggesting.
Again, that has nothing to do with the scope of the proffer, which was only as to these exhibits.
Okay, it has nothing to do with the scope of the proffer. I understand your point. Go ahead.
Could you explain that, please?
Well, yes, there are the pictures of the gun were hidden also on the phone, and by a separate application that was on there. And what this application did not put them on the SIM card where pictures normally go, but it created a folder, basically in a program file, with a French language name, so it looked like it was a French language folder. And it put the pictures in that folder, and it also renamed the extension. The pictures taken with the camera are JPEG pictures, and they have a JPEG, JPG extension. What this app did was it also changed the extension of the pictures from JPEG to .bin. So in normal computer and digital data use, if, for example, you go to click on a bin file, your app's going to tell you, I don't know what this is, I can't open it. Whereas if you double click on a JPEG, it'll open up as a picture. So this app moved them and hid them, and again was password protected. And these were pictures that were not deleted off the phone. Whoever was using the phone would have to, again, have the codes to get to those items and know where they were.
Are you saying it's a separate hidden application from the one for the text messages?
Yes.
So there were two hidden applications that required a separate access?
Yes.
And the text messages were in one of them, and the pictures of the gun, among others, were in another?
Yes.
And that, if I hear what you're saying, the casual user of that phone wouldn't see those pictures unless they knew how to access that application?
Exactly.
And the application assigned a different file name so it would not appear to be a picture?
Correct. If you were just browsing the content of the phone, if say you had an app so you could browse the folders and files, you would see these as bin files and not as picture files.
Thank you.
Thank you. May Mr. Connor be excused? Can I have the exhibit?
You may.
Thank you. May Mr. Connor be excused?
Yes, Your Honor.
Thank you very much, sir. You may be excused. Okay, the testimony's been proffered. I'll hear argument.
There's additional evidence offered.
As the court is aware, Rachel Gentile has been a witness in this trial, and that she also was deposed. She was deposed over a period of 2 days, a little over a month apart, and of course the state was present. And at her deposition in April of this year, while she had denied that Mr. Martin had talked with her about fighting, that in the deposition in April, she did then acknowledge that she'd had a conversation with Trayvon Martin where he told her that he was in a fight. And in fact, he told her that he knew how to fight and that he was in a fight that he won. We know from her testimony in trial that she had only renewed her acquaintance with him after a number of years, in February 1st. So these conversations about fighting, knowing how to fight, having been in a fight that he won, took place within the couple of weeks prior to Mr. Martin traveling to Sanford. So that sort of closes the loop, if you will, on this authentication issue that I anticipate the state will argue. So we can offer the pages of the transcript, or the court can accept my proffer of the questions.
I'm sorry, I don't understand. Is it your proffer for the purposes of this proffer of Mr. Connor's testimony, or is it another proffer of something you want introduced in the trial in front of the jury?
Your Honor, the larger issue is whether Mr. Connor will be allowed to testify as to the content of these text messages on Mr. Martin's phone. The court has already raised the question of authentication.
I just want what you just told me about the proffer of Ms. Gentell's deposition. Is it for the purposes of this hearing or for the purposes of the trial?
No, for this.
Okay, thank you.
I have an excerpt of the deposition that I can just mark as an exhibit that references what I just orally proffered about that deposition.
I'm not saying I'm objecting, I'd just like to see which I said first. I have to make sure we're in context, please.
Substitute one that's not marked for the exhibit, but you're welcome to review that.
Are we ready for argument?
Judge, I'm fine with the court accepting whichever.
Okay, that'll come in for this. Purposes of this hearing is defendant's exhibit number 5.
Number 5 will be the transcript.
Yes.
And did we?
I have the other exhibits here. I have, although they haven't been remarked by Lisa, but I'll give them to her in a moment. I'm ready for argument.
All right.
If you want to mark these and then give them back to me. Thank you.
Before I forget, Judge, Mr. Zimmerman has a 10 o'clock curfew. May we have it extended until a reasonable time after
Yeah,
court?
it'll be extended for 30 minutes after court is concluded.
Is that enough? Thank you, Judge. Okay. So on the argument part of this, we are asking that Mr. Connor be allowed to testify as to the substance of the text messages that he recovered from Trayvon Martin's phone, specifically as to the fighting. I think that's the core issue here. We laid the predicate for a picture, if it's otherwise relevant and we want to offer it, and for the pictures of the gun and the discussions about the gun. I'm not ready tonight to make the argument why the pictures of the gun and the discussions about the gun
I don't have the pictures of the gun. Defendant's exhibit number 4 has 3 pictures of the profile of Mr. Martin.
there is an exhibit that was marked that has the discussion of the gun.
Right,
And,
I have that, but I don't have included in Defendant's Exhibit Number 4. The first page is an extraction report with numbers 1, 2, and 3, and then it has three of the same picture. Those are the only parts of this exhibit. I don't have a picture of a gun.
Does the court have the exhibit that has the text messages referencing the gun?
Exhibit number 3 is an extraction report. Oh, yes, here it is. Well, let's see if the pictures are attached. There's an extraction report that has 4 thumbnails. Oh, here they are. They're attached to that, yes.
Yes, okay. And that has the gun and the hand on the gun?
Yes.
Okay. So I don't want to address that specifically tonight. The hour is late, and I'm not suggesting that Mr. Connor can, at this point, come before the jury and testify about the gun and the hand on the gun and the text messages, because I don't think that's been directly related, at least not yet, to the facts of the case. That would go more toward a notion of aggressiveness, maybe even a fact supporting a violent tendency. And
what part of the evidence code are you seeking to have this introduced? This information? All of the information that was proffered by Mr. Connor?
I believe that it most squarely is admissible under, well, no, it's different depending on what parts of the exhibit. The picture of Mr. Martin is simply that he has laid the predicate for a picture of Mr. Martin. That's not related specifically to fighting or guns. It's just a picture of Mr. Martin that was on his phone that shows his physique. That's the relevance of that. The pictures of the gun, the hand on the gun, the discussion of buying a gun and such is not directly related to the fighting issue. The fighting issue, the central core of the presentation, two legal grounds. One is 90.803. That's an exception to the hearsay, prohibition against hearsay that does not require the declarant, that the availability of the declarant is immaterial, and that it relates to an then existing mental, emotional, or physical condition. And in that primary text message with Lavandria, Mr. Martin is asked how he's doing, and he says he's tired and sore. And that's because he had just been in a fight that he had won, a fight.
What part of, I understand that, but I'm just trying to find out now, what part of the evidence code are you seeking to have that evidence admitted?
90.803.
All of them are 9803?
The text messages regarding fighting, I'm seeking under 90.803, and also under the legal authority of Chambers versus Mississippi, but that's a separate argument. I'm not addressing the admissibility yet of the firearm pictures, because I don't think that we've connected that up completely with the evidence in the before the jury. So I'd like to concentrate on the evidence of fighting and why that's admissible under several theories. Not as reputation testimony under Munoz and such, but under 90.803 as reflecting a then existing mental, emotional, or physical condition. And that mental or emotional physical condition was at the time that Mr. Martin was in the fight, that he won the fight, and that he explained how he won the fight. He won the fight by, while losing the first round because his opponent was on top of him and rendered him helpless, much like the testimony was that he rendered George Zimmerman helpless in this case.
Okay, can I interrupt you for just a minute? Mm-hmm. So you're seeking it under 9803 sub 3?
Uh-huh.
Okay, go ahead.
That's one of the legal grounds. That he talks about having been involved in, obviously, an orchestrated fight that was orchestrated for 3 rounds, that he lost the first round because his opponent was able essentially to take him to the ground and make him helpless by being on top. He also talks about how he won the second and third rounds and therefore actually won the fight. He also talked about how he was able to hit the person in the nose and make their nose bleed, but he wasn't satisfied that there was quite enough blood, so he talks about how he's not done yet with this guy. And of course, he's cautioned by this person that he should quit doing this stuff. That conversation about that particular orchestrated fight is corroborated by the conversation with Michael French that occurs within a few hours while he talks to Mr. French about this event having gone 3 rounds. So we know those are connected in time and in content, certainly helping toward the authentication that those were the words of Trayvon Martin to 2 people that he communicated with regularly. Mr. Connor talked about how there were conversations with these folks on other subjects and that he extracted just that part of it that related to the fights. There's also a Facebook post by Trayvon Martin's younger half-brother, Demetrius Martin, and we can offer evidence in the record to connect up all the dots on that. Mr. Martin has several children. One of them, 2 or 3 years younger than Trayvon Martin, is Demetrius Martin. He identified all of that at his deposition. So we have more of the loop being closed that Demetrius Martin asked Trayvon Martin when he was going to teach him how to fight. Obviously, Demetrius Martin thought that Trayvon Martin knew how to fight enough that he would ask for his advice and training. We also know from the evidence, the proffer of the deposition of Rachel Gentile, that within the first couple of weeks of February that Trayvon Martin told her that he had been in a fight, that he had in fact won the fight. And we know that from Rachel Gentile, who obviously knows Trayvon Martin's voice and knows him personally, and testified that it was Trayvon Martin that told her about being in a fight that he had won. All of that is strong circumstantial evidence, if not clear direct evidence, that all of these conversations were by Trayvon Martin, his words being sent to his friends about a fight that he was proud he had won because he was able to draw blood from the man's nose and to ultimately prevail, even though he'd been in a difficult situation in the first round. So factually, we've connected the dots on authenticating this. Why is it relevant before the jury? Because, as the court will instruct the jury, the relative physical abilities and capabilities of the parties is relevant. There's a jury instruction that says just that, and this jury is going to be asked to decide who George Zimmerman was physically, what his physical capabilities were, as well as Trayvon Martin's physical capabilities. And that includes knowledge, that includes experience, that includes Trayvon Martin's experience in fights, having been put in a position of vulnerability by being put on the ground. However, of course, in that fight, it was an orchestrated 3-round fight. So when Trayvon Martin lost the first round, when he couldn't get up, whoever was refereeing it stopped it. And then they had 2 more rounds, which Trayvon Martin was able, by hitting this fellow in the face, apparently take steps toward winning. So that shows clear knowledge of Trayvon Martin prior to his contact with George Zimmerman, that he'd been in a fight, that he knew how to fight, and that he, in fact, knew what George Zimmerman would experience when he was on top of him, because the similar thing had happened to him in the past. We know that this is relevant because the state took great efforts to try to make that information relevant as to George Zimmerman. If the court will recall the testimony of physician's assistant Lynn Folgate, one of the things that the state took great pains to get this court to agree to and ultimately to question Ms. Folgate on was when Mr. Zimmerman spoke with her about his exercise regimen, that he had mentioned to her that he exercised aerobically with MMA. And the state made a big deal of that. They made a big deal about it in the case, that he had experience as MMA based upon the medical records from the Altamont family physicians, I guess it is. So we know these things are relevant because the state wants it to be relevant in their case. It's likewise relevant in our case because the jury is going to have to make that decision. So because I think that this information shows the existence of Mr. Martin's mental state shortly after this event occurred, because he's telling Lavondria that he's tired, that he's sore, that he had just been in a fight that he had won, that it is in fact admissible under 90.803.3, the existing mental, emotional, or physical condition at the time of the event. I'm not suggesting that that statement was him talking about anything in February of 2012, but it does in fact, on a relevant matter, show his thinking and his emotional and physical condition at that time. This is clearly compelling evidence in support of Mr. Zimmerman's self-defense claim. The testimony is that Mr. Martin sucker punched him, was able to by surprise, frankly, and then shortly thereafter was able to get him on the ground where he was mounted. We know from the testimony that mounting is when you straddle somebody around the area of the hips, and that it is an extremely vulnerable position because there are very limited acts that one can do, unless they are very skilled, to get out from under it. You are essentially helpless, and you are subject to the whims of the person on top. We know John Good said he saw Trayvon Martin mounted on George Zimmerman MMA style, and that we know from the physical evidence in the case, all of the physical evidence, frankly, especially the testimony related to firearms, corroborates that the shot was fired from the ground up, that the shirt was separated from the skin by somewhere between 2 and 4 inches, and that it exactly corroborates and is consistent with not just what Mr. Zimmerman said, but with what John Good observed some 10, 15, 20 seconds earlier when he went outside to investigate. So this is absolutely compelling evidence and is highly relevant and admissible under 90.803. We submit that it's also relevant because not to admit it in this case under these circumstances would violate Article 1, Sections 9 and 16 of the Florida Constitution and the 5th, 6th, and 14th Amendments of the United States Constitution that guarantees an accused to confront the witnesses and to present evidence in support of their defense, guarantees due process of law in presenting a defense. This theory, this constitutional principle of, if you will, preservation of the accused rights is discussed in the United States Supreme Court case of Chambers versus Mississippi. The court, I anticipate, is familiar with that decision, but what's to be taken from that decision is that a state's hearsay rules and such cannot be mechanistically applied to deny an accused the right to mount a defense. So I suggest that any application of a rule of exclusion because the court finds it to be hearsay or any other reason would be instead a mechanistic application of that rule that the Constitution of both the United States and Florida prohibits, especially under circumstances where it's clear that the evidence is reliable and trustworthy. We have closed the loop on all of this. It was Trayvon Martin's phone. It was Trayvon Martin's words in the context of all of the other words through the thousands and thousands of text messages that he had with others and with these individuals. He talked about a specific incident where he talked about his skill and the other person's skill in fighting, that he was able to injure the person, but he wasn't done with him yet. Completely consistent with what happened on February 26th when George Zimmerman was screaming for help, but Trayvon Martin wasn't done with him yet and kept on going and kept on going. We have indeed closed the loop the rest of the way with Rachel Gentel's deposition testimony, that within a couple of weeks of this event occurring, Trayvon Martin had been talking with Rachel Gentel about winning a fight, being in a fight, knowing how to fight. So this isn't something that the state can say isn't authenticated, isn't reliable, could have been somebody, anybody else just typing this stuff out. That's not at all credible. That can't possibly be the case now that you've heard the testimony of Richard Connor about these text messages, the context of these text messages, and of course what we've said here today about the highly probative value of this very, very relevant evidence. The default of this court should be to allow Mr. Zimmerman to present a defense, to guarantee his constitutional rights to present a defense. And this evidence is one step in that process. So we urge the court to allow Mr. Connor to testify about these text messages.
Thank you. Response?
But I think Mr. West has just made my point. He's got an orchestrated fight with the referee. He's telling us how many rounds there are. He's telling us that somebody's mounted another person and then they got off the ground. That's not in here. I mean, that's exactly why this type of evidence should not be before a jury. It is rank speculation. He's told a story that is not in these messages on Trayvon Martin's phone. We don't know, again, what type of fight he's talking about. If it's a slap fight, a play fight, a verbal fight, a wrestling fight, we don't know what it is. We don't know if the word fight is code for something else. We don't know anything about if there was a fight between Trayvon Martin and someone else. We don't know who his opponent was. Was he fighting Andre the Giant that he could lose a round to and then beat in a couple other rounds? Or was he fighting a little girl? I mean, that's why this sort of thing should not be admitted. That doesn't even address the authenticity issue. I mean, he keeps saying we've tied all the, connected all the dots. I submit to you he hasn't. We don't know who typed these messages. We don't know if they're connected. He said the message with Lavondra and to the other gentleman was hours apart. Actually, they were the next day. The message to, or the conversation with Rachel Gentel was weeks later, if not months later. Again, there's an authenticity issue, and they keep talking about the then existing mental state. We don't know when this fight was. There's no indication with any definitiveness as to when these fights took place. So,
I'm sorry to interrupt, except as a point of procedure. Mr. Manti did the cross, and now Mr. Guy is doing the argument. Are we allowed to do that here?
Well, Judge, that's the way we designed it. It's my issue. I filed the motion in limine. Mr. Connor was Mr. Manti's witness. So that's why we found it this way. That was his witness and my issue.
Okay, go ahead.
This was the issue I argued before the court. Judge, so again, we've got an authenticity issue. We've got whether or not it was then existing mental state. Again, there's no definitiveness as to when these events occurred. But most importantly, we don't know exactly what was meant by these words. Are they code for something else? And
And again, the danger is exactly what Mr. West has put before the court, that there's an orchestrated fight, that there's a referee, that there's mounting going on, none of which is in here. There's talk about being on the ground. That's it. It is not competent evidence. If there's any probative value, it's outweighed by the prejudicial effect of what a jury might imagine was meant by those text messages that may have been sent by Trayvon Martin and may have been about a fight. Your Honor, I don't know if the court wants me to address the issue of the photograph. I think it's Exhibit 4 or the information purportedly about a firearm.
The firearm, Mr. West said he wanted to address at a later time, so you don't have to address that.
Your Honor, the photograph appears to be Trayvon Martin, but they said they offered it for, I can't remember the term he used, but the best photograph of Trayvon Martin for this jury to consider is the one of him on the medical examiner's table that was taken just shortly after his death. We don't know if when this photograph was taken. We don't know if it was something that he took right after he worked out and got all pumped up and maybe took a picture of himself for that reason. We just don't know. But the best photograph are the ones already in evidence that were taken at or about the time of his death. So for that reason, I see no probative value to the photograph, as we already have that in evidence. If I can just have a moment. And Judge, they relied on Chambers versus Mississippi. Again, I don't think the purpose of that is to eradicate the evidence code and to allow into evidence items that are subject to the type of speculation and misinterpretation that this proposed evidence is. So I would ask the court to continue to grant the state's motion and deny this evidence. Thank you.
Thank you. Any further argument?
Only brief response as to the authentication issue specifically.
Well, first of all, as to the content of the text messages, they are what they are. I'm not suggesting that we should be allowed to explain them when they're offered to the jury. The jury will see them and give them whatever weight they choose to give them based upon what they believe them to mean. As to the authentication issue, this issue is mired in the mess that discovery on this issue has become. There is a pending motion for sanctions before this court that will be taken up at the end of the trial because Mr. Della Rianda stood before this court and said, we gave the defense everything. We offered the testimony of Wesley White, we offered the testimony of Ben Credos, that in fact wasn't true. And we finally got the report from Mr. Brenton at FDLE on June 4th. June 4th, and we still haven't had a chance to go through it because we had the Fry hearing, we've had 2 weeks of jury selection, and what is this, our 3rd week of trial? I can't even keep track of time. There is an ongoing discovery issue, violations. In fact, Mr. Guy stood there silently when Bernie Della Rianda said, we gave him everything, there's no other report. We didn't get any information from anybody different than what we gave them. And we know that's just not true. Mr. O'Mara said to this court, let's relax some of the authentication issues, if nothing else, because we can't get through this issue with the timetable the court has set. There is no authentication issue. In fact, the authentication issue that Mr. Guy raises is illusory. And to the extent this court thinks there is one, it's because of the state's misconduct, not because of anything that we've done.
Even if you were to take everything out of that bin file, it would still be the same issue. It's coming from the same phone.
We did not have the ability.
Well,
we were misled, Judge. We were given a.
Go ahead.
We were given a report at the same time we were given the bin file in late February. The report was misleading. It did not contain the same information that the state had in its possession at that time. We got the report, which was incomplete.
Mr. Conner testified that he found 600 additional photos that the state didn't know about. So
that's not true. That's just not true.
I thought I heard him say that. I'm
Well,
sorry.
that's what he said, but that's not true that the state didn't know about them. We had testimony before this court from Ben Kritos that he
We're
printed
getting off
2
on a
reports.
really side issue, because my point being is, if you had 5 years to look at that bin file, it's still coming from this same phone.
We
correct?
only wanted an
it's
extra week.
It's still coming from this same phone, correct? Yes.
The data
So
set is the data set, yes.
Okay, it's still coming from this phone. The information that you're seeking now to introduce through Mr. Connor, I do have an authentication issue about it. 90.901 is the requirement for authentication or identification. 90.901A, 901.1A, and I'm reading from Earhart. The most common method to authenticate the electronic record or message is by the testimony of a person with knowledge who created the record or message of that printout accurately reflects the contents that the witness created or sent. And it goes on and it brings you to footnote number 3, and it references Griffin versus State, 419 Maryland, 343 19A 3rd 415 2011, and State versus Ellick, ELECK, 130 Connecticut Appeals, 632 23A 3rd 818, 2011 case. An electronic document, example, email, text messaging, and networking sites like Facebook, may continue to be authenticated by traditional means such as the direct testimony of the purported author or circumstantial evidence of distinctive characteristics in the document that identify the author. Typically, electronic messages do have self-identifying features. For example, email messages are marked with the sender's email address, text messages are marked with the sender's cell phone number, and Facebook messages are marked with a username and profile picture. Nonetheless, given that such messages could be generated by a third party under the guise of the named sender, opinions from other jurisdictions have not equated evidence of these account usernames or numbers with self-authentication. They cite another case of Commonwealth versus Purdy, 459 Massachusetts, 442, 945 Northeast 2nd at 372, 2011 case. Evidence that electronic communication originates from email or social networking website that bears purported author's name is not sufficient alone to authenticate it. Another case, they cite emails authenticated not only by defendant's email address, but also by inclusion of factual details known to the defendant that were corroborated by telephone conversations. And my point being is that what has been presented to the court, Exhibit 2, Exhibit 4 is the profile picture. Exhibit 2 and Exhibit 3 has nothing identifying Mr. Martin. He doesn't say, hey, this is Trayvon, or it has going out to Lavandria, coming back in from Lavandria. It has the phone numbers, it has the time, but anybody could have picked up that phone and sent these text messages. A third party could have access to it. People have children who pick up their phones and play with them and send text messages to their friends or other people. I don't have any identifying marks that these text messages are created by or sent by Mr. Martin. I have a concern about that.
Well, we know the phone had a double level of security. We know that.
And I know any 7-year-old can learn the passwords and get into that because they do it all the time.
FDLE couldn't do it for a year almost.
Well,
they sent this phone all over the country, and they had to write code for it.
But a person may know that password. Another person may know that password. FDLE didn't know the password.
Right, it's evident under 90.901 that there's evidence sufficient to support a finding that it is what we claim it to be. All of this came off of Trayvon Martin's phone. There are thousands of pictures, thousands of text messages, no indication that anybody else was using his phone. Mr. Connor looked at all of those text messages. Further, under the authority of is it Manuel?
Yeah, it's on the same page.
Manuel v. State, is that the one you're talking about? 357 Southwest 3rd, that one?
Yes.
Cited in Earhart's book, I guess, Mr. O'Mara pointed this out to me, to suggest, I don't know what else we could do under these circumstances when the state didn't give us the information timely.
But even if the state gave you that information, is my point, what on these text messages identify that they were created by Mr. Martin?
We would have had the time and the opportunity to find the witnesses on the other end, first of all. And we have not had that because of the state withholding valuable, exculpatory, probative evidence in this case repeatedly, and then misrepresenting to the court what they did. And then finally, when we caught them doing it, we get it on June 4th. Judge, I don't know what else we could have done, frankly. We asked for time. We wanted to depose Steve Brenton. We asked the court to delay the case a few days. I don't know what else we could have conceivably have done under the circumstances to further this authentication issue under the circumstances that the state is solely responsible for. It's simply unfair for Mr. Zimmerman not to be able to put on his defense because of the state's tactics. It was a strategy, obviously, because they had it in January and kept it from us, made us spend 10, 20, 30, 100 hours digging it out, playing games with us, lying to this court, and now it's our fault. It's our fault. To deny Mr. Zimmerman the right to present this information violates both the Florida and the United States Constitution. Thank you.
Does the state want to respond?
Judge, not in substance, but because Mr. West said, I would offer him the opportunity right now to apologize to me for suggesting that I stood by silently with information that I did not have.
I'm not getting into this. Court is in recess. I will give my ruling in the morning. I'll see you at 8 o'clock in the morning. Court is in recess. It is
it's 10 o'clock
9:56. No, court is in recess. Thank you very much. With all due respect, we'll see you at 8 in the morning. Well, at 8 in the morning, the issue is Mr. Donnelly, who may have violated, or counsel has informed the court that you know that he violated the rule of sequestration. That's the second time today that I've heard that there's been a violation of the rule of sequestration by the witnesses. I don't want to take that up at 9 o'clock and have the jury sit out there and wait like they did today. We will be in recess until 8 in the morning. And so have I.
Not being able to prepare or get my witnesses gathered for tomorrow, and I can't do it tonight.
I'll see you at 8 in the
I'm
morning.
not physically able to keep up this pace much longer. It's 10 o'clock at night. We started this morning. We've had full days every day. Weekends, depositions at night.